now, Minister?
Yeah, it's better.
Yeah. So
you don't have to switch it off, ne?
Okay,
It can,
I'll
you
do
can
so.
keep it throughout even when questions are asked to you.
I'll do so, Minister. I've got a BUris degree and an LLB degree from the University of Zululand. When I was appointed to head the Free State as the Director of Public Prosecutions, I decided to further my studies, and I registered with the Business School of the University of the Free State, and I obtained my NDPP, which is a Management Development Program. It also deals with labor issues, issues of leadership. It also touches on the issues of audit. So that's what I did. I also obtained an LLM from the same University of Free State. Besides, the LLM was focusing on the multiple agencies in South Africa that are focusing on fighting corruption, to see what are the benefits and what are the challenges there. But it was an LLM where I had to do a research, but also do a lot of coursework. I also have a certificate from Duke University. This is a certificate that I got whilst I was serving as an acting director of public prosecutions in South Gauteng. I was appointed by the then National Director of Public Prosecutions to represent the NPA in the Department of Transport board. So the Department of Transport, it was Road Infringement Agency. It's one of the agencies under Department of Transport. So I served there as a board member, and that's when I got an opportunity to really go and study more about the role of board members, and I obtained that certificate from Duke University. Those are my qualifications. How are they relevant? If you look at the prosecutors really currently, we've got prosecutors, we've got master's degrees. We've got prosecutors who are very much knowledgeable. And it doesn't look good if you are a leader, but you are lazy to study. The course really that was focusing on leadership and focusing on being a board member, it's also very critical, even though in the department, in the NPA, we've got Department of Justice that is responsible for really the functions of the CEO or accounting authority. It's still very critical as a DPP. It's very critical as a National Director of Public Prosecutions that you be able to interrogate the issues of performance, that you be able to interrogate the issues of the credibility of the information that the prosecutors are giving you when they say they finalize this number of cases. That issue of being able to play oversight on the issue of assets, being able to play oversight on the issue of finances and detect and prevent unauthorized expenditure, irregular expenditure, as well as wasteful expenditure is very, very critical. If you've got an organization that says it has performed very well, but there's an audit finding that says there's an issue with the reliability of that information, then you can't be proud of that information that you have given to the country by way of your annual report. So these issues are also very critical. The issue also of leadership, MDP was covering those issues. What does it mean to be a leader? Are very critical, because being a leader doesn't mean you need to be in an island. Being a leader, that doesn't mean really you need to be managing work on a daily basis. It means you need to have a vision, you need to have a direction, you need to be able to communicate to your team your vision and allow the team to go with you in implementing that vision. And so the issue of being a visionary leader is very, very critical. And the issue of how you also interact with your staff open, developing those open channels of communication and being available, it's very critical.
We will come to that part
Yeah.
around management and leadership. Let's first move to your positions you've held. So according to the records you have provided for us, you've been a district court prosecutor from 95 to 2000. And then you've been, is this at Pietermaritzburg?
It was at Madadeni,
It's at Madadeni.
in Newcastle. Let me apologize, Minister. I'm not young, so my experience is quite long, so I didn't want to give you 30 pages. So when I say district court prosecutor here, then I moved to senior state advocate. I was a district court prosecutor. I was also a regional court prosecutor. So I've gone through those ranks in the district court.
In the same
in the district court, I was even a control prosecutor before I was promoted to a regional court prosecutor.
Same district court?
Same district in Newcastle.
In Newcastle,
Yeah,
okay.
the regional court is in Newcastle and the district court is at Madadeni.
Okay. And then you moved to becoming a state advocate?
I moved to become a state advocate in Pietermaritzburg. Yeah.
And then is that separate to what you have listed here? Is it state advocate in asset recovery?
I was appointed as a state advocate in the High Court, in the general prosecutions in the office of the DPP.
Okay.
And then I was also promoted from a state advocate to a senior state advocate in the office of asset recovery. So I did asset recovery whilst in the NPA. So you've got it, state advocate and also state advocate in asset recovery unit. At that time, I had to move from Pietermaritzburg to Johannesburg. I remember when I was moved, Willie of Mayor wanted to open an asset recovery office in Pietermaritzburg, and I was told to go and learn in Pretoria and then come and implement. But when I came and learned, Judge Radin Kitley said, I don't want you to go back. So
no,
I ended up staying.
Yeah. Let's stick to what I want from you.
Yeah.
Confirmations. April 1995 to 2000. You were a district court prosecutor.
Yeah.
And control prosecutor and regional court prosecutor. So you were at Madadeni and then you moved to Newcastle. April 2000 to 2005, senior state advocate.
Yes.
Now I've moved to your CV because your form doesn't give me proper dates.
Apologies for that.
Yeah, DPP's office and asset forfeiture in Johannesburg.
In Johannesburg.
At what point were you in Pietermaritzburg? State advocate Pietermaritzburg, because your form says that.
Yeah, I was appointed in Pietermaritzburg in 2000. I was appointed in 2000. Then in 2002, that's when I went to the asset recovery office.
In your CV, it says May 2005 to 2007.
I'll have to look at both, otherwise I'll confuse the minister and I'll confuse myself.
Yeah.
I don't have a copy, unfortunately, Minister.
You don't have a copy of your CV?
Apologies for that.
Okay, the team will make that copy for you. Because as I do, I cross-check your CV with the form.
Okay.
But the record of your experience is important to understand where you've been, at what point, because your work is linked to decisions that are made at a particular time where you've been.
If I can be finished with the copy, Minister, I can be able to assist you better.
Okay, the team will come back to that. I think we'll pack it because I do have quite some few things that I want us to correct if they need to be corrected there. The accuracy of information is important. Were you given the CV to look at it and correct it? Because I'd asked the team to send all of you the CVs before we published so that you can correct and make sure the accuracy of your CV.
I tried to really refrain from giving you a new CV. So what I did, and the instruction was, the CV is going to be made public, so I need to go through it and ensure that there is no information that is confidential that goes to the media. So what I did with my CV, I just removed the email addresses and the contact details of the persons that I've listed as references.
At that point, you didn't see these inconsistencies?
No,
Because other candidates did email and requested to change.
Minister, I thought the focus was remove issues that might infringe the privacy, your privacy, and the privacy of the persons that you have mentioned here. So okay. I didn't really go back to my experience.
At the point of submitting the application, you were nominated, you were asked to provide a CV. Did you verify it?
I was nominated and I was asked to provide a CV, and I provided the CV. When I was approached again and nominated by other people, then I tried, if you can look at the CV, I tried to make it more polished and more brief in the format that you have in front of you.
Which format?
The one that you have just given me, this one.
There's two that I have, but both of them seem to have
similar information. Problems. Yeah, it was just the format, not the content.
It was just formatting. Okay, I'll come back to this.
Yes.
Because it is quite significant. That's why we ask for CVs.
I fully understand. I fully understand.
Okay. While they give you a copy, I need you to help me correct and records, so that we have a correct record of your work history. So the team will do that. Let's move to the next one. We'll come back to this part. I'll park it for now. You a member of the Society of State Advocates of South Africa? Are you still?
I used to be the member when I was still in the prosecution. I don't remember saying I'm no longer your member, but I assumed that they are no longer deducting anything from my salary when I left the NPA.
What do you mean you assume? Because in membership, you would be a member, you know the condition of membership, that I'm a member. I belong to an NGO. So I know that every year, if either I renew my membership annually or I do it 5 years, and I know the conditions that if I don't renew my membership will lapse. I'll cease after 6 months without renewal. I know. So what is the condition? Why would you not know at what point your membership will lapse or will not lapse, or whether you are a member or not?
I now remember, Minister, I now remember that when I was the DPP, I used to be invited by them to come and speak as a guest speaker. Even when I was in the FIC, they invited me to come and speak as a guest speaker. But I remember whilst I was in the NPA, I was teaching them about the issues of their responsibilities and the issues of the membership of senior people who are representing the management or the employer in the society. I think at that time I had already withdrawn as a member. I was no longer a member. So I can confirm that I'm no longer a member, Minister. I'm only invited by them. I'm still very much visible. I've got a gift that they gave me last year because they invited me to come and speak as a guest speaker. So I do support them, but I'm no longer a member.
Yes.
Yeah, so
I remember even myself, I get invited to go and speak to them. But I'm not a lawyer.
I can confirm that, my Minister, that I'm no longer a member.
I'm not a lawyer, I'm not a member. But because of the position I hold, they'll invite me to come and speak. So what we were focusing on is your membership.
Yeah, no, I terminated my membership once I was still in the NPA.
Okay.
Yeah.
Are you a member of any organization?
Of any organization?
That's what the form is asking you.
No, I'm not a member of any organization.
Okay.
Yeah.
I see you confirmed your state of health. That is correct. No issues that will impede your holding of office as a NDPP. let's go to your area of work in terms of law. If you can take us through that.
Which section are you now on, Minister?
I'm on I'm on section 2, legal background. Where you stated, section 2, legal background, where you stated your area of work around criminal laws. Take us through all that.
Yeah. Minister, I've dealt mainly with criminal law as a prosecutor in the National Prosecuting Authority for a period of 23 years in all levels of courts, from the district court to the regional court to the high court. I also have experience of civil law because I've practiced as a practitioner in the Office of the Asset Recovery Unit. And our proceedings there are civil proceedings because we draft founding papers, we draft supporting affidavits, and we go and move applications ex parte. So I do have that background as a senior state advocate in asset recovery, also as a deputy director of public prosecutions. That was really responsible for checking those papers and ensuring that they are court ready. I also have experience on issues of corruption, mainly as a prosecutor, but also during my term in the FIC. When I was in the FIC, I played a very critical role when the country drafted the National Anti-Corruption Strategy. I was appointed to represent the members of the anti-corruption task team in that team. We are calling it a reference group that was assigned to review the National Anti-Corruption Strategy and ensure that it is of quality and it meets it's in line with the global standards and it's in line with the risk that the country is facing. So I chaired that reference group together with Mr. David Lewis from Corruption Watch. But I was in the FIC, I stayed up until the president appointed the National Anti-Corruption Advisory Council to take over from the reference group. So I do understand the obligations really that are imposed on us when it comes to the National Anti-Corruption Strategy. I also represented the country in the G20, Anti-Corruption Working Group, and I took a project which I thought was very critical, the project of prioritizing asset recovery. And we were looking at it from an angle of enhancing asset recovery through public-private partnerships. Through public-private partnership. Why?
When did you participate on the G20 now as South Africa was chair, led by SIU? Or is it prior to that?
It was prior to that. I was still in government. I was still there in the FIC at that time.
Which year were you participating there?
I was appointed 2018 in the FIC.
Or for your duration at stay?
At that time, it was India. That was the presidency of the G20.
During presidency of India.
During the presidency of India. So I represented the country there. Then on the issues of transnational organized crime, that's one area that I'm focusing on now in my business. And it started, I gained really that interest when I was still in the FIC, in the National Prosecuting Authority. I was responsible for the Africa Prosecutors Association. So I was a member in representing the office of the NDPP in the Africa Prosecutors Association, together with Advocate Machugweni, and also at a later stage, Advocate Machugweni was replaced by Advocate Mzingat. So at that stage, we were trying to encourage countries to have laws that are focusing on combating money laundering. And South Africa was a bit advanced there. And so while we were advanced, we were also a member of the Financial Action Task Force, and currently was still the only member in Africa or that is sitting in the Financial Action Task Force. So it was critical for us to be able to raise awareness, especially in Africa, on how critical it is to be a member of this organization. So I'm training a lot of people on issues of organized crime, but mainly meeting the recommendations of the Financial Action Task Force. So I've got experience in that area. I must say, Minister, even now in my business, through the EU Global Facility, I've trained more than 24 countries in Africa on the issues of FATF standards, focusing on IO6, immediate outcomes 6, 7, and 8, that relates to law enforcement agencies. Then in the FIC, I've got an experience also in the FIC in running the Financial Intelligence Unit. And globally, we also have Financial Intelligence Units. It's one of the recommendations of UNCAC, that countries establish a financial intelligence unit that can assist in the identification of proceeds of crime. So I've served in the FIC for a period of 5 years, 8 months, but during my tenure there, I was able really to receive the confidence of the global heads of FIUs. They appointed me as a vice chair. I served as a vice chair for a period of more than a year, and after that, they also appointed me to chair the Egmont Group. So it was really the global organization saying, we've got confidence in your leadership. Yeah, so I've got experience of in the financial intelligence.
And where you say I chair, you mean yourself personally?
Myself, I was chairing.
We're sitting there representing the country?
No, they don't appoint a person there to come and represent the country. We don't have any rotation. They look at you as an individual and say, we want you to be able to lead us.
Is that including the work that you did in UN Convention Against Crime, and also on the United Nations Convention Against Transnational Organized Crime?
In Egmont, we deal mostly with issues of transnational organized crime, issues of money laundering, but we also deal with issues of any forms of proceeds-generating crimes. Same as the FIC is focusing.
What I'm trying to understand is, remember here we are looking at your knowledge, your participation, and your areas of law.
Yeah, I fully understand.
That's why I would ask that question. So I know with us as South Africans and Africans, we normally use the plural word we as well. So I don't want you to make that mistake where you're saying we and I. So I need you to be clear so that the panel can see the expertise that you're talking about.
That was me in my. Let me explain this, Minister, because the Egmont Group, it's a group of financial intelligence unit. They appoint a person who is in the financial intelligence unit, but they don't appoint a country. We don't rotate, we don't take turns. So they were looking at me as a person. Yeah.
Compared to the G20 as well, because it's a country.
In the G20, the G20, I was approached by the office of DPSA, and they said, we think you can be able to do this as a person. So, and they approached me, and I accepted, and I got a letter from the Minister of DPSA appointing me to represent the country in the G20. Yeah.
Okay. No, I just wanted, because not all members would be familiar with how we've got members in the panel who are not in government. So they must have a distinction between, because in G20 you'll represent, but these others you are appointed directly to say. This is what, but your knowledge of being involved is not retracted.
Yes. Then in the Financial Advisory Intermediary Service Act, when I left the FIC, the Minister of Finance, I think a year later, appointed me to serve in the tribunal, in the Financial Services Tribunal. So I sit with other advocates and sometimes with judges in that panel, and we deal with those issues. It's mostly...
You're still a member now?
I'm still a member now of the tribunal appointed by the minister, We deal with issues when persons have been debarred, and they come and apply for the reconsideration of that debarment, and we'll go through the papers, even have a hearing and draft judgments. I think I've been involved in 6 matters because we're quite a big pool of advocates sitting there. I've sat in 6 matters and I've drafted 2 judgments.
Okay, no, that's good. Let's move on to your next area. I think we've dealt with your area of law prosecution. Have they been able to give you your copy, or maybe let's finish the management area? We'll come back to your experience because it links to prosecution. Your experience as management, you are indicating here you've been in management level, both in terms of the Deputy Director Public Prosecution for 5 years, acting DPP South Gauteng, and DPP Free State for 8 years, head of FIC for 5 years. Tell me, how many
Minister,
people did you
where are you
manage?
now? I apologize. Where are you now, Minister?
Section 4, managerial experience. Section 4 of your question.
Okay, on page 5, yeah.
Yeah.
Thank you, Minister.
Page 5.
Yeah.
How many people, more or less, have you been managing at FIC that were reporting directly to you, like as a head? How many people?
The EXCO, I think it's about 8.
EXCO is 8.
Yeah.
So you were the head.
I was the head, I was the
So
director. In terms of the act, the director is the CEO of the FIC. Yeah.
Overall staff complement of FIC?
It's not a big complement. It's about 300 people in the FIC.
300
yeah.
people.
Yeah.
And then in the Free State, how many people were managing as head, as the DPP?
As the DPP in the Free State, in South Gauteng, people were quite many. In the Free State, I think, I don't recall, Minister, but they were in the thousands, but not too many. Not as many as in South Gauteng. South Gauteng, when I acted as a DPP there for a year, it was quite a
South
big
Gauteng
team.
is big. It's one
Yeah,
of our
South
biggest
Gauteng is
offices.
big. Yeah.
But we can say you've literally managed more than 300 people.
Yeah, yeah.
course.
South Gauteng, yeah. South Gauteng was quite big then, yeah, Johannesburg.
Okay. And then your management style. How would you describe your management style?
Minister, I'm that person who wants to say...
I'm asking you this
Yeah.
because you didn't answer it in the form. The form asked you to answer the number of years, the number of people you've supervised, and describe your management style.
Yeah. My management style, Minister, I'm a manager who's quite involved and close to the issues. And you can't be close to the issues when you are not close to the people. So the open channels of communications is what I always advocate. I'm a person who is also visible. In the Free State, in Johannesburg, I would drive and go and visit the courts. But I'm also a person who is hands-on. I can just give you an example. In South Gauteng, I had an opportunity to deal with appeals, to lead the appeals section. And there was a time when there's a matter that's supposed to be sitting in court, there is no record. I just decided one day, I took advocates and said, let's go to that court and check what's happening. Being formal and wearing a suit, and we went to the strong room that keeps those files, and we cleaned it up for a period of a week until we knew which file is sitting where. But the lesson that we came up with was that we had a number of appeals wherein the persons had been found guilty, sentenced. Then they come and apply for leave pending the appeal. And they won't do anything to prosecute their appeal. If there are challenges with the record, they won't do anything to ensure that their record is properly transcribed and ready to go to court. And we had to have a list of all those cases, write letters to their attorneys, because we picked up that gap. And had I not gone there with my team, I wasn't going to know. We were able to write letters to the attorneys of those persons and say, if you are not going to prosecute your appeal by this time, we are going to issue you with a notice of surrender. And we did exactly that. We issued notices of surrenders, and people were able to go and save. Those that were serious, we were able to assist them. If they were saying, I'm still having challenges, I haven't in having the record transcribed, we'll assist them. But we also had a few cases where we couldn't do anything with the transcription of, or correcting of the record, where magistrate had died or had left the country. So I'm a person who's very much hands-on. I'm a person who believes that if I push you and say this needs to be done, I must also show that I can do it myself. Yeah, so I'm that kind of a leader, but I'm a kind of a leader who tries to be part of the team rather than thinking I must be in the island, because if you do that, you end up not knowing the challenges that you are that your organization is facing.
Yeah, I see you explain it as a leader who maintains consistent, under leadership section, consistent presence and actively engage with the team. I think that's what you just described now. Okay, let's move to the section 5, page 6, ethics and integrity. You are saying to us as a panel, you've never been subjected to any DC, nor suspended from any position. Can
That's
I confirm
correct,
that?
that's correct.
Okay. And there's not been any reporting in any legal body or any professional?
Not at all, Minister.
And you've never been reported even when you were in NPA?
Not at all,
Nothing.
Minister.
Okay. And the next part of that section talks about your contribution in law and pursuit of justice. Can you take us through, take the panel through?
Where are you now, Minister?
Page 7, number 3. What would you regard as your most significant contribution to the law and the pursuit of justice in South Africa?
Okay. Yeah, Minister, let me start with the FIC unless you want me to start. I can start in the prosecution
it's
before I go
choice.
to the FIC.
We want, this process is also to introduce you to the public.
Yeah.
Let them know who you are,
Yeah.
what you stand for.
My
That's
contribution,
what it's about.
Minister, I'll start with the South Gauteng. When I was in South Gauteng and acting as a director of public prosecutions, one senior public prosecutor came to me and told me about this project that they were running in Boksburg. It was a project focusing on diversions. Those persons who really end up facing prosecution because of their drug addiction. So there was a good project that was trying to really involve the churches and ensure that those persons are supported. And they go through a program being run by the church, they have their urine tested, because they are not really criminals, but they are getting involved in criminality due to drug addiction. So I took that project. After I learned of it, I went and visited the court, I visited the church, and I was satisfied that it was really running smoothly and it was in line with our vision as the NPA. And I wrote it over to I spoke to the senior prosecutors and to directors of public prosecutions. They were excited, and we wrote it over to Soweto and other areas in Johannesburg. That project, when I went to the Free State, in the Free State, I know it's still running. The CRC church is still involved in it. And it's really assisting. You just need to have a mentor, a person, whether it's a family member or a friend, who will support you and go with you when you take your urine test, be involved in the church, and we see that you are a changed person. After a period of 6 months, we're able to say we can withdraw charges against you. If you are not serious,
doesn't believe in church, is not a Christian, what happens?
If you don't believe in church, but you are involved in some church activities, you can even
I'm saying if a person does not believe, is an atheist.
Hey, we never had that challenge, Minister.
Did you ever ask?
I never asked, Minister.
Remember, we are a secular country.
I know. Yeah, we never asked those questions, and we never had a person that was saying, I don't want to be part of this program. It's something, Minister, that you can look into. It's in Boksburg, it's running. It's still running even now. I remember when I was still in the FIC, I've discussed it also with the current national director. In the Free State, it is still running. So I don't think there's anything that is perfect, 100% perfect, Minister, but it has a lot of benefits, and it's something that we can enhance.
I'm not denying the benefits.
Yeah.
Remember, I'm also one of the issues that I'm responsible for. Hence, the portfolio is called Justice and Constitutional Development.
Yeah.
So I've got to promote constitutional values, and one of the issues is that the right to choose religion and religious practices is enshrined in the Constitution. So if a person is saying, that's why I had to check whether, and it's correct for you to say that no one has said.
No one really raised that issue.
You've never checked whether the people do not, and they've never objected.
But what we need to promote, Minister, when it comes to fighting crime, with the level of crime that we have in the country, we need to find other ways of resolving crime that works, other than saying we'll have backlogs at courts and we'll have cases running for 10 months. The issue of alternative dispute resolution, and also involving the entire community, the churches, the private sector in this fight. It's not the fight that we can win alone as law enforcement agencies.
Go into detail, I'm interested.
What?
I'm interested in that concept, finding alternative
ways of finalizing
fighting crime.
Yeah. One example is just that the systems are really different. In the US, 90% or more than 90% of the cases, they finalize them through your plea bargaining.
Through your?
Plea bargaining.
Okay.
Yeah, then you get a benefit. But we do the same thing in our country, but we don't have, we are not recording the highest number of plea bargainings, because our prosecutors, they tend to say, let's bargain, but still want the same sentence that they will give to a person who is not really
even
cooperating or supporting them.
I know there's work that is being done on civil, but does this apply on criminal matters?
It does apply on criminal matters. It does.
And on sexual offences?
No, you can't. You don't. No, you can't.
But on murder?
No, even on murder, Minister, you can't. I think there is a guide.
That's what I'm saying. Explain.
Yeah.
Because you're sitting with victims, they are listening to you.
Yeah. Let me tell you, Minister.
Victims of crime.
Yeah. Let me explain, Minister. I'm happy that you have asked me to explain. In the lower courts, if you look at the cases that are sitting in the lower courts, and you look at the roll, you will find that the prosecutors have placed 4 matters for trial. But on the day of trial, it's only 2 matters that are now proceeding. The victims are no longer interested. They are saying we are withdrawing or whatever. Or prosecutors end up doing mediation, or they end up doing diversion.
What type of criminal offenses will be those ones?
Those are the
advocate.
Yeah, it's
just because remember, not only are you sitting here as a candidate, but people are thinking this is going to be potentially our NDPP. And if you're not clear, you can send shivers down people's spines with the level of crime we have in this country, where victims are saying to us, we see our cases vanish in courts, allegation of prosecutors colluding with perpetrators of crime. That's why I want you to, when you make a statement in that context of high organized crime, gangsterism in this country that takes the lives of young boys, that you be articulative of what you mean by the sentences that you are making.
The cases, Minister, that I'm referring to are cases that are in the lower courts, in your district courts. Those will be your trespassing cases. This person was drunk and trespassed in this place. Those will be your cases of theft. This child stole from a cliques or stole from checkers.
Petty crimes.
The petty crimes. Your crimes of assault. The boys were playing soccer and they ended up really assaulting each other. It will be those petty crimes. So when it comes to petty crimes, we need to be able to find ways of resolving them. And in the country, we have a good diversion program wherein we are able to even involve social workers. But the challenge is we don't have a diversion program that's focusing on adults. So if we can have a diversion program that says if adults are involved in petty crimes, we will finalize those cases by way of a diversion. And there will be processes, there will be directives that explains what kind of cases can you not really divert, your repeated offenders, because you also don't want to send a message that you can steal every day and nothing will happen to you, you will be diverted. So there will always be exceptions to the rule, guided by what we see on a daily basis in court. But there are a lot of cases that are clogging the systems that we can finalize by way of adult diversion, if we can have that in our country, that we can also finalize and encourage prosecutors. I think we tend to challenge prosecutors a lot when they've reached a plea agreement, when it's something that is in the act that we can bargain. But you cannot say you are bargaining, but I still want to win. I still want to give you a same sentence. So those are the issues that we need to manage and ensure that prosecutors are able to finalize cases. And bargaining, Minister, doesn't mean now that there's a plea bargain. I'm now going to be scot-free. I'm not going to face a sentence of imprisonment. You are still going to face a sentence of imprisonment. If a minimum sentence is 3 years, you'll plea bargain and saying, I'm going to give you 1 year, 3 months because you have not wasted my time, instead of really having a lot of people in prison and kids who have no future, because when they go for interviews, they are told that you have this record when you were still young, when you were 18 or 19 or 20. So it's something that we need to look at. But what are the benefits? The benefits, Minister, is that if we open up space in the lower courts, we'll then allow the lower courts to be able to deal with your assault GBH, assault with an intention to cause serious bodily harm. If you look currently, even at the stats of the NPA, some of those cases are sitting in the regional courts. So if you open up a space in the district courts, you'll have your district courts dealing with assault GBH. And what then happens when you have your district courts dealing with cases, trying cases, instead of focusing on diversions? I also propose that have courts that are only focusing on diversions. In the Free State, we had one that was run by a chief magistrate in Velcom. It used to be called a love court, just a court focusing on diversions, and you are not expecting them to do any trials. In the regional court, once the regional court is not dealing with assault GBH cases, then you have your regional court prosecutors dealing with your corruption, dealing with your fraud cases. So that's what I think we need to be doing. So by saying, let's do ADRM, alternative dispute resolution, and let's embrace the plea bargainings, I'm not saying let's really send everyone home and let no one face any consequences.
The other argument on that, and perhaps we'll come to it, I wanted to finish this, is that while we acknowledge that some of this diversion will work, but when you look at the statistics of repeat offenders, some of them start with petty crime and then become, and they would have been on diversion as young boys through social workers, as we do. But others, yes, can argue that if you take them to prison at an early age, you literally almost orientating them to crime. So it's both ways. How would you deal with that?
You balance the two.
As an NDPP, you're confronted with that situation. Yes, Minister of Correctional Services comes and say, please find ADRs and other mechanisms because our prisons are full. But there is a record from police who would say, but these people are repeat offenders.
Yeah.
And therefore you are making our life difficult as police because we have to chase these people. You release them, they come and commit, or they start with a small crime because they've not been punished enough. They go and commit a bigger crime, they kill.
Yeah. Minister, as I'm saying, you will never really find an absolute answer or an answer that resolves all your problems. You just need to keep on trying. But I've already explained that even you'll be able to come with directives because the NDPP is responsible for policy and directives. You'll be able to come with directives that's able to say for repeated offenders, we don't do mediation. I can't say repeated offenders. There'll be exceptions, and you'll also expect prosecutors to use their discretion, really looking at the facts of the case in front of them. But it's something that's happening globally. And with FATF, when they assessed us, Minister, they said 50% of the crimes in South Africa that we are dealing with are proceeds-generated crimes. Whether you commit theft or housebreaking or fraud, you do that. Even in murder cases, in some instances, we've seen people committing murder with an intention of really being paid or quickly benefiting from that will. So it's very critical when we've got 50% of proceeds-generating crimes to be saying, as a country, what is our biggest risk? And we adopt a risk-based approach. And we say, when it comes to corruption, we want to look good. We want more time in our courts dealing with corruption cases. When it comes to rape, we want to be focusing on those cases. Organized crime, sexual offenses, instead of saying, everything will get a time, everything will run through court. You'll have a small case really running for 3 or 6 months, and it's a case that you can resolve by saying to the people, let's sit down, let's get a social worker, let's really fix your problem, your anger issues, if it's a man that is angry or it's a boy that is angry. But we need really to find other ways of addressing the backlog. If you read, I remember when I was a director of public prosecutions, and I was sitting, acting director, and I was sitting with my management. And in the discussion, it was the issue of a blame game, prosecutors blaming attorneys blaming the courts, blaming the police. And the one chief prosecutor from Joburg, Mr. Arno van Wyk, said, you know what, when I was cleaning my office for the purposes of my retirement, I found minutes of a meeting that took place 30 years ago, and the problems that were mentioned there are the same problems that we're mentioning now. So we cannot really address the current issues with the same strategy that we have been using 50, 40 years ago. And we need to be brave, Minister, to take those decisions.
Is this, maybe just you remind me of the case that was handled in the Free State University students, that under your leadership, NPA withdrew the charges and opted for mediation. Do you remember that case?
The Free State University students?
Yes.
I remember that case. And I did do diversion. I agreed to diversion in that case. It was students.
But do you think that was a best model to do? With that diversion that you said?
Yeah, I was proud of the
This
decision.
was racial issues?
Yeah, it was.
And we brought the black pastor with the black students and the white pastor with the, am I having correct information of that
brought
case?
What, Minister?
On the mediation. Maybe take us through what you did so that you correct the records that I have. Okay. Maybe set the record straight on that one. Okay. What did you do on that mediation?
Okay, Minister.
Because I want to understand your approach to mediation.
It's an old case, so I'll tell you, and it hasn't been brought to my attention when I was given a list of matters to comment on as a result of the information or objections that came from the public.
No, it didn't come as an objection.
So it didn't come. But let me tell you what happened.
Your positioning on mediation triggered it in my mind. Because I remember it very well.
Let me tell you, Minister.
It was in 2016.
It was in 2016. And in that university, we used to receive a lot of cases that were racially motivated. And they are still happening. There was also one recent one where one student was peeing on, yes, on the food or lunchbox of another student. It's still happening. So in that, but I'm not talking about that particular case, but we used to get cases of that nature. A student being run over with a car by a white student, and there'll be a mess in the university. The university will close because the black students will say, what is the university doing about it? So in this case, it was a nice day where they were playing soccer, if I remember very well, if I've got a good recollection of those facts. They were playing soccer, it was a nice day, but then something happened in that soccer field and there was a fight. But it ended up being a fight of a white person hitting any black person in front of him, and black people also doing the same, hitting white people. So a number of people were arrested and they were brought to us. And Minister, even
when
the
you
quality...
say number of people, you mean in the students?
The number of students that were arrested. And Minister, it wasn't a decision of saying it's racially motivated, I'm not going to fix it. I engaged Legal Aid South Africa. In this case, I sat with Legal Aid South Africa. I went to the university with my deputies to understand what the university was doing to resolve these issues, because it was quite a number of issues that used to come to us. And the university was also doing the same thing. They were having disciplinary hearings and trying to speak to some of the students. The evidence there, Minister, it wasn't evidence that was reliable, because if you were white, you will say it was the black people. Black people will say it was the white people. And people that were injured, when you go through the docket, the injuries were on both sides. So instead of really taking that matter to court and knowing very well that it wasn't going to go anywhere because of the quality of evidence in that case, I was happy to mediate. I was happy to speak to those students and say I'm withdrawing. And I did speak to the university. I consulted the university in that case. And let me tell you, Minister, one of the things that I also initiated in South Africa
Before we
in
move, I
every
want
state.
to come back to that one.
Yeah.
Yeah. You go, and who was the complainant on the case? Because the complainant, somebody opened a case. Yeah. It was not both sides. It was one side.
It was one side
that opened a case.
Yeah.
And in that process, when NPA decided to do the mediation, brought in both sides. But even at the withdrawal of the case, the complainant remained aggrieved.
Yeah, but Minister, you take a decision based on the law, based on the facts. Do you have good facts in your case? And what is your law?
But if a complainant does not agree with mediation and say go to trial, why didn't you go to trial?
No, Minister.
Because they didn't agree to mediation.
I'm not aware of complainants that didn't agree to mediation. I don't remember that information, but I took a decision not based on what the complainants were saying. I took the decision based on what my facts were saying in the docket.
No, I'm saying you took the decision knowing that the complaint, but you were aware that the complaint remained aggrieved.
There were quite a number of complainants. Minister, you can have one complainant registering a case is in a form of allowing the police to register a case docket. But through that investigation, there were quite a number of complainants. There were quite a number of people who were victims. So it wasn't one complainant. But Minister, we are talking about something that is very old, and as I've said, it wasn't brought to my attention. So it's not easy for me to really give accurate answers and say complainants were 5 or whatever. But what I want to convey to you, Minister, one of the things that I did in that province, because of the racially motivated cases that were happening there, you'll get a case, young boys severely beaten up because they've stolen from a farmer or whatever. When the matter is ready for trial, those boys are saying we're no longer interested. When you look at their faces, they are not even recognizable. They are no longer interested because there's been settlement. The accused person has paid them or something, whether it's 1,000 rands, then the matter is sorted out. But my focus wasn't only cases against Africans. It was also cases against white persons. If there were cases against persons, I will ensure that there is justice. And I had a number of white people in my office. They wouldn't have really allowed me to only really divert cases involving Africans. But I had a number of cases involving young boys who will be assaulted and they'll come and withdraw because I'm scared we're staying at the farm. My mother is working there. I cannot really take this matter to court. So I had to appoint a dedicated advocate in the DPP's office to oversee these cases. I had to speak to chief magistrates and say to chief magistrates, appoint dedicated prosecutors who are going to focus on these cases and ensure that we've got justice, who are going to speak to the victims and explain their rights and ensure that we've got justice.
You advocate, you wanted to say something. I'll come back to it.
Yes, Minister. I just wanted to take this further and ask you about how you would deal with corruption matters in particular, where there is an offer to repay the money in lieu of the damage that has been done. I'm asking this against the backdrop of South Africans being tired of waiting and waiting for services, and then when somebody gets caught after so many years of them living off the money that was due to them, then they get offered that. But it also has an angle to it, because some of the people who commit corruption and leave the country running away or are based outside, like your international organizations that we know were implicated in some of the corruption cases in the country, and they get away scot-free. But in South Africa, then it gives it a racial slant where people just feel, I'll up and go and continue to enjoy my money, or I'll up and go and just pay something towards this. And then there are other people who do not have the means, who do not have the muscle for legal representation, who end up languishing in jail because they cannot bargain. So I suppose it's a comment, but also wanting your views, because that's what has happened in this country, and that is what has affected the trust towards the NPA, where people actually feel there's some people who are above the law, whereas it's not that. Part of the challenge is actually in the plea bargain system that we have. What's your comment on that?
Yeah. Thank you, Advocate. Let me touch on this issue. When it comes to criminal cases, I've already mentioned we've got your alternative dispute resolutions. We can be able to say we're diverting these cases. When it comes to criminal prosecutions, we've got your 204, where we say you have come with clean hands, you are prepared to cooperate and support the state, either by giving evidence of the modus operandi that is involved in this crime, implicating others, going to court and testifying against other accused that are involved. And if you do that with honesty and you are frank, we are going to ensure that you are protected and you are not prosecuted. And if we do that with persons, there's nothing wrong if we do that with companies who are also saying, especially companies who are self-reporting, companies who are saying, I haven't been found guilty, I'm not under investigation, but I'm coming with clean hands to say this is what I've been involved in, and I want to speak to the state, and I want to undergo the corporate alternative dispute resolution. But the process is what the people will complain about. If you look at international best practice, in this process, when you deal with corporate alternative dispute resolution, and there's a research that has been done by the South African Law Commission on this issue, advising the country. They say it should be companies that are operating cross-border. It should be companies that are self-reporting. But if you negotiate with that company still needs to really give information on what they've been doing, what measures they've put in place, governance measures that they've put in place to ensure that there is no repeat of what they've done. Cooperating means if the the staff members or servants in that company that have been involved in corruption, directors who have been involved in corruption, they must come clean and they need to be prosecuted. So coming clean means the advantage that the companies will get is that it won't be a company that is going to be an accused in the case, but it will be a director or directors that were involved or the staff in that company that were involved. Then over and above prosecuting those who were involved, you are able to say they have paid back to the state. So it will look very bad for us if we say you are not going, no one will face prosecution, then pay. But also the issue of oversight, having that process, having a body, it can even be a body of head of SIU, a body of a representative from the AG's office, forming a panel to say we are going to play oversight of that process. So that is not only a decision of the prosecution, but it is a decision that is endorsed by that body. But it's very critical that we be open to these mechanisms, because everyone, if you look at the way that we are fighting crime now, we're not only focusing on taking people to court and you sit with a case for 12 years because it's not moving and you are not taking a decision. And we're sitting with a number of those corruption cases that have been on the roll for 12 years or whatever. So if you can finalize a person by way of asset recovery and be able to recover assets, that's where you hit the criminals the most, because you are hitting them on their pockets. But it shouldn't be. You must be able to also see what is this company making on a yearly basis, because it shouldn't be a system where a company now is even budgeting for a fine. We'll be corrupt, we'll do anything, but we'll save this 5 billion so that if the prosecution wherever comes, we'll be able to pay a fine. So you must also look at what they are making so that you really hit them hard where it matters the most. But it can't be you just pay, but you don't face prosecution. Yeah.
Thanks. Good morning, Advocate. I wanted to check with you these measures that you so eloquently are talking about, particularly the ADR system as you explain it. How do we, in your imagination, build a buy-in? We're sitting with two poles of societal perspectives of our court system, whether our court system is actually assisting in the encouragement of the crime dens, or whether it is actually helping us resolve the crime situation in South Africa. And we're also sitting with a society in which the trust deficit is growing in our court system. It is not attractive, and I believe you would agree with me that the NPA's major role is to ensure that it improves its outward look and also improve the confidence levels of society in its work, and whilst upholding the rule of law. Now, when you don't have these things speaking to each other, society's then perception of the scenarios becomes something else. How do we have a buy-in of that part as part of the rebuilding, if you can call it that, of the image of the NPA and increasing confidence in it from society's perspective?
Yeah. I've already touched on the issue of oversight, that if we can have oversight of processes like the OC, ADRM, it will really assist. Issues of transparency, we need to be transparent to our people about these processes and raise education, continue educating people, and people need to know that we are not in an island. We learn from other countries. If there are other countries who are doing things better than us, we need to learn from them, especially if those things are working. But also the credibility of what we are doing. People will complain if it's me today, I'm involved in crime, and there's a plea bargain, and they see me tomorrow, I'm at home. But if it's a person that is just owning a tuck shop, a small tuck shop, a person who is not profiled, of a high-profile nature, if you've got systems and there's credibility in that process, you don't have one person really paying 5,000 and getting scot-free, and the other is not getting that same benefit. People will compare. You'll also hear in Parliament, they will say, with so-and-so, you did this, but with so-and-so, you didn't do it. So you need to ensure that there's credibility in your processes, there's integrity in your processes, and there is oversight. And there's also guidance. Guidance to prosecutors is also very critical. And oversight is also there with the minister. When the NDPP really issues directives, there needs to be concurrence with the minister. So, but education is critical. I've seen it with sexual offenses. Sexual offenses, we are seeing a number of victims now reporting, because soccer has been really focusing on issues of education, educating people about their rights and encouraging people to come forward and report.
Prof, Mike, and then we'll come to you. I see other hands. Yeah, we'll come to you. Let's start with Prof. First.
Thank you very much, Advocate Kanyele. First, to clear this one, of the roles and positions that you mentioned, representing the country or participating in international organizations, which ones were you there because of the position you occupied, and the ones where you were invited because of the weight you add there, even when you are not in a position? Because sometimes you are sent to some of these because the country is a state party, therefore needs a representative.
Yeah. I think I've clarified, Professor, on the Egmont Group, that I wasn't sent in the Egmont Group. I was appointed as a person. They were looking at me as a person. In the G20, I can't say the FIC is really playing a leading role on issues of corruption. You've got the NPA, you've got the police and whatever. They came to me because of their role that I had played. Also the public-private partnership, the SAMLIT, if you have heard of the SAMLIT, the South African Anti-Money Laundering Integrated Task Force, where you find the FIC, NPA, the banks. It's more than 20 banks that are there, and we are about sharing and exchanging information and ensuring that what the FIC is giving to law enforcement agencies, it's better, it's consolidated, it's actionable. So I think it was both being in the FIC, because I wouldn't have really went there if I was outside of government. It was both being the FIC, but it was also both the initiatives that I've come up with in ensuring that there is coordination in the public sector in fighting crime. I also championed the establishment of the Fusion Center, which is a public-public collaboration still existing and sitting in the FIC. When we started, it was during COVID, and I was able really to say, what are we doing? And the president was also asking, what are we doing? And I said, there's a Fusion Center that we were really thinking of, or we're not even thinking of, because we had already broken walls in the FIC to allow a space for the Fusion Center. And I said, there's a Fusion Center, let's use this, let's enhance the regulatory reports that the banks are sending to us in order to be able to fight corruption better. Then in the Africa chapter of the Global Coalition, I was appointed as a person. I had already left government, and they appointed me to chair the Africa chapter of the Global Coalition. I'm the chair now, I'm the global chair of the Global Coalition to fight financial crime, and I'm not in government. I've been appointed as a person. I'm also a chair of the advisory board of open ownership, which is really focusing on issues of beneficial ownership, knowing who's behind the company, who's behind trust, people who are really rich but they are poor and they are not having any names linked to those entities. So I'm sitting there and they approach me as a person. I didn't apply for all those positions that I've just mentioned.
A follow-up to that, you have outlined your experience and what you are doing. But what you are applying for is not the past or present. It's very relevant. What would be those things, 1, 2, 3, that would be so central in repositioning the NPA externally and internally? You've been an insider at some point. Now you have the distance of looking at it from the outside. And what's the problem that you would be trying to address?
Yeah, I haven't been totally from the outside. I'm still very much involved with law enforcement agencies. As I've said, I've trained in my business, I've trained more than 23 countries on the immediate outcomes of FATF relating to law enforcement agencies, from regulators to law enforcement agencies, police, prosecutors, financial intelligence units. Currently, I'm involved in the training. You have heard of the funding coming from Germany that is being administered by the Hans Foundation. I'm one of the consultants there.
I mean, inside within the NPA.
Within the NPA. Yeah. I'm one of the consultants there, and I'm training prosecutors from even starting developing the curriculum to drafting the manuals. It's the work that I've been actively involved in the NPA. So even once I was in the FIC, I enhanced the relationship of the FIC with all law enforcement agencies. I signed MOUs with the Revenue Service, and we were able to assist the Revenue Services in increasing their orders, because we're sharing information with them, and they were saying, but we get this information sometimes when money is no longer in the bank account. And I said, I'll trust you with my information and you'll do your own analysis. And the recoveries went up. Same as I had a number, even with the Office of the Auditor General. Vision? I had a relationship I had a MOU with Office of the Auditor General.
I think the problem here is that we have not gone to the section that deals with the work, because it was a bit of a discrepancy. Maybe let me go there, so that it helps to recap, because ordinarily we would have finished that part, so that all members know, including this work, because we want to come to it. Maybe let's go back to your CV. In terms of taking us through, did they give you a copy?
I've got a copy.
Yeah, because what we wanted to understand is your track in terms of working. Because if you look at your CV, and I'll come to members, they must just keep their questions, we'll come back to them. It said, and these are the corrections so that we can have correct record of your profile. April 1995 to 2000, District Court Prosecutor, Matadini, Regional Court Controller, Prosecutor, Newcastle. This is in the 5 years. April 2000 to 2005, which is 5 years, Senior State Advocate, DPP Office, and Asset Forfeiture Unit, Johannesburg. Is that accurate?
Yeah, that's accurate.
2005 to 2007, Deputy Director of Public Prosecution, Asset Forfeiture Unit. I take it is in Johannesburg.
It was in Johannesburg, yeah.
Then, 2007, promoted to Senior Deputy Director of Public Prosecution.
Yes.
Here is this?
It was NPS. I left asset recovery and I went back to National Prosecuting Services. Okay.
2010 to 2011, 1 year, Acting Director of Public Prosecution, South Gauteng.
Yes, yes.
Okay. 2015 until NDPP appointed, Acting Deputy National Director of Public Prosecution, head NPS.
Yes.
So you acted until what time here?
I acted until I was appointed in September 2011 to the Free State as a DPP, no longer an acting DPP now. So as a permanent.
But it doesn't make sense. Because you've got 2015, and you're saying until appointed. I couldn't understand. Look at your CV there. June 2015, until, in brackets, you're saying until NDPP appointed. Then you're saying you were acting Deputy National Director of Public Prosecution. But you were appointed Director of Public Prosecution in 2011.
Minister.
So you were Free State DPP, and then you were appointed acting Deputy National Director of Public Prosecution in head office during the time you were in the Free State as DPP.
Yeah, Minister, that's not accurate. It should reach 2010 to 2011. It's not accurate. I apologize for that. It should reach 2010 to 2011. If you can read it, I'm sorry to even say that in conjunction with this paper. I'm sorry about this. Minister.
Okay. So 2010
to 2011.
2011.
Yeah.
That acting Director of Public Prosecution South Gauteng is the same.
Yeah.
And then 2011 to 2017, Director of Public Prosecution
in
Free
the
State.
Free State.
And then
January,
2018 to 2023, Director. When were you in Pietermaritzburg? Because your form talks about you being in Pietermaritzburg.
Minister, may I request that we finish with this? You said we'll finish with it. If you don't mind, can we finish? Can we come back to this at the end of the interview?
No, the reason why I had to stop, remember I parked it earlier, so that they give you a copy. But the questions that members are posing, it's about your career. Because we base our question with your experience. Remember, we're looking for a National Director of Public Prosecution. We're looking at the experience of national, which provinces you've worked. You have a footprint of understanding NPA broadly, or are you based on that? So it's important as part of our questioning. If you can see where Prof was going, that's why I stopped him, because we had not done this. This is basic. And that's why this information is provided for us up front, for us to prepare. And I was saying to the candidate yesterday, for lawyers, because you know as a legal person, if you submit something, it's a record. When you appear in court as a lawyer, what you submit to the court is a record of what you are saying. You have signed the form at the back, confirming it to be accurate and correct. Now, I'm picking up these discrepancies because these are the documents that helps us to prepare for the interview, to ask you questions, to verify, because we're looking not only for you to tell us, we want to understand your leadership style, want to understand the type of person. NDPP position is a very serious position in this country. National Prosecuting Authority is a very, very critical institution, not only in the justice system, but in the country. Now, South Africans expect us, when we do this process, to be diligent and to pay attention to detail. And my expectation is that when you sit here as a candidate, you must pay attention to detail. And a basic thing is a CV. The form itself as well. Because I looked at the form, I found these problems. I couldn't understand. I'm going to the CV, I'm finding the problems.
Minister, let me apologize again.
You prepared for the interview.
I've prepared for the interview.
You've looked at your CV, what you have said to us in your CV as part of your preparation.
Yeah, Minister, it's not an excuse, but I've said it. I've said it that I was asked to forward a CV, and I forwarded a CV to people who nominated me. The one that I cleaned up was this one. If you look at this one, but what I also did, Minister, it's my fault. I thought my experience, the positions that I've occupied, it's going to be a full page in the NPA itself, 23 years. So if you look at what I've done, I've just said district court prosecutor. I didn't even cover the control that I was talking about. Even the senior public state advocate, I didn't cover a junior. In the NPA, you wouldn't just be appointed as a senior state advocate when you haven't been a junior. And I was appointed as a junior state advocate in Pietermaritzburg during this period, 2000. But in Pietermaritzburg, as a junior state advocate, I was promoted. I started as a junior in Pietermaritzburg. From Pietermaritzburg, I was sent to Pretoria to come and learn more about asset recovery so that I can go back and open that office. If I were to be given an opportunity, Minister, because I don't want my 2 hours to be focusing on this and I end up not selling myself adequately, can I be given an indulgence to really give more information or details on this?
Advocate
Because,
Kanyile,
yeah.
we are the panel who determines how the interview process goes. Your CV is what sells you,
That's true,
and
Minister.
currently is inaccurate. I'm not using what is not in front of me. I'm using what you provided to us. When you were sent to nominate, you were asked, please complete this and sign it. And I'm saying, as a lawyer, you know the minute they say, look at this and sign, a signature represents you confirming accuracy of information. And I didn't go to anything outside. I would have found your profile in others. I'm looking at what you have provided to us. And I'm simply saying, I'm going through on page 2 of your form. District Court Prosecutor, I've gone to the number. State Advocate Pietermaritzburg Senior, you didn't. Others you have put time frames. This one you didn't put time frame. It's either you were in Pietermaritzburg or you were not. But let me tell you why it's important for us to look at the process. Sometimes you find in the system there's incidents that happen at a particular time. And if an individual has been there, we have to put it to you questions that relates to that particular office at that time. Like I was asking you about the case with the Free State because you were head at that time. So that it clears my mind. You answered me, I'm clear, I'm fine.
I'm with you, Minister.
You don't want panel members to leave and say, you know, there's a time where in this court, in this area, certain things happened.
I'm fully with you, Minister.
So you understand why it's important, the record. Because we've got to ask you these questions. But for an NDPP, because we've got to convince, I've got 2 of your CVs, by the way. I've got the reworked one, where it has more nice adjustments. I've got, actually it's 3. I've got what is called profile with your picture. And then I've got your CV that they used as nomination. And I've got the form. And the reason why the panel decided to develop a form was that in case there's information we're looking for is not provided for in the form, we should be able to say, at least the form has closed the gap. Let's go even, because if you look at the form, Advocate Kanyile, you'd have on 2, it will ask you for chronicle particulars of your employment since leaving school. Yeah? And then it will go again. There's a section where it also again speaks about your experience as a prosecutor. So here as well, these forms are not a mistake. They're meant to assist the panel to be able to do its work. So you can see here, you've got started as a prosecutor, you've explained all that, moved into Pietermaritzburg. You actually you are an admitted attorney at the Pietermaritzburg High Court, practiced as an advocate at Pietermaritzburg High Court, based in the DPP's office, Pietermaritzburg. We're looking for that information.
I hear you, Minister.
Because you were in court as well,
Yeah.
doing matters here. Because we need to understand what is your record as a prosecutor. So you understand. And that's how I would say moved into. So that's why there will be sections like that. in terms of understanding. So you concede that your forms are not going to assist. I'm not so sure when you say you want to deal with it later, how do you want to deal with it later? Because after our session, we can interact with you, would be done.
No, I was thinking that maybe you want to hear more about me.
Beyond your
beyond
your
my
CV.
CV. So I wanted to focus on that other than what we have just picked up here, which I admit that is it's something that I should have really paid more attention to. So I wanted to really focus more on focusing on your responding to your questions rather than focusing on
But these are
the
our
CV
questions.
and the qualifications. Okay.
These are our questions. Okay. What were you doing in Pietermaritzburg, and which years were you in Pietermaritzburg?
In Pietermaritzburg, Minister, I was a state advocate prosecuting cases in the High Court, and I've got a record of really securing convictions in all my cases whilst I was there. But I then left Pietermaritzburg and went to the Office of the Asset Recovery Unit of the NPA. From Asset Recovery Unit...
Which years were you in Pietermaritzburg?
In Pietermaritzburg, it was year 2000. I was there from year 2000 till I was there for year 2000, Minister, until I left and joined the Johannesburg office as the deputy, as a senior state advocate doing asset recovery.
Okay.
Yeah.
I'm going to move on and leave that one. I think we'll leave it at that point. Under financial disclosures.
Yes, Minister.
Page 8, section 6. You've got Boma Educational Trust Holding. You are saying you are a director.
Yes.
No interest, meaning that you don't gain remuneration and only receiving board fees for attendance. Africa Financial Crime Dialogue. It's an NPO.
Yes.
It's based here in the country.
It's based here in the country, and since its registration, we are still really working on what we intend to do is focusing more on training, but it hasn't been really operational.
Or you are a co-founder
I'm a co-founder.
With who?
Co-founder.
Who are the people who with?
I'm a co-founder with Mr. Roy Melnick of, he's also having a forensic company in Roteport. Yeah.
It's just the two of you.
FCRMC, and it's Elliot Tanner, Mr. Elliot Tanner. Mr. Elliot Tanner is also focusing more on issues of financial crime, and is having a business that is coordinating webinars on financial crime globally. Yeah, we had Alex Matole as part of the team when we started, but she's no longer part of us. Yeah.
So currently you are the three?
We are three.
Members of that NPO? Yeah. Okay. And, okay. So no new, it's also training?
It's focusing on raising awareness training within us. Yeah.
So it has been active? Its activities are what?
The activities, let me give the background. We picked up that there are issues that are having an impact on Africa, because every Africa country, when it's assessed by FATF, it ends up being grey listed. So we did a study to check what are the common denominators, what are the areas that leads to Africa going through the grey listing. So after identifying those topics, then we went to law enforcement agencies, to NPA, to the police, to Financial Sector Conduct Authority. We spoke to the regulators so that we get their support. We launched it with Gibbs University. After launching it, we had an issue now of how do we take this further without funding, because we cannot use money from our pockets. Then we felt it will be good if people are giving funding and they know that they are giving funding to a structure, because the support that we got from Gibbs, it was a support of just giving us a venue and giving us tea, and we bring people. So we wanted to take it further, even approach business against crime, and be able to say, let's get a sponsor or a number of sponsors who will say, we'll give you a venue, we'll really give you support, whether it's lunch or whatever, so that you do this for Africa. We are not doing it for us to gain anything. So we ended up registering it. It has just been registered recently.
And it's got funding?
We don't have funding
it
at the moment.
It hasn't received any funding?
We haven't received any funding. The funding that we are receiving, it was the funding in kind, like the one that I've mentioned from Gibbs University, to say we are going to give you a venue. Yeah.
Okay.
Yeah.
It's, this number, it's registration, so it's registered this year.
It's now registered, yeah, because we are looking into growing it, yeah. Yeah.
Okay. So you have not submitted your annual reports as yet? It will be due next
it has
year.
been recently, yeah.
Okay.
Yeah.
Let's move. And then you are a director of Langalihle Consulting.
Yes.
That's your business, the one that you
That's
are now a consultant at NPA.
Yeah. But
Okay.
I'm also doing a lot of work through my company, focusing on training. Like I've mentioned, the training that I'm doing through the EU Global Facility.
Yes.
Yeah,
Okay.
focusing on FIUs and law enforcement agents.
No, that's fine. And you have indicated in the report that should you be appointed, you will relinquish all the responsibilities.
Certainly, Minister.
Yeah, that's what you have said. I wanted to get into that. Just one thing that I need to go on record on. In your reference, can you explain how Dr. Masondo relates to you? In which capacity?
Dr. Masondo was was a deputy minister in National Treasury when I was in the FIC. So I worked very closely with him. So that's the reason I had him.
Yeah, it's based on your work as FIC.
As the FIC, so
yeah, I need to
testify
put it
on my
in
work
record
as the
because
FIC.
Dr. Masondo is a political figure.
No.
And NDPP position is critical.
Yeah.
And therefore, we do not want to create cloud. That's why I wanted you to be able to clarify the relationship.
Yeah.
It's on the basis
It's
that
on the basis of that.
you were
yeah.
appointed FIC head.
And I wasn't
being-
reporting to anyone in the FIC, so I was interacting with the minister and the deputy
and
minister.
the deputy minister. And that's the context
that's-
of him
yeah,
being in
that's
your
the
CV.
context, yeah.
Okay. I think that's important for us. Let me move into so that I can open for other colleagues. One of the issues that we ask is that you've seen being even in training of the NPA, looking at where it is now. What difference will you bring? What vision do you have of the NPA? And how will you be able to improve the situation that we have?
Yeah. Minister, I'll start. I think I've already covered the lower courts, Minister. I don't want to go back on the lower courts. Partially, I've also covered the regional courts. But if you also focus on the regional courts, Minister, my concern on how the law enforcement agencies are performing. I'll just give you an example, and it's information that is in the annual report of the FIC, of the NPA. You'll see that when I'm going to give examples with murder cases. Those are the cases that are also tried in the regional court. You'll find that the NPA is focusing more in their report on the conviction rate, which in my view it's high. And when you look at the conviction rate and you try to unmask it and say what lies behind the conviction rate, you'll see that it's a number of cases that are reported and are undetected. And from the number of cases that are detected, it's a few number of cases that results in a conviction. if you look at your murder cases, you'll see it's about 75,000 murder cases in a year. If you look at the cases that have been detected, it's about 43,000. If you look at the cases that have gone to court where you talk about the conviction, it's sitting at about 1,006. But same as with rape cases and other cases, we focus a lot on a conviction rate, which is good because victims of crime will want to know that if I take a decision to go and report this matter to the police and take a decision to testify, what are my prospects of really winning in this case? And they define success through conviction rate, but that could not be the only indicator. For me, it is very critical that we don't brag about the 10. It's a good conviction rate of 95%, you'll get 84 or whatever, but it's a good conviction rate of 10% or even less than 10% of the cases that have been reported. Then you are not really saying you are delivering quality service to the people by doing very well on 10% or even 4 or 5% of the cases that are reported. And it's not the NPA problem, it's the criminal justice value chain problem, starting with ensuring that when we deal with these cases, we focus more on quality investigations. When we say to the country, we've arrested a person is facing prosecution, we know that in 3 months, in line with the norms of standards that have been set by the JP, we are ready to say to that person, plead to the charges against you. Instead of bringing persons to court and they lose their jobs, they lose their positions, after 3 or 4 years, we say charges against you are withdrawn. Sorry. So it's very important that we focus on investigations and we bring more of these cases to the system, even if we can have a conviction rate of 70% and say we are successful, but it's more cases that we have taken to court. It's also what has been covered by ISS in a number of their papers. South African Law Commission is also touching on it. There are countries who will tell you that from the cases that have been reported, it's 50% of those cases that end up with a conviction. So we need to focus on that, Minister, and ensure that we don't have too many withdrawals that are in our court. And when we say we are going to court, we know that our investigation is complete, not that we bring cases for trial, then we investigate, and then say, sorry, go home. We are not ready. So, and it's not even those issues. In some cases, we even proceed and start a trial, and we get embarrassed when the judges are saying 174 discharge. So the quality of investigations is something that I will really ensure that I prioritize, working closely with the police, and also sending that message when you look at the indicators.
Can I ask in particular on that one? The current structure of NPA is such that the DPPs are the ones that drives prosecution, and also reporting to the DNPP responsible for prosecution currently is acting Mzinyati.
Yeah.
Now, as NDPP, where do you come in? At what point with these issues that you're talking about? Because it's not coming out. It's as if now you will be at the DNPP position, DNDPP position in how you're expressing. Because, and also, wouldn't you end up being seen as interfering with the work of the DPPs? And also the DNDPP? Yeah.
Minister, it's very critical to give DPPs their autonomy and their independence. It's very critical that DPPs be able to run with their offices without overreach from the NDPP. But you need to have the NDPP that is really visible, that can be able to intervene. I can't sit and saying, I'm the NDPP, I trust that things are going well in the Free State. I'll use the Free State because I'm coming from there, not because they are not doing well. I need to be able to intervene. I need to be able to give directions. So using the powers, the Act says the NDPP exercises overall control. That means the buck stops with you. You ultimately, you are responsible. When people are asked, you can't say, let me go and ask the DPP. You know the high-profile cases that have attracted a lot of media coverage, cases that really, if you lose them, you'll know everyone will say these people are wasting our time. So you need to be able to support the NDPPs and say, give me a copy of the docket and come and brief me. You need to be able to intervene and say, put more people in this team. So I don't believe in that. It's not only the issues of the DPPs. If you look at the structure, and it's something, if I were to be appointed,
no,
that
the
I
issue I
would
was
ask that we look
asking
into. Yeah.
is, wouldn't that be the role of the DNDPP? Was the DNDPP responsible for prosecution? Should be able to manage in that context. So what becomes the role of the DNDPP?
The role of the...
Okay, maybe
Yeah.
phrasing the question differently. Because the NDPP will decide on the DNDPPs that he has, will you have DNDPP prosecution if you are appointed?
I'll definitely have the NDPP prosecution. That's the biggest unit in the NPA. But the NPA is so huge, Minister, for you to say, I'm going to fold my hands and wait for the Deputy
I'm not saying
National.
you fold your hands. I'm just trying to give me
Yeah.
a sense of how things would be in understanding the role of the DNDPP prosecutions and DPPs in the province.
Yeah.
Remember, the DPPs as well will have their deputies. It's full complement. You've been.
I've
Full
been there.
it's staff of 300. They're working. And I'm not saying that the NDPP has to be hands-on. No.
Yeah.
But I'm just trying to understand the hands-on approach
Yeah.
in how it's being done versus the role. As I said earlier on, we have public that are listening. We have staff members of NPA listening to you.
Yeah.
So that's why the things must come out clearly so that as panel, we're not seeing as if we do recommend you or do not, having been prejudiced and not asked the right
I wouldn't
questions.
take over the responsibilities of the Deputy National Director. The Deputy National Directors are there to support me in decision-making. They are there to ensure that we've got a credible NPA that is performing well and that is respected by the people, that prosecutes with no fear or prejudice. But I will be visible and I will intervene. I will even speak to them and say, if I have to ask them to go and get me that case and say, I needed that docket, but I will be visible and I will intervene if I have to. So that's very critical, Minister. I was on a question that, Minister, you asked me. You were talking about my vision for the NPA. Can I move on and go back to that question now, Minister? So I think I've covered the number of cases now that are in the murder cases and the problem that I'm having with the conviction rate. Then, because it drives a message that deal with the easy cases and the ones that are difficult, you can look at them after 3 years or whatever. But also the support of prosecutors all over is critical. We've got good prosecutors in the NPA. We've got intelligent prosecutors who would have been at the bar, but they are still in the NPA because they are committed to saving the people of this country when it comes in the victims of this country. But they need to be supported. We have had cases, Minister, where prosecutors have been killed. We have had cases where a prosecutor is driving to the office and the prosecutor is killed. So we need to ensure that we support them in a manner, the same way that we are looking at supporting victims of crime by ensuring that they've got rooms where they can sit instead of sitting with accused persons. We need to support them by ensuring that our courts are safe. And when there are threats, we are able to really provide them with security. But I'll now go to the dedicated courts. We are saying we want to prioritize corruption. We've got the SCCU that is doing exceptionally well. They've dealt with your state of capture cases during the past financial year. I think they've finalized 6, they've dealt with your staying off. But the fusion center that is operating nationally, you need to ensure that even in the provinces, you've got SCCUs that are supported with financial investigation. If you look at what IDEC is doing now, IDEC, they are talking about the technology or digital evidence unit that they want to establish. SIU, they've got forensic accountants, they've got analysts. We need to provide the SCCU with the same support in all these provinces so that they are able to have the investigations that they are dealing with, focusing on intelligence or on intelligence-led and following the money. And when we go to court, we know that we've done sufficient investigations when it comes to financial investigation. So SCCUs also have a problem, Minister, with special directors who are just supporting. It's a very senior position, a special director. It's at the level of a DPP. Special directors with a number of corruption cases that we are having, they need to be actively involved in supporting the investigations and the prosecutions in the SCCUs. Then I will go, Minister, to organized crime, your organized crime component. I'm taking myself as an expert when it comes to issues of organized crime. And we are about to face now the mutual evaluation. We have exited the grey listing, but we are not, there's no time for us to celebrate. 2026, FATF is coming again, and there's going to be an on-site visit in 2027. By next year already, we'll be starting giving FATF information. So we need to prioritize organized crime, ensure that we are doing, there is about 99 cases, if you look at the report, 99 cases that they've enrolled, which are organized crime cases. From the 36 cases that the NPA has finalized last year on organized crime, we don't have a lot of cases involving your enablers, your professional enablers. Those persons who are attorneys, who are your accountants, who are your estate agents, who are your company and your trust service providers, who are not really involved in the commission of corruption or any predicate crime, but they are just being paid a fee to assist criminals in disguising their crime, the source of their illegitimate funds. So we need to ensure, Minister, that we continue training our prosecutors so that we increase those cases of trade-based money laundering, third-party money laundering involving professional enablers. But in organized crime, Minister, I think the NPA is doing very well, other than supporting that team and ensuring that there is training. It's what we are doing even with this foundation. We got SIPSI. I initiated to the NPA that let's got SIPSI to come and get involved and teach us about beneficial ownership information. How do you understand? How do you unpack complex structures and know the person behind that structure? Because we've got a lot of rich people, politically exposed persons who are poor in terms of paper, but they are really sitting with a lot of assets through companies registered in the names of their relatives. So those are the things that we need to be able to deal with. Then I'll move from organized crime and go to the Special Offences Unit. The Special Offences Unit, it's one office, Minister, where they are saying for the past 2 years, we have increased the number of cases that we have taken to court by 44%. This is what I want to see, cases going to court, other than cases just being closed and withdrawn and nothing happens to them. So they've done a lot, and they've increased cases that have gone to court by 44%. But the biggest issue is that 2020 we said gender-based violence, it's a pandemic. And recently, whilst we're hosting the G20, women said it's not enough. And the president has now classified the issues of gender-based violence as a national disaster. So what needs to follow now is the declaration. We need to ensure that in terms of the Disaster Management Act, there is a declaration through Government Gazette, there is funding, there is a plan from all law enforcement agencies involved, and I'll work with those law enforcement agencies to ensure that this agenda is really effective and we're able to see the results. We've got a plan as a collective from Department of Health, Police, and NPA, Social Development, to ensure that we've got a plan that speaks to us now, saying this is a national disaster that has been declared. So that's an issue that is very critical. We've got Thuthuzela care centers that are operational, but it's important, Minister, that we look at where they are located. We can't be pushing numbers and say in terms of the medium-term development plan, we're supposed to have two new Thuthuzela care centers every year and not look at where they are located. They need to be close to people who are living in the rural areas. We need to ensure that really they also get that one-stop service in the rural areas. So it's critical that we look into that. Then looking also in the NPA, Minister, what is critical at the moment and for the country is the issue of protecting our whistleblowers. The issue of protecting our whistleblowers, it's very critical and needs to be a focus. If you look at the National Anti-Corruption Advisory Council, they've issued a paper and they've made recommendations. And one of the recommendations is that if we were to establish an office that is going to run with the matter of protecting our witnesses, that office needs to be the SIU. To me, it is also very critical, Minister, that we don't have a lot of resources in the country. We need to avoid duplication. We need to assist those offices that are already existing. In the NPA, we've got the Office of the Witness Protection Office that has had 100% success rate. They've never had a witness that has been killed under that protection. But you can't force also witnesses to go through that program. They need to agree and volunteer to say, we want to be part of it. So it's important that we look at the lessons learned. That office has assisted a number of countries to learn from us. We need to sit down with them and say what works and can we amend our act so that you don't only look at the witnesses, but you also cover whistleblowers. So those are the issues that I think are critical. But the issues of FATF, I think I can add a lot of value to ensure that in the prosecution, we prioritize our terrorist financing cases. We don't have a lot of them, but we've got a number of cases that have been, a few cases that are under investigation, but what we want to see, I didn't see even a single case that has been finalized. We need to ensure that we've got that unit, and it was working well, Minister, when it was located within the NPA. Now it's sitting in the DPPs, and you don't see a lot of progress. So it's something that I can, if I were to be appointed, I can speak to the management and see how we can resolve it. Because if you don't deal with issues of terrorist financing in our country, we don't have issues of terrorism. But if you don't deal with terrorist financiers in your country, the countries who ends up being victims of the funds that goes and support terrorism in their countries, they will retaliate and will end up really having cases of terrorism. So it's very important that we prioritize those matters. We have the fit-for-purpose tools from both the police intelligence as well as in the NPA to prioritize those cases and take them to court successfully.
Thank you very much. I think you were now alluding to that vision.
Yes, Professor.
Yes. What would you say, looking over the years, has been, in your diagnosis, the problems within the NPA so that your solution is fit for purpose, as you said?
Yeah. The problem of the NPA, looking at my involvement, there was a lot of time, Professor, when the NPA was not sufficiently capacitated. Where we'll go and ask for more funding to have more prosecutors, and that funding won't be forthcoming. So if you are prioritizing fighting crime, you need to have the police. And it was quite sad, Professor, because it had to take the Financial Action Task Force to come and tell us as a country that you need more police to deal with financial crime. You need more people in the FIC, you need more people in the prosecution to be able to deal with these matters. So it's very critical that I think Advocate Batoyi was able really to push and be successful in getting prosecutors to be supported. Even the aspirant prosecutors program, there was a time for years where that aspirant prosecutors program was no longer running because there was no funding. So you can't prioritize crime and you don't prioritize capacitating your prosecutors and your police officers. The issue also of training, if we need to focus on ongoing training of our police officers. Not every police officer, even a police officer that can say, I've got an LLB, not every police officer can be able to analyze a bank statements in a corruption case. So they need to be taught. We need to develop more skills of financial analysts, financial investigators. And we're starting to talk about those skills now, and we see them working in the SIU, and the IDEC is also trying to attract those skills. Those are the skills that we need in order to be able to succeed in winning the fight against financial crime, corruption, and even organized crime. Also, the issue of really the tone from the top, the tone from management needs to be a tone that is supporting prosecutors instead of saying, we're now arresting you, what have you done? Or everyone, people are captured or whatever. It needs to be a tone that says, you are my prosecutors, I support you, but still hold them accountable. It is critical that they be held accountable. Prosecutors can't go to court when they haven't consulted with the victims, can't go to court when they don't know their case and they don't know their law. And if they don't know, we've got senior deputies in all the offices that are available to assist. They need to say, can I be assisted? This case is too big for me. Can I get a senior person, a senior deputy to come and assist me? So the morale of the prosecutors, they need to hear that the country respects them, the country cares, and they've got leadership that is behind them.
Thank you. A follow-up, Minister. The role of the NDPP is the one where you have to deal with a lot of pressure and many interested parties. The stakes are very high. Can you take us through any instance in your career where you have had to deal with a dilemma of pressure from your authority or from powerful actors, and how you dealt with that? Because you'll have a lot of that within the NPA at its helm.
Yeah. Throughout my period in the NPA and even in the FIC, I've never really encountered a situation where there was pressure that I would conclude that it's interfering with my functions. If there is pressure, if there were pressure, it will be pressure really on senior leadership wanting to see things getting done. But it's very important. It's very important that we have a credible NPA that has gone through ethics training, NPA that has gone through even the assessment by our state security, so that we know that they've been cleared. We've got the right people. Assessment that will even, we collect a lot of information in the country where we ask, especially people who are sitting at SMS, to say, give me information on your assets and whatever, but the verification is not really that much. We're not good at verifying that information. So it will be critical that we also look into that to ensure that we've got the right people in the NPA, not people who can be infiltrated by organized crime, as we are hearing at the moment, that the police are infiltrated. And there is mention of prosecutors, but it's still allegations. It's not something that has been investigated. But as a person, I'm not a person really that you can easily influence. I'm a very strong and a fearless woman. You can't come to me. Some will say I'm arrogant. I'm not arrogant, Minister. I'm a Zulu woman who respects a lot. But don't treat me with disdain, and don't. I'm that kind of a person. I'm strong. I work very hard. But yeah, it's not some. The NPA really will be guided by what the Constitution says. We are accountable to Parliament. We are not accountable to any politicians. And the law is very clear in terms of what the relationship between the NDPP and the minister. There have been court cases defining what that relationship should be looking like. It's a relationship of concurrence. It's a relationship of ensuring that the minister is kept informed, and when the minister asks things, we are able really to respond. But it's not, court cases will tell you that the minister in the case of, it was the case of freedom under law and the NPA, it involved the case of Celebi, where the court said that the minister is not responsible for the case management of the NPA. The minister can't say, yeah, get involved in case management issues and say, do this by this time and not do this at this time. But yeah, I hope I've answered that. I've been in the FIC. You have never heard of any issues about the interference or me playing politics. We work with politicians because we need to be reporting to them. There needs to be concurrence. There needs to be meetings. They've got the right to ask questions because they can't fold their hands and say NDPP is independent. But there are always checks and balances guiding that relationship, and there's even case law. Yeah.
Thank you. My last one for now is you have this backlog of cases, some going back to the Truth and Reconciliation, the Zondo Commission, and I'm sure the Madlanga Commission ad hoc committee is also adding more. Whilst also at the same time, the major changes globally are introducing new forms of crime. As other countries clamp down, for example, on narcotics, they might see vulnerability on our side. What strategy would you deploy to deal with, expeditiously dealing with this backlog and the case flow management in terms of prosecution that has not yet been deployed now?
Yeah. When it comes to the commissions, it will be very critical for me to prioritize that and check what's happening, with those cases, what kind of support really I can offer in order to ensure that those cases, they move with speed. But with what's happening now, Professor, when we assessed, we're saying we're cleaning up. After Zondo, we've got Judge Zondo, and we've got these recommendations, we're cleaning up. The Madlanga Commission is revealing to us that we haven't cleaned enough. There's still more work to be done. And it's a situation really where fingers are even pointing at law enforcement agencies, correctional service, and all that. So it will be critical, if our way to be appointed, to assemble a team that will start really listening listening to the evidence that is being heard in all these commissions from day one to date, and start really analyzing that information and being able to say what is it that we'll focus on, especially those cases where people are even killed and eliminated so that they don't testify. So I don't think you'll have to, we need to wait until Justice Madlanga is saying, here are my recommendations. We still need to start now assembling a team and ensuring that it's the team of the right people who have vetted them and is starting now to listen to that information and getting it structured. The issue that we are facing, we need to learn from our experiences. The issue that we are facing with the Zondo, there was a lot of information that was not even structured, that we need to get it structured in order to be able to use it in court. So even the issue of from these commissions, we need to start now structuring it and being able to say this is what we can use, this is noise, this is hearsay, or even if this is hearsay, we can be able to really corroborate it through these means. So it will be critical really to prioritize on that commission so that we don't have Justice Madlanga after 5 years singing the very same song that Justice Zondo is singing, that I did work but people have not been prosecuted. So that will be a priority really for me.
Thank you very much. Is it a follow-up so that I move into the management? Okay.
Thank you very much, Chair, and good morning, Advocate Kanyile. Let's just go back to your vision a little bit and ask if you consider what you know about the NPA, what you know about the law enforcement value chain, what you know about the current priorities within the country, and your recognition of what the international developments are. What would you prioritize in the first 3 years? And what do you think would be your biggest impediments, and how would you deal with those?
Yeah. Sexual offences matters will be a critical one for me. I've already mentioned it. There's progress, but there's a lot to be done, and there's a lot of planning and engagement on what needs to be done after the announcement, starting with getting it declared. So sexual offences, it's number one for me. Number two, it will be the grey listing, ensuring that we don't really find ourselves entering into the grey list again. If you remember when we were assessed in 2018, I assembled a team from the FIC. I was appointed in 2018. Same year in 2018 when I was appointed, I assembled a team that was led by Mr. Phineas Moloto to start really doing education and preparing the country for the mutual evaluation. And we set up a number of streams focusing on all the 11 immediate outcomes. And that team is still in existence and is reporting to National Treasury because we formed the IDC, the Interdepartmental Committee. So the FIC was very instrumental during my tenure in the FIC to ensure that we get prepared. But our preparation, it was quite late. We had not done a national risk assessment. I championed also the development of the national risk assessment. We finalized the national risk assessment on money laundering and terrorist financing. We need to review our national risk assessment now so that it covers proliferation financing. So ensuring that we don't go back because we are now seen as having amended the laws, but those laws have not been implemented. After we agreed, when we agreed listed, or when FATF came here, we didn't even have beneficial ownership registers. We've got them, but the issue, how effective are they? Are they being used by law enforcement agencies? So as I'm saying in the training that I'm doing, I got open ownership. I spoke to the NPA and other consultants, and I said, let's get open ownership to come and speak to the prosecutors and come up with case studies to say, what tells you that this person is a beneficial owner of a company? So the issues of ensuring that we prioritize the cases that we are saying in court of money laundering and terrorist financing will be very, very critical for us. The third thing that the third issue that I will prioritize is to ensure that we build up from the fusion center that is existing in the FIC, and we have the provincial fusion centers in the provinces. That I won't be able to do alone. I will have to ensure that I speak to the FIC, I speak to, we also have crime intelligence, I speak to SARS, I speak to all law enforcement agencies, and we identify a few provinces where we can start really having these fusion centers and allowing SCCUs to benefit from the financial intelligence in their cases. Those are the, I will also prioritize communicating with the DPPs, having meetings with the DPPs, because you cannot plan alone and run alone when you haven't sat with the DPPs to understand what the challenges are. So my first thing will be a meeting with the DPPs and visits in their offices to see what is actually happening.
Maybe as a follow-up, at the end of year 3, say you're appointed now, at the end of year 3, and you look back, what would you want to see as having been the achievements of the NPA under your leadership?
I'll be happy to see that we've got prosecutors who are able to deal, who've got Ubuntu, and they are able to deal with victims of crime. That when the victims of crime, they come to a prosecutor, they feel at home. We've got court preparation officers, but court preparation officers, they don't really take over the functions of prosecutors. I will want to see prosecutors who are proud of their profession. And you see by the way they walk, by the way they address the court, by the way really they do cross-examination, that these are prosecutors who have been polished, who have been trained, and they love what they are doing. And I will also want to see that our country really looks good. We are not a country that is seen to be really leading on a number of bad things. One number, we look good when it comes to a number of murders and whatever. We need to have a country. It's the only country that we know, and if we don't fix this country as a collective, then I don't know what we will be doing. But I would want to see really a country that is doing better on its higher risk. And those are the higher risk areas that I've mentioned: sexual offences cases, your corruption, your organized crime cases, and your murder cases.
Thank you. Mfundisi, Advocate Nissen.
Thank you so much, Chairperson, Minister. Two things. The one will be a follow-up on what our colleagues have asked, but the first one is one that you raised earlier on about the ADRs, because the perception will be created that, you can do something, and especially in petty offences, there'll be no consequences because you'll shake hands and you walk off. But the whole issue about non-custodial sentences, because that does create the perception that you cannot get away with it. So it is community service, and it is also maybe, I don't know whether we still have the tracking thing, and house arrest and reporting. Is that something that you will be looking at as part of just not simply an ADR or mediation where people say, yeah, I can do things and it's over, but that people will say, if I do something wrong, there will be some consequences, and maybe in terms of non-custodial sentences that will ensure that the person realizes that I have done something wrong and I need to correct it.
Yeah.
It's okay?
Yeah, I've clarified that it will be for petty cases, but we need to ensure that we broaden the scope and we do adult diversion. But adult diversion, there is a process there. It's not an easy win. There is a process of even involving professionals. Prosecutors can say, you've got anger management issues. Before we finalize this case through diversion, go through an anger management program. And it will be when there's a report that says you have gone through that program successfully and you are a person really who understands the consequences of your actions, of your emotions, before the prosecutor says we are withdrawing. For serious cases, for serious cases, I've been saying, I gave an example and said, if a minimum sentence, it's 3 years. Prosecutors must be open to persons who are saying, I'm coming clean, I don't want to waste the court's time. They must be open to say, instead of 3 years, I'm going to give you 1 year, 5 months, or 1 year, 6 months. I'm not saying people must go scot-free, because that will not really be doing anything in resolving the high levels of crime in this country. It's not, the intensity it's at a high level, and even the volumes on its own. So that's not where I'm going when it comes to these crimes. Even at with the corporate ADR, I've said it's not an issue of I've self-reported. I've got now systems in place to ensure that we don't repeat. I'm saying if there's a director that was involved in that corruption, that director must face prosecution. If there's a junior person or whatever in the office that were involved, those people must face prosecution. And over and above that, you pay.
The second one, Mr. Minister, to Advocate, with all the priorities in what was asked of you, what would you be doing, what next 3 years, or next, if you're successful, what you'll be doing, and you eloquently explain what you're going to do. But what is important, and you started off with talking about your leadership and so on, but what is important, it is you need a motivated people. And you need people to be inspired. You need people to know that what I'm doing is worthwhile. If in the event that you find yourself in the organization, you are in the organization, that you will identify, maybe you find a low morale, you find a divided staff or whatever, what would be your plans to be in order for all those business units that you talk about, all the plans that you have in order for them to be successful? Because all of those priorities can fall flat if you do not have an inspired and motivated and a cohesive staff that believes in the vision and will carry the vision.
Yeah. You know, being a leader, some people will say you are born a leader, but you are also taught now to become a leader. So in those cases, it also assists to take managers through a leadership development program, or through some, even if it can be short training, so that they know how they deal with people. But at the same time, if you are the National Director of Public Prosecutions, and you see that you've got a director or a leader that is a risk because that person has his own issues that end up impacting on the staff, you need to be able, I will have to be able to deal with that fearlessly.
Mr. Mtlo.
Thank you, Minister. Advocate Kanyile, I'm riding on Prof's question on case backlogs, which incessantly rear its ugly head and is an elephant in the room of the criminal justice cluster. Mindful of multiple role players involved, but I'm looking at it from the angle of the intervention that was created by the then Chief Justice Mogoeng on norms and standards. And there is case flow management, which, among others, other intervention brings about or establishes the National Efficiency Enhancement Committees, cascading them down to local level, and also coming up with timelines within which matters must be finalized. But the reality on the ground is that these challenges are still persisting, they are still ongoing, and they're still there, despite these interventions. Now, what systems would you put in place to ensure that we manage the space and ensure that we bring about speedy finalization of the matters? Because with speedy finalization of the matters, this goes to the center of the right to a fair trial. How would you manage that space and bring about a policy that will efficiently address case backlog?
Yeah. Yeah, the issue that you are raising goes back to the mission of the NPA, giving justice to the victims of crime, but working collaboratively with the stakeholders and the private sector. Law enforcement agencies have indicated that there are a value chain. So the backlog in the courts is not mainly caused by the NPA. So it's important that when you fix the problem, you fix the system, because it's a number of agencies that are involved, from the police, the quality of investigations, to prosecutors, to even the judiciary. Legal aid also is very involved. I'll give you an example. We had these norms just that, and I've touched on them, that if we investigate and we focus on investigating fully before we enroll a case, we'll be able to implement the norms by having a person pleading 3 months after the first appearance. But it's critical, that's the function of the DPPs. It's critical for the DPPs to drive that process. It's critical for the DPPs to even attend those meetings. So that will be the role of the head of NPS, to ensure that that happens. And if there are matters really that are brought to my attention, because I will be interacting at the national level with the head of Legal Aid Board, I'll be interacting with the head of the courts, and to find those solutions. But I can't find the solutions alone when the DPPs and the police provincial commissioners, legal aid, are not playing out their role. They need to collaborate and function as a team at a provincial level, and we need to be able also to close gaps at a national level. I'll give you an example of what prosecutors really are doing. Prosecutors are trying very hard. In the Free State, Minister, we used to have rescue teams. We're calling them rescue teams, where and I'll be part of those rescue teams as the DPP, where we will go to courts, visit courts, and ask from the police all those cases that have been withdrawn in court, and screen them. And we'll be shocked that we'll find a case that is supposed to be on the roll, and it's withdrawn. And the instruction that the prosecutor gave was saying follow up on 1, 2, 3, and 4, but it ends up being withdrawn. It's a case that was supposed to really come back to court, but it's withdrawn. But if you are able to screen those dead cases, you are able to even fight corruption, because you might find that there were people who were paid to have that case withdrawn. Once you bring it back to on the roll, whoever was paid will need to pay back. So the screening of those systems, people need to come up with solutions instead of problems. DPPs, if they've got problems, they need, in terms of if you read the annual report now of the NPA, Shamila is asking the NDPPs to even give report on their activities in their provinces, to say this is what we are doing to fix problems. And those activities are activities really that are focusing on the risk, on the high risk that are facing that province, and trying to address them as a collective. So we need to have prosecutors who will think out of the box and say, let's go and resolve these issues. Let's go and sit down and work on these issues. And I will ensure that the DPPs come with answers instead of coming with problems, comes with initiatives that are aimed at showing that we are prioritizing sexual offences cases. If you ask them to do that, you'll hear people saying, we now have a dedicated week, or this is what we are doing to ensure that we've got most of these cases getting more time in our court rolls. So that will be the function of the DPPs, but as the DPP, I will ensure that I support where I need to support. But it's the issue of the interagency collaboration. If prosecutors are not working in collaboration with your legal aid board and are not able in the project that we're having, Minister, the rescue team, we're able to identify even cases that we can take to Legal Aid South Africa and say, can you speak to the accused persons here and see whether we cannot finalize these matters by way of a plea? I don't know whether I've answered you. The standards are there. It's for the people to implement those standards, and oversight from the leadership, including myself, to ensure that those oversights are, those measures that are in place are implemented, and there's effectiveness as a result of the implementation of those measures.
Thank you, Minister.
Thank you. Proceed.
Thanks, Minister. Advocate Kanyila, I'll just be brief. I just want to know what is fundamentally attracting you back. Why I say that is because you are at a place where you are globetrotting, you are going from conference to conference, sitting in boardrooms with very influential people, being regarded as an authority somewhat in certain areas of finance and corruption and money laundering, etc. Yet, when you look at this position, it's a slog. It's some people have used terminology like, oh, it's a poisoned chalice, etc. What's attracting you back?
Yeah, I'll be very much frank with you. I normally tell my kids and my friends that since I've left government, I haven't seen a doctor for the past 2 years. I have quality of life. I'm able really to see what needs to be fixed in my house. I have time for my grandchildren. I've got 2 grandchildren. I've got time for my daughter. But I've always loved my country. I've always, as I've saying, even when I was outside, I was still close. When I did training through the EU Global Facility, the first countries that we prioritized were African countries, and it was South Africa was one of them. So through this training with the German funded training, through that training, developing the manuals, identifying issues that we need to prioritize when we do training, took me back to my NPA time. And through even interacting with the team through that training, I felt I was part of the old furniture again. And I got quite a lot of requests from prosecutors, and I won't mention names, saying, please, we would love to have you. It was a lot of please, please, please. And I said, really, do I want to do this? And the answer was, for my country, someone must do it. If it's me, I'll give it my all, I'll do it. So that's the reason.
Minister, just the last one. Tutuzela care centers are wholly or almost wholly funded by private sector, 66 of them. I just want to know, what do you think of that? Because this is a fundamental crime response, not even prevention, response mechanism that is supposed to be set up by government as a way of discouraging that crime, as a way of punishing that crime, securing convictions, and yet it is funded by outsiders. But this funding is also not like your proper funding. It's actually government buildings, but inside that government building, even the paper that you use in the bathroom is funded by somebody else other than government. How do you feel about that? Because I'm worried about a situation where when you have partners, I don't want to mention them, but we do know them, who may pull out. That's the end of Tutuzela centers. We will have the buildings, but the quality of service is going to be compromised. And the quality of service, by the way, continues to be compromised as a result of that. The centers that do not have local business supporting them provide a different quality of service as opposed to the centers that are maybe in urban areas, etc.
Yeah. And that's a good question. That's a good question. But I really don't have an answer for it. But what I can tell you, when South Africans, when we are told that go and attend training, or there is the EU, I engaged with the EU Global Facility before we really started to say, can you come and support us? And they've done a lot of things for the country. when you get countries that have money and that love Africa or South Africa, and they want to assist, and they say, we'll offer training, come and attend this course, we'll pay. I think we are better off in South Africa. In other countries, the donors will even pay for the traveling cost and say, we'll pay for your accommodation and we'll pay for your traveling. It's critical that we learn from those who are at a level above us. And it's critical that we grow our people. We need to just have checks and balances. If we are getting funding from government, for me, it's really not an issue because it's government to government. And you do have donors running with a number of things, assisting social development other than prosecution. And even though really we play a critical role in the Tutuzela care centers, but it is a one-stop center. It's department, that funding, it goes to Department of Health, it goes to social development, it goes to the NPA. So for me, it is not an issue. If we don't have enough funding to find our own priorities, I don't think we can say we are going to fold our hands and take no funding from people who are prepared to assist us. And before we even receive this funding, it's critical when you get funding as a department that you get the authorization from the minister. That's how I know that you'll tell the minister. That's what even the Act says. When you come with the training plans, training programs, you need to report to the minister. So if you are able to satisfy the minister that there are no high risk with this funding, it's funding like the German funding that is administered by the Hans Foundation. If it's government to government, I see no issue with that. In fact, we are a country that still needs more funding. We struggled when the US said we are no longer assisting on a number of issues. And it's an indictment on us because we should be able to fund our own priorities. But if we've got other countries that are saying, we want to take over, we are friends of South Africa and we want to assist them, it won't save us to be proud and say we don't take funding from anyone when we need that funding and when we need to train our people.
Maybe even just to, she's correct, just on the issue of funding, because sometimes it's important. We become the buffer as the department. I am coming in because there's been quite a number of people who came in the public domain to say, can NPA receive private funding and global funding? So as the department, we become the buffer, including for the judiciary. So we become the conduit of receiving that, like the High Court, Johannesburg High Court, upgrading precinct with the NGO. I thought, let me clear that one so that it's not seen as members of the panel saying no, but also this side as if we are compromising NPA, because she's speaking about how it's being done. No, we do vetting for it. We do vetting. So we open, and like she said, it's government to government on the project that we're doing with NPA.
Thank you, Minister.
You're the last one.
I'm covered. Yes.
Okay, Mfundisi, take us through the public comments.
Thank you, Mr. Minister. Advocate, there were a number of public comments, and I'm sure you've seen it. We've received over 200. In your case, there were 8 in support of you and 0 against you. And they speak about your leadership, your dynamism, your international and your national contribution, your transformative approach, but also there's only one that says cautiously supporting you, but there were 8 in support of you and 0 against you.
Thank you. I didn't see the 200. I think I saw the ones that were written and forwarded to me, and I had to respond to them. Thank you. Thank you.
Thank you, Minister.
Thank you very much. Yeah, you received positive comments, mainly. Nothing much afterwards, but I think is that work. You'll be happy to note that we've come to the end.
I'm so happy, Minister.
I I can see the way you're looking at me. It's like, there she goes again, paging her file. Thank you very much for availing yourself for this interaction. And we have come to the end. It was quite a fruitful engagement with you. And we thank you very much for making time.
Thank you, Minister.
Thank you very much.
Thank
and
you.
have a
Thank
lovely
you.
day.
Thank you. Thank you, too.
You want to stretch legs and then we take the next one. Otherwise, we lose the audio and the process. I think all other matters, I'll deal with them at the end. Let's bring the candidates so that we don't disrupt the process. Good afternoon, Advocate Krunya.
Good afternoon.
How are you?
Minister. I'm well, and yourself?
I'm okay.
Good. Just
I'll
give
allow
me
you
my-
to settle.
Thank you. Thank you. I'm settled, I think.
Okay.
As settled as I'm ever going to be.
Okay, no, don't be nervous, just be relaxed. You've got your questionnaire with you.
Yes.
Okay,
Yes,
thank you. We're going to start with the questionnaire. I'll take you through the questionnaire. And then, together with panel members, we'll ask you questions. And then we'll take you to the section that deals with the comments. You would have sent you the public comments that we've received about your work and you. And then, let me just check who is going to lead that section so that I don't have to come back. Okay. It's Advocate Spania who's going to lead on the questionnaire for you when we come to that section.
Thanks, Minister, I don't have a copy of the responses that I have it on email, but I don't have a hard copy. I received.
Would you like the hard copy?
I would, if
Okay, the
that's-
Secretariat will make that hard copy for you while we deal with the others. Thanks for flagging that. We'll be making that copy for you so that it's easier. But if you want to open your laptop, you're allowed to.
Thank you, Minister.
So that you can get the
It's
information.
my safety blanket, so I'll keep it here.
You are, yeah, myself as well. I battle with papers, so that's why sometimes I go to my gadget. We'll go through section 1. It's your personal information. That is confirmed.
Yes.
And then we go to your qualifications. If you can take us through how these qualifications are important for this position and how they are relevant for the position of the NDPP. And you can keep your mic on. It will not disrupt us, so don't worry about switching it off. Otherwise, you'll forget to switch it on again. So you can keep it at, we will switch ours as we speak.
I'll apologize in advance because my glasses are for reading here, but when I'm looking at you, I have to take them off, so they get very annoying. So you want me to take you through my qualifications. I did an undergraduate Bachelor of Arts degree at the University of Cape Town from 1990 to 1993. I actually took a year longer than I was meant to, because I was SRC president in 92, 93, and politics was quite intense at the time, and my academics suffered a bit. In fact, Latin in particular proved to be a challenge. So I was meant to do a 5-year BA LLB, the accelerated one, but it wasn't compatible with being a student activist and being SRC president. So then, actually between my undergraduate degree and my LLB, I was selected to participate in a diplomatic training program. It was a project to skill up young professionals to take up positions in government. And my majors in my undergrad were in politics and in English. And in politics, I was asked if I wanted to apply for this program. It was the first part of the program was run out of UWC. And then if you qualified to the second round, you went to New York and Washington, D.C. for the second part of the program. So I did that. I did both parts. And so I have a certificate in diplomatic training. And it's a certificate I'm very proud of, but I suppose has come to define my character. But they described me as a little unnecessarily contentious, because I think in a meeting with Hillary Clinton, I asked what they considered a very undiplomatic question. I knew then probably a career in diplomacy is not really for me. So I came back and did my LLB, which I finished in 1996. But I still wasn't sure what career I wanted to do. You know, you grow up, I grew up in a township called Atlantis, and your options were doctor or lawyer. If you had, actually, the option was machinist, because all the people in my family worked for clothing factories as machinists. So I was terrified that that is going to be my fate, because I didn't consider myself very good at sewing or knitting or anything to do with making clothes. So, but I remember failing Latin in university and saying to my grandmother, yeah, so I don't know about this law degree, whether it's actually going to happen. And she said to me, don't worry, you can always switch to medicine. And indicating that there weren't very many people who had any idea what it is that I was doing there at university. But I thought, I mean, I was going to be a lawyer because that's what everybody told me. If you have a big mouth and you're outspoken and you debate, then obviously you're going to be a lawyer. But arriving at university and seeing all these options, I thought I should pause and just give it more thought. So I didn't apply for articles straight away. I went, because it was an exciting time in the country, you know, the Constitution had just been adopted and Parliament was in the process of passing laws that was going to reshape the country and lay the foundations for the new democracy. So it was a really exciting time to be there. I was appointed as a researcher to the Select Committee. I think I've moved on from my qualifications because my next degree comes 10 years later. I have a master's in public administration from the Harvard Kennedy School. And there too, I had to decide, am I doing a master's in law or am I doing a master's in public administration? And having ended up in the prosecution almost entirely by accident, because I was working for Bulelani Ngcuka in Parliament, he becomes the first national director. I end up in the National Prosecuting Authority. After 10 years, I thought, again, you need to think about this. Is this the career you really want to do? And at the time, I mean, I was in the public service and interested in management, and I thought, let me give this a try. So I applied for this master's program, and I graduated a year later. I spent a year in Cambridge, Massachusetts. So that is my professional qualifications.
I thought you link it for us in terms of the work in the NP, but let's get to the history of your work. I think as you respond, you'll be able to do that.
Yes.
I'm going to start where you just left off at the Select Committee in Parliament. So you were in the Select Committee 1997 to 98 as a researcher. And then you moved, and thanks for the detailed and explanation of what this position is about. I think it's quite helpful. In a number of areas you've gone in detail to explain, especially in areas where it's not within even the country. So August 98 to 99, professional assistant to the Director of Public Prosecution.
The first National Director of Public
first national
Prosecution. So
director.
I was one of about 4 staff members.
Okay.
So the NPA you see in the VGM building now started out with us looking for chairs to sit on because the commencement of the office was announced with the appointment of the National Director, and that was it.
Okay.
And we
We'll
had to
we'll
build
get
from scratch.
into that in terms of your experience as well. And then 1999 to 2000, junior state advocate, and then 2000 to 2003, senior state advocate. And then you moved March 2003 to 2012. AFU, regional head. I see here, this is the period you were able to take a sabbatical leave to do your master's at Harvard. And then December 2012 to 2018, advocate in private practice and a member of the Cape Bar. And then you moved in that National Prosecuting Head, Investigating Directorate, 2019 and until 2022. Okay, we'll come to that. Open Secrets NGO, part-time head of legal unit, 2021 to 2022. This was consulting.
Yes.
Okay.
I was also consulting outside of Open Secrets.
So it was multiple consulting
yes.
process. Okay, that's understood. And then part-time legal researcher for the DGRU, the Democratic Governance and Rights Units in the University of Cape Town. You are contracted there currently.
Again, part-time, and
Part-time.
I consult to the World Bank, UNODC, and STAR.
Yes.
Yeah.
UN Anti-Corruption Law Enforcement Global Network, also 2023 to 2024.
So with my short-term contracts, that's what the official term in the UN system and the World Bank system, these are called, and they go from year to year, and there's 30 days for this particular project, 100 days for that project. So none of them were full-time. They were all part-time, short-term
project-based.
contracts. Yes.
I think, what we're looking for as well is what has been the work there, and I think you've done as well to assist us. But we're trying to ensure that it's also on record in terms of anti-corruption specialists and strategic work, and we'll get into that because it's within what we also, I think there's a link with our work, or that's UNCAC as well. And then it goes into European Union anti-corruption initiatives that you've done. It's also as a contract.
Yes.
There, okay. And then this one is the Stolen Asset Recovery Initiative with UNODC as a partner, but also being able to work with NACEC
Yes.
in the anti-corruption, national anti-corruption institutional architecture proposals that we have. That's between 2013, 2018, but also currently. So it's in phases as well.
Yes.
Okay. And then currently you are freelancing as an international anti-corruption and asset recovery specialist. Just take us through your journey in terms of professional, because I don't think I'll do justice in what I'm doing here. I'm looking at quite a number of issues. I see here you've also done some research in terms of accountability in terms of the state capture accountability projects involving PRAS and Transnet. Maybe take us through that process of your work that you feel is also important. I've selected what I saw is as critical for me to ask questions. And I think I'm being fair because you've written down, and if I am to read everything for the record, but perhaps let me give you an opportunity to go through it.
So I overcompensated. I will try to be brief
Actually,
then. Yes.
to be honest, it's far better because if you don't have much information, then we deal on one issue that we don't move on, whereas it doesn't allow us to get into the real critical issues.
I think because I'm in private practice and I have to advertise and market myself to get projects, I have to be able to demonstrate what I've done for people to risk reappointing me to do further work. So that's why I have a CV that captures what I've done over the years. So I do want to briefly start with the very beginning, the setting up of the National Prosecuting Authority, maybe even before, the year in Parliament where I first, I think, got interested in issues of criminal justice, because we were looking at the National Prosecuting Authority Act was before Parliament at the time, the proceeds, the POCA, Prevention of Organized Crime Act, the International Cooperation in Criminal Matters Act, so the ICMA. These were all laws that I was doing research for members of Parliament on and looking at comparative studies around the world. So I think that's how I became interested in these issues. So when entirely fortuitously, the chair of the select committee and my boss at the time, Bulelani Ngcuka, was appointed the first national director of public prosecutions, he asked me if I would join him as sort of a personal assistant for want of any other title, because there was no organizational structure, there was nothing. There was basically, we're going to go there and we're going to start this thing from scratch. And I think he also brought his secretary from Parliament. He brought Sipho Ngwema, who became the spokesperson for the NPA. And we were the people who started the process of establishing a structure that came off the ground very quickly and developed very quickly. But what it gave me was an incredibly privileged vantage point, watching, firstly, Bulelani Ngcuka as a leader in a very complex environment, because he had all these former attorneys general who were practically, frankly, hostile. And he had to win them over, at the same time set a tone and an agenda that spoke to change, that spoke to how we are going to do things very differently in the NPA going forward. And I think it is a responsibility he acquitted himself of fairly effectively, I would say. I had many criticisms, and he would be the first to tell people how freely and openly I would criticize him. But I think, stepping back, he had a unique set of skills for that moment and that time. He had to set up this national office. There was a compromise, basically, at the Constitutional Assembly, because before 1998. The attorneys general were basically laws unto themselves in their divisions. They only answered to the Minister of Justice and under apartheid. And so for them to now account to and report to a boss was new and in their view, mostly problematic, because they feared political interference. They feared that they would be directed by a political head in terms of who they should prosecute and who not. On the other hand, the things needed to change. The prosecution before 1994 was a very different project to the one that we wanted to create under the Constitution. There was now a Constitution that had to be implemented and complied with. So these were very tricky and difficult decisions. But the compromise reached is that the national director would have the role of setting policy, of almost being the bridge between the minister and the executive authority and the professionals in the prosecution. So the idea was not that the NDPP would exercise original prosecutorial discretion. That was reserved for the DPPs. They were then given the continued authority to institute and stop prosecutions, whereas the national director could only act through policies and directives, in, making sort of through directives rather than through direct management of those people. I enjoyed very much working with Bulelani, but I also thought if I'm going to become national director myself one day, I'm going to actually have to get some legal experience and get myself properly qualified and practice. So, you know, shortly after the establishment of the Scorpions, the establishment of the asset forfeiture unit, which again started with Willie Hofmeyer, myself, and a colleague, Lungisa Diosi, built up an institution that 10 years later I was very proud of. And I think you asked me to point out a highlight in my career, and I think what we did in the asset forfeiture unit in the first 10 years was extraordinary, and it's less recognized here at home. It's much more appreciated out in the rest of the world because, you know, almost 60% of the work I get is off the reputation of the South African Asset Forfeiture Unit, of the jurisprudence, the body of jurisprudence that we had developed over the first 10 years. The Asset Forfeiture Unit in South Africa is still recognized as one of the leading asset forfeiture units in the world. So I joined the Asset Forfeiture Unit, and I had to make some career decisions because while I was in the National Director's office, I was studying part-time. I wrote my 4 attorneys admission exams, and I passed them. And I was left to do a 6-month, I also did the School for Legal Practice for 6 months, and so I was left with 6 months in articles. And I said to Bulelani, I think I need to go do these 6 months, otherwise I'm never going to do them. But then really persuaded me that this is an exciting opportunity. It's a once-in-a-lifetime opportunity to start something from scratch, something so novel, and something you can shape and impact on, that eventually I was persuaded. And so I spent the next 10 years doing that. And I say 10 years because right in the beginning, we had colleagues from other parts of the world come and talk to us about implementing an asset forfeiture unit and an asset forfeiture strategy. And there were all these people who said, oh, I've been doing this for 10 years, 15 years. And I just looked at them thinking, I want to be able to say that I have 10 years of experience in this thing. So when my 10 years came, I was also confronted with an NPA that was looking less and less like the one we started building under Bulelani. And there, you know, in 2010, I had come to the point where I was also exhausted. I had been working very hard and under very stressful conditions, and I thought, maybe I just need a break. Again, really persuaded me that instead of taking a break, maybe I should take a year sabbatical, apply, you know, study somewhere for a year, and then come back and continue the fight.
Maybe explain that. Was it conditions in the environment that got you exhausted?
Yes, it was very stressful being in the NPA in 2010, 2009, after the disbanding of the Scorpions. And you know, one of the ways in which I thought capture of the NPA took place was appointments into positions in in 2009, I was part of panels for junior state advocate positions in my office in Cape Town. And the NDPP, a deputy national director, and some senior deputies were on the panel for a junior state advocate position in asset forfeiture. That was unheard of.
From National?
Yes.
It's a panel from National?
Yes. I was included in the panel, but it primarily consisted of an HR rep, but the national director. And I raised concerns about this, saying, okay, firstly, my immediate supervisor isn't even on this panel, but it's unusual for someone of that level to be on a panel. But the national director is the ultimate appointing authority, so it didn't seem appropriate for him to be in the panel. It was Advocate Simelane at the time. Yeah, so he was an acting NDPP, but nevertheless. And Advocate Jiba was also there. And I couldn't understand the purpose of this. But as the interviews unfolded, it was very clear to me that the purpose was to appoint people loyal to what they considered their faction, and not people loyal to what they considered the other faction, which was the Willie Hofmeyr faction. And I remember thinking this is extraordinary, because we were appointing people in asset forfeiture. We were developing people in asset forfeiture. It's a very unique skill in the NPA. So there were people who had developed experience and applied themselves, and they were ripe for appointment. They were not recommended in the end over my recommendation.
Sorry to interrupt. So majority were people would have been people from outside who got appointed then?
Yes, definitely. And I'm not averse to that, because we were looking for people from outside, because in the prosecution, there are not many prosecutors who have civil litigation skills and practice and experience. So we were looking for people from outside. And we were also looking for young black people. The reason ultimately given for some appointments was representation. But we only interviewed at that point black staff, because the demographics in the organization were really very skewed. And so our project was to advance transformation. But the people who were selected were not suitable. And
so were not qualified?
They had, well, that's the issue I would love us to debate at length. What qualifies you as a prosecutor? For me, that is the most critical question facing the NPA today. What qualifies you as a prosecutor? I think then it was a basic 3-year legal degree. For a junior state advocate, you had to have, I think, between 3 and 5 years legal experience. That is also an extremely debatable term. So people qualified, but whether they were the most appropriate people and the best qualified people to occupy the positions, I didn't believe so. I wrote a memo afterwards raising all my concerns with the process and send it
because you were the head of that.
I was the head of the asset forfeiture unit.
That you work with.
So this is the team I was going to now have to deliver on with. And it not only gave me people who would require a lot of training and a lot of support, but it also demoralized people who had worked really hard and thought that they had produced and thought that they had done what would be required of them to be appointed in those positions. So it was a real double whammy. And I thought, you know, there's not a lot I can do here, but I'm going to record my objections. I even sent it to the Department of Justice as well, because at the time we reported. And I wrote a memo saying, I think this is unlawful. It does not comply with the prescripts of the organization, of the public service, but I had no response. And I think that's a process that replicated itself in a number of areas. So appointments were made primarily on the basis of loyalty than on competence and skill and contribution, which I thought was a real danger for the organization. There were lots of other things happening at the time that, you know, if I had more energy, I certainly would have, you know, rolled up my sleeves and got into the fight. But I also was wondering if I shouldn't be, you know, qualifying myself as an advocate and seeing what a career outside of the public service looks like. Because in the public service, strangely, consultants and outside counsel are given a lot more respect and credibility than those of us who spent 10 years in the place developing the skill and the experience. But I thought I should go and have a look at what it is that they are supposed to have from doing that and see if it's fair, that assessment. So I did apply to Harvard, and I did get in. And while I was away, my staff in the Western Cape were working on, I had done the Shabir Sheikh case, the asset forfeiture part, with senior counsel, Advocate Wim Trengrove, and can't remember exactly who the other counsel was, but we did the legwork, and you know, they added tremendous value. And one of the things I think Willie Hofmeyr was astute to realize early on is that you have to sell this law and to get this law implemented and effectively utilized, we needed good jurisprudence. And because it's novel, you needed people that are trusted and respected in the eyes of the judiciary to run these cases, which, you know, was hard for us to swallow because we thought we deserved opportunities like that. And I think we had many fights with him about who, you know, whether it's us or them, internal or external people. It's interesting that later on I had to confront those arguments again myself with the shoe on the other foot. So
we'll come back to that.
Yes.
Yeah.
Yes. So I think in 2010, I would say, certainly was the beginning of capture of the NPA. And the primary tool was through appointments. Particularly, I would put my head on a block and say appointments in the Specialized Commercial Crimes Unit. And, you know, the NPA I left in 2011 and the NPA I returned to in 2019.
Your record says 2012 you left.
I left in 2011.
To go to Harvard.
I did pupillage at the bar.
Oh,
so I
okay.
didn't, so
Okay.
the bar was kind enough. For my 10 years in the NPA, they recognized my experience, recognized 3 years of that as relevant experience.
Okay.
So I was on the same level as attorneys who had 3 years legal experience, whereas I had 10 years. But I did, they gave me 3 months off pupillage, the year pupillage as a credit for my experience. So I left the NPA in about March 2011 and finished my pupillage at the end of 2011. So I started my career at the bar, my consulting career with STAR and UNODC in 2012, at the beginning of 2012. So yes, when I left the NPA, it was very hard because I felt the NPA head office, the office of the national director, I had been very involved in. I knew most of the people as the place was growing. In AFU, I was part of the management team for 10 years. And I could see that it was not going well. When I was at Harvard doing my degree, one of the cases my staff in Cape Town were working on involved a seizure of assets in in Switzerland. The Swiss authorities had told us that relating to an arms deal case, we have, a couple of 100 million, and our eyes were all very big because, we had never done cases of that magnitude back then. And so my staff in the Cape Town office, I was at Harvard.
Was it not the first one, the first case of asset forfeiture externally?
Yes.
It was the first case.
It was the first case seizing assets in another jurisdiction, getting an order here, because we had to address the issue of jurisdiction and how can you get an order in South Africa in respect of money located in another jurisdiction. But we got a preservation order in that case. And my staff were all extremely proud, and I certainly was proud of them, because it was novel and big and impressive in so many ways. Only to learn that the defendant in that case had made representations to the acting national director. I don't know yet if he was appointed permanently by then, but Advocate Simelane had met with the defendants and had decided that he didn't see the underlying criminal activity, that we said this money was the proceeds of crime. And he instructed my staff to withdraw the application. And
okay.
Yeah.
Just on that, was it still at application or you'd won?
It was
still at
application stage. So it was a civil forfeiture application. Yes. So you start with preservation, and then you have 90 days. You give notice to all interested parties, and then the NPA has 90 days to bring a forfeiture application.
And the representation was done directly at national.
Yes. Yes.
Because AFU would be.
Yes.
It was, okay.
Well, so
maybe just explain. With
yes.
others, representation, for example, it will be with the DPP,
yes.
not with the NDPP.
Yes. But
So
asset forfeiture is slightly different because the national director is the person who is authorized to bring asset forfeiture applications in her own name. So even when we bring the applications in the DPP's office, we don't cite the DPP, we cite the NDPP, because that's what the Prevention of Organized Crime Act requires. But remember, I'm sitting in Massachusetts trying to do a degree. I'm also very pregnant. And my staff are saying to me, how is this possible?
What was the value? Do you still remember?
I don't, but we did. An affidavit was put into the Zondo Commission on the entire saga. It didn't really address it, though, unfortunately, because it didn't. I think it ran out of time to address issues relating to the NPA. But certainly the advocate who dealt with this matter did an excellent job in the affidavit of recording how this entire thing happened. And it's almost a lecture in state capture. And so, when these things were happening, my first reaction was, because I can be quite impulsive, I thought I should resign in protest because this is unacceptable. For a court had decided we had made a case without going back to court and allowing the court to make the decision. We were told to withdraw, and in the end.
Maybe you're saying the court had made a decision.
A provisional decision. Yes, so we got an interim preservation order from the court, ex parte.
Yes.
So what should happen next is we give notice to all the interested parties. They can then set the matter down and say they either want to contest the preservation or, because we have 90 days from that day to file a forfeiture order, they can decide they will oppose forfeiture, because the standard of proof at forfeiture is balance of probabilities, whereas at preservation it's just reasonable suspicion. But so they did. We were told to withdraw. So I wasn't here, so I didn't have all the details about who actually withdrew it in court, who actually went to court, because none of the staff in my office did it, because they It also wasn't a Cape Town matter because I was involved in the Sheikh matter, so in the arms deal matters. And so they just continued working on those matters after I left. So it was a Gauteng matter, and someone in the Gauteng office went and withdrew the matter because we act on the authority of the national director. So our affidavits are in the name of the national director. We sign them with authority delegated to us by the national director. So the national director, of course, overrode and could withdraw. But you know, after that happened, I didn't resign immediately. I had to come back and work back my sabbatical time and pay back some of my sabbatical money so that I could be released to go and do articles. But, you know, I could see that the writing was on the wall, but I didn't realize that things would deteriorate to the extent that it did when I returned in 2019. But shall I talk a bit about...
Yes, because I noticed I have on my notes here that you left 2012 to return 2019.
Yes. So, but in between, I said what stood me in great stead is the reputation the asset forfeiture unit had internationally. So as soon as I started at the bar, worrying about where I was going to get work and how I was going to survive, colleagues from the Stolen Asset Recovery Initiative approached me and said they were doing a project in Tanzania with setting up, with the DPP's office there, the Director of Public Prosecutions. They just adopted an asset recovery law, and they wanted to support that office with training. So I started off with the training that was about what we did when we started out the asset forfeiture unit. And it was really well received. They then, you know, it became a 2-year project, and then it became a 5-year project. And after a while, I was mentoring them quite consistently for a period of time. And out of that grew a whole lot of other projects that I did around the world, mostly in the first part, mostly on asset recovery, you know, asset management. I ended up writing a publication for UNODC on the I wrote it in my CV on the management and seizure. I'm too tired now. I can't even remember my own publication.
Okay.
Seized and confiscated assets. Yes,
we'll come to that even as part, because we're interested more in terms of this work experience in the NPA, but also how it adds value into that. So that I can take you through the question. I wanted you to take us through, because as I say, what is coming out is you leaving at 2019, come back at 2012, coming back at 2019, but only to leave in 2022.
Yes. So
we understand why you left in 2012.
The first time.
Why did you leave in 2019?
So
in 2022, sorry.
2019, I arrived. I was called by the NDPP. I was, in fact, at the time in Tanzania. And she asked if I would consider leading up the investigating directorate. And I was certainly not convinced. But what intrigued me is I had been working in Sri Lanka, in Ukraine, Moldova, Kenya, all over Africa. And it's advisory work. So you pour your heart and soul into advising, and then it's up to the practitioners there to decide whether they're going to take your advice or not. And 9 times out of 10, life happens. And by the time you come back 6 months later, they're scrambling to make it look like they did some of the things we all agreed needed to happen. So I thought, I mean, I'd been doing this for 7 years. I'd been practicing at the bar. I'd learned an incredible amount of the practice of law, and I certainly want to come back to the experience of qualifying as an advocate in private practice as opposed to qualifying as a state advocate, which I think is critical to where the NPA finds itself today. But I came because I thought this is an incredible opportunity for me to implement some of the things I've advised people to implement in their own jurisdictions and haven't quite had the satisfaction of them doing it the way I think it should be done. So I agreed with the national director that I could do it for a few years. I still had relatively young children at the time and wasn't convinced that I should move them to Pretoria because I would have no time for them. I would disrupt them from their routine, but then not be available to support them in settling here. So my husband and I took the decision that they would stay in Cape Town and I would, and as far as possible, commute. So from a personal point of view, I wasn't off to a great start. But I don't think that was the reason I left. I left for professional reasons. I left because I felt that I think I said in my response to the questions I had, I found that the space wasn't there for me to implement the things that I thought should be implemented. And I will give you a few examples. But you know, I was first struck by the levels of dysfunction that I thought I was seeing in the NPA. But I was surrounded by people, not everybody. I often get accused of saying everybody in the NPA is useless because I criticize some aspects of the NPA. But I certainly saw dysfunction that I thought needed to be addressed. But if you raise the criticism, the counterattack is, you know, you're negative and you don't. So I was in an organization where there was a narrative that actually everything's fine now in the NPA since the capturers were left. So now we can just be left alone to carry on as before. And that was definitely not my experience and certainly not what I thought needed to happen. And let me give some concrete examples. The one that I was most quoted for is that I said there's a skills catastrophe in the NPA.
You what?
A skills catastrophe.
Explain.
I'm prone to hyperbole, but what I meant, there was a skills crisis in the NPA. I still believe that. I must start immediately by saying that doesn't mean there aren't very good people in the NPA with very good experience. But as a rule, we are failing in ensuring that prosecutors have the skills that they need to come up against skilled legal professionals on the other side. And
this is across.
It's across the board, is in my opinion. Not everybody, but it's systemic. And I want to address the systemic causes. I don't think this is because there are individuals there who aren't hardworking or there are individuals there who don't take themselves seriously. We have designed the system to perpetually relegate prosecutors to second-class legal professionals. And that's the problem, you know, and that's the problem I felt very strongly needed to be addressed. But I kept being confronted with how many years of collective experience everybody had, because people have been there for 10 years, so they have 10 years experience. Whether they were actually practicing in court, when I tried to recruit people to the ID, I was looking for a specific type of skill. I wanted people who had conducted opposed trials, people with litigation skills, people who were confronted with large volumes of data and could extract from that a charge sheet or an indictment that spoke to the most serious offenses that were committed, but at the same time could get you a prosecution happening sooner rather than later. And the people who were already working on state capture cases when I arrived, I was told, here's the team working on state capture cases. I, by and large, didn't think were equal to the task. There were exceptions, but I'm just saying as a general rule. I met with management and I said, we need a skills audit. We need to understand what skills people actually have, not talk about 20 years experience because people have been in the NPA for 20 years. What were they doing in those 20 years? How many court appearances have they had and in opposed matters? I was told that a skills audit had been done before we came there. And I promise you, I'm quoting verbatim, the results were so depressing, we thought it would just demoralize staff if we released them. So for me, that's tantamount to saying, why don't we just bury our heads in the sand and hope this problem goes away? I wasn't given the results of that skills audit, and I said, it's probably dated anyway. Can we do a new skills audit? And I think a year ago, a skills audit was released, but only partially released, because it's an issue I'm interested in, so I keep an eye on parliamentary hearings where this issue is discussed. And we will all speculate if we have to talk about how many people in the NPA have the ability to cross-examine effectively. There are many ways to become an effective cross-examiner. Certainly the most brutal is being thrown in the deep end in cases and develop your experience like that. You can get good training in cross-examination. You can get good mentorship. But we don't know how people are getting those skills in the NPA, and we don't know how many people sit with those skills.
But is that the reason you left?
It's fights like that. Everything in the NPA was a fight. I needed to get a building for the IDAC, for staff in the IDAC to put down the dockets, have investigators come and work. I became an expert in how to procure from Public Works a building, because nobody else was supporting us getting a building. You would hear that there are reasons why it's difficult. And it's DPSA, or it's this department or that department. But I didn't find there was a drive. One of my staff members at the time was saying to me, you should actually ask the panel to get all the memos you wrote and see how many memos on every issue, from a deviation to procure staff. You know, I had to become an expert in all these public service processes, because you would be told that it's not possible to do what you want to do. And
this is from sorry to interject. I'm trying to understand. This is from NPA and the department?
It's from the administration in the NPA.
Okay.
And of course, the NPA administration would often say their hands are tied because of the DOJ administration. I wasn't that sure about that. But, you know, what you found in the NPA is a disinterest in implementing the policy that you want to implement. People were far more invested in saying why this can't be done than they were in trying to figure out how to do this. You know, I worked with Bulelani in those early days, and he had a can-do attitude and a let's get it done attitude. Around Pagad, you know, in the Western Cape, he stuck his neck out and said, you will give computers to the investigation team working on that matter. And I will explain at Parliament why I made an urgent decision to procure in that way. So, you know, it does take leadership to say, this is what needs to be done. Of course, you must do it within the prescripts and within the confines of the law, but find a way to do it. Don't tell me it's not possible. Because if it's not possible, write me a memo on why you say that, and I can escalate the issue to the people not making it not possible. But, you know, No, it was exhausting and frustrating because on the one hand, you're trying to build cases. On the other hand, you have nothing. You have no staff, no infrastructure, no budget, just generally no support. Very quickly, I was getting memos about how I was responsible for irregular expenditure, or memos saying that I was breaking the law. And I realized that I'm on a hiding to nowhere here. And I also thought that, I'm not getting any traction at senior management level on what I think are the priority issues that we need to address. I was very early on labeled problematic, and it pretty much descended from there, that I didn't get much support. Every little ounce of infrastructure that we got, I can give you a volume of memos that I had to write to justify, to follow up, to overcome objections or overcome constraints. And meanwhile, in the public court of public opinion, we're being pilloried for not delivering on the prosecutions. And on that front even, I felt undermined. I had certainly had clear ideas about the strategy that I wanted to implement in our cases. The Nulani case for me is
We're going to come to that because I'm interested in your vision going forward.
Yes.
Let's get to the point where we complete our section of the questionnaire. We have gone through your legal background and your work in terms of what. Maybe just talk a bit about the poker work. I think you didn't go into detail, and then we'll go the prosecuting side we've done, and I'm interested more your experience in law, criminal, civil, and all that. If you can do that.
Yes, thank you, Minister. The poker work, as I said, is my proudest achievement and most satisfying. But it wasn't always like that. When we opened up shop as the asset forfeiture unit, there were no takers. No one was interested in using the provisions of the Prevention of Organized Crime Act to recover proceeds and instruments of crime. In fact, all legal professionals, prosecution, defense lawyers, certainly constitutional lawyers, everyone was convinced it's unconstitutional. You cannot take away the assets of someone who is not convicted of a crime on the basis that you say it's proceeds of crime. So the conservative legal fraternity, and probably judges at the apex of that conservatism, did not believe that any of the provisions of poker were constitutional. And every case we were able to put together was challenged in the Constitutional Court, which is why we have such a rich body of constitutional jurisprudence. And I don't know if anyone here remembers, but our early cases was met with much fanfare, typical of even the Scorpions in the day. We had cartoons saying Willie's removals when we were loading assets of criminals into the truck and taking it off. And then a few weeks later, Willie's returnals because we lost the cases in the early days, which we realized meant we had to regroup, and hence the strategy of bringing in the most senior, serious legal minds in the country to present the cases in court. And very quickly, we developed jurisprudence on the key issues, that it is constitutional to seize assets. It's constitutional to even approach the court ex parte in the early days. We litigated so many issues in the early days, and we have a very proud body of constitutional jurisprudence that I train people in other parts of the world on, because you listen to people now talk about asset recovery as if it's very ordinary, as if it's a no-brainer that this is the way to deal with organized crime. Back in the day, we were treated with a lot of suspicion, thinking, what is this newfangled ideas that we're coming with? But I think under the leadership of Willie Hofmeyr, I think, I was privileged to have really good bosses in my day. Bulelani was one, Willie Hofmeyr was certainly another. I have great respect for his strategic ability. He's not infallible, nobody is, but I certainly respect the vision that he executed in the asset forfeiture unit. I almost lost track of where I am.
No, it's in the law explaining
Yeah, the
yourself. You
poker.
started with, so you need to go into the areas of other
law,
experience in criminal and civil and all that.
So most of my experience, I don't have experience prosecuting cases. I think someone raised that as an issue and asked, did I think it was necessary to have this experience? Obviously, it's a very important advantage to actually have been in the trenches and done the work that you expect prosecutors to go and do day in and day out. It's also, when my career was fashioned in asset recovery, which was predominantly civil work, and there wasn't a lot of civil experience in the NPA, so we largely built a capability from scratch, trying to recruit people from the private sector. So better, and there were lots of curious and interested prosecutors who also, we considered ourselves the mavericks, not the run-of-the-mill people, because we were willing to try new things. And asset forfeiture was way more satisfying than prosecution because it just could happen in a lot faster time frame than the prosecution seemed to be happening. The skills that you need to be effective in asset recovery as opposed to prosecution is good writing skills and good synthesizing of evidence skills. And we found that that's actually not a skill as abundant as we would like it to be in the prosecution. Prosecutors typically fill out pro forma charge sheets, and the evidence is collected by the police, or the affidavits are drawn by police officers. Prosecutors review the docket, and, as they become more senior, they will write a charge sheet or an indictment with a summary of substantial facts. But writing skills are not weren't abundant in the NPA. And I guess, again, I'm going to be pilloried for not saying that there are people who have very good skills. I'm not saying everybody doesn't have the skills, but I think sufficient numbers to make us worry and develop a plan to address it is what I mean. I litigated, but I didn't run trials. I would be involved in the odd inquiry, confiscation inquiry, where you lead evidence, but to establish the value of benefits derived from criminal activity. But I did not run trials because I didn't feel like I had any training or any experience, and I didn't. I first developed that experience when I went to the bar and did pupillage, where I spent a year getting a really excellent grounding in criminal procedure, civil procedure, and just high court practice, trial work, and then obviously wrote the bar exams at the end. The mentorship at the bar, I think, was really critical in helping me. So when I was in private practice, I ran trials. Again, not as many as I would have liked, because I think opportunities weren't that many. Trials are really intensive work and take long periods of time to progress, but I certainly had a trial experience then.
Okay, let's move to the next area. I think it's only at the AFU that you've given us the number of people that belonged to where you worked. But here, you were responsible for the Western Cape.
Yes.
And then you are giving us that the initial staff have grown. This is 200 nationally.
Nationally,
Not
yes.
in where
No,
you were.
no, no.
So we're looking at yourself when you supervised. How many people you had since in that area as head of FIU?
Yes. So asset forfeiture is always only a very small component.
team.
We would have police officers from SAP seconded, co-located, and so we would have joint strategy and management meetings. But I don't think I ever supervised more than 20 people, I would say.
In ID, staff complement, you were establishing it and all
Yes.
that. By the time you left, how many staff?
By the time I left, there were certainly more people than I could identify even. I thought I did provide a number for the ID staff. It's in the responses.
Yeah, I looked
because
for it in the questionnaire, I couldn't find.
it's not in the questionnaire, it's in the responses.
Or in the responses of the...
Yes, because I was asked, I was said I didn't do anything while I was on the ID and I had to respond. And I took from a document that the NDPP had presented to Parliament. Thank you very much. Yeah. So, yeah. The ID was now, after 2.5 years, over 120 staff members.
Over 120 staff,
Yes.
okay. Is that the highest staff complement that you've managed in your career? Because others, it's consulting work.
Yes.
Okay.
Yes.
Okay, that's good. And then your management style?
My management style. So, in my career in the NPA, I've actually occupied sort of leadership management positions. I was on the AFU national management team, and we met monthly. And I was also involved in many management initiatives for the broader NPA. And from time to time, we would be sent on these management training things where you get psychoanalyzed and your management style gets pinpointed. And typically, I am described as the person who will get the job done. There may be some bodies in the wake in the process of achieving the objective, but I'm the kind of person, when the chips are down, I'm over-focused on the outcome. And yes, there may be some casualties in the process.
Let's go. I hear you avoiding to use the words. Am I correct? Is it an issue that you are being said that you focus on getting the work and leave others behind? Or is it the fact that are you able to bring, because NDPP position, it's leadership, and you have DNDPPs, you have DPPs, so it's an EXCO and an extended EXCO that you have to be bringing along. So I'm trying to understand in that context that you are saying, are you not going to leave them behind?
So I certainly, the people I have led, I don't know people who complain that I've left them behind. These kind of assessments is when the chips are down, what kind of person are you? And I want to give just one example and then I'll move on. I had an employee in the asset forfeiture unit in Cape Town who was in an abusive relationship and a husband, who at the time happened to be a magistrate, was allegedly beating her up. And she came to work and we were trying to figure out how to support her. And I said to her, the organization has infrastructure and support. But I also said to her, I can't help you with your personal problem. I can direct you to services that the organization has. And also, here, we have a job to do, and we have to deliver. And I have staff members here who have all sorts of other challenges. I have someone who has a wife who has cancer. I have someone who has difficulty managing their children. When they show up here, I expect them to deliver the mandate that we've all undertaken to deliver on, and to do the work as best we can. So I can assure you that in this space, you are protected, you are supported, and you can thrive. But there's very little I can do to impact on your personal situation. Safe to say, you need to keep the boundaries clear and then to draw on the support. Now, at the time, she wasn't very impressed with me, but I think we're still friends today. So I'm that kind of person. I'll be open, honest, and frank with you. You'll never not know where you stand. But I do want to say something.
Okay, maybe let's get to decision-making process.
Yes, that's
I
is
think
important.
that will help us understand your management.
Yes. So I am the kind of manager who likes to get to the bottom of the problem, that I want to understand it properly, and I want to get as many and as diverse a set of views. But we will agree, and then we'll hold ourselves accountable to what we've agreed. So my challenge with management in the NPA is, as the national director, I'm not sure No. But I do recall that shortly after I left the NPA in 2022, I worked at Open Secrets. And two complaints were leveled at me, one by Paul O'Sullivan and one by the NDPP itself. And the allegations
The current NDPP?
Yes.
Okay.
The allegations were that I was using information that I had at my disposal when I was investigating director, and unlawfully sharing that information with researchers at Open Secrets, which was responsible for reports that they had produced on state capture issues. Paul O'Sullivan wrote to the board of Open Secrets saying that what I was doing was criminal and he was going to lay criminal charges. The NDPP wrote to the board saying that they were concerned that this was the case. I wrote to the board. I came very close to litigating. The accountability work that was coming out of Open Secrets, and so this was just an intimidation tactic. It didn't go any further. I did get called by journalists saying, are you breaking the law or something? And I explained, but the board, I think, wrote back to both parties and said they didn't see that there was any merit. But if they felt there was a crime being committed, they should certainly report it to the authorities. I don't know that a case was ever opened.
Okay. So that's where it ended,
That's where it
from
ended.
your knowledge, and never reported even to LPC or anyone as a practicing
Nope.
lawyer. Okay.
Nope.
No, thanks.
I'm in good standing with the LPC.
Okay. And then moving into the financial and property, in terms of directorship and interest in business, you've got a 15% interest in property?
Yes,
Explain.
with my husband and his sisters, we jointly own a property.
You own a property, or you own a property company?
No, we own a property in those shares. 15% each own a share in the property. So it's not a company. It's just we are all just co-owners of a property.
Is it a business property?
No. It gets let out from time to time.
Oh, so it's got income for...
Yes.
So it's like when you have a house and then
And you rent it out, yes.
Okay.
That's
It's
how
not
it
like
is.
you're running a formal business.
No.
Okay.
It's like an
Because I wasn't
Airbnb
sure
type
if I
thing.
understand it.
Airbnb type.
Oh,
Yeah,
okay,
yeah.
okay. That's fine. And then I think, and then you've disclosed your health condition, but which has never impacted on your work, and we don't see it as impacting on your work. So I don't think that's an issue for us. Okay. Now I think that concludes our questionnaire, which took long because it was very detailed, which I'm not complaining because it's helpful as well. Just moving on, and as I said earlier on, I parked you, but I want you to give us, with what you know of NPA, having been in, having been out, not fully out because I can hear, still quite do a lot of research, analysis of the work that is being done by NPA. What would be those things that you do should you be appointed? The vision of NPA, and how would you help to solve some of the issues that you have identified?
I wanted to ask that I just talk a little bit about what I've been doing since I left the NPA, because it'll feed into what I think should happen and what I would want to implement. So last year, I spent 6 months working with the National Anti-Corruption Bureau in Ukraine. I traveled to Kyiv 2 times, and what the job was to review the effectiveness of the National Anti-Corruption Bureau in Ukraine. Ukraine has very similar corruption challenges to South Africa. While they have a war going on, we have sort of low-grade murders and other problems that are actually very comparable. And, I found the experience incredibly valuable because, I could sort of digest the 3 years of experience I had working in the NPA, trying to set up an anti-corruption capability in the NPA with one that had been going now for about 8 years in Ukraine. And I was sitting with 2 other international experts reviewing the effectiveness, looking at what data should they have and should they be able to present to demonstrate their effectiveness, looking at their decision-making, looking at the impact. So I think that was a really important piece of work from which I learned a lot. The next, and actually let me just say that I think the thing that struck me the most from that work and the work with NACAC is that I've always been in law enforcement, and I probably was a snob when it comes to prevention issues, corruption prevention. I saw it as fluffy, publicity, kind of talking to people about why corruption is bad. I think what I learned from Ukraine is that unless you use prevention measures effectively, you end up with systemic corruption. So the 3 areas where I think South Africa could learn a lot from a country like Ukraine is in financial disclosure forms. Now, every government department and every public servant at a certain level can tell you that we fill in these forms, and we're very proud to announce every year that we have 100% compliance with filling in the form. And then what happens? Who's looking at that form? Who is making sure that disclosures that haven't been made but should have been made are being investigated? Or who is assessing whether there's a wealth commensurate with the income that the person is disclosing? We do not have an effective system for managing disclosures, and we can eliminate a lot of public servant excess by using tools, computer tools. So in Ukraine, they have a very effective system of taking those forms. Firstly, they have a very effective form. Ours could use an upgrade. They take the data and measure it against other databases like the property, immovable property trust, all these systems that you can just assess. Does this person own a property that they didn't disclose? And have red flags. And then we need people to follow up and actually, assess consequences that should happen. So, our system is a little archaic. The same goes for our conflict of interest system. We have in the law, we all, although it's debatable whether we're all on the same page. Excuse me? It's not within.
I want you to tell me, what would you do for something?
Yes, okay. Yes.
This one of
Prevention.
disclosures and everything we can deal with. I think public service, it's good to have that advice, but I'm looking for
Yes,
the NDPP.
but I will
and the
just
NPA
say
for the future.
that NACAC proposed that we have to set up structures to deal with systemic corruption. I think we need to focus on getting the basics right, and doing. But I hear you. I have views on the role of the SIU and really giving it teeth to do prevention, but that's for another soapbox, right? So coming to the NPA, the skills catastrophe remains my enduring concern. And it's a concern about how we appoint prosecutors and how we become qualified as prosecutors. So prosecutors have always been, as a law student, you first look for a job in the private sector or somewhere else, and if all those doors are closed, then you think about applying to the prosecution. Again, not everybody does that because there are a lot of prosecutors who come out of the womb passionate about being a prosecutor. I'm not talking about those people. I'm talking about the average law student. when they want to get employed, they know that they're going to, if they get a private sector job, they have a much better prospect of a successful trajectory in their career. In the prosecution, what the Legal Practice Act sought to do was to create some uniformity across the profession. What your predecessor was encouraged to do by your pre-predecessor was encouraged to do by the NPA was to drop the standard for prosecutors in terms of just qualification. So while all other legal professionals must have a 4-year LLB, in the prosecution, a 3-year qualification suffices, right? So that kind of, most prosecutors have an LLB. Probably 95% have an LLB. But it creates this dual system now where the standard for the one is lower. But that's not where it ends, right? In private practice, whether you're an attorney or an advocate, you need a period of mentorship, right? And most prosecutors will tell you that you become a prosecutor in the trenches. You learn while doing. But we must make sure that you're learning from people who are doing the right thing and who really know what they're doing, right? So in the private sector, for attorneys and advocates, those who have mentoring responsibilities must themselves meet certain criteria. There are none in the NPA. In the private sector, you have to have undergo a curriculum. As an attorney, it will take you 1 year or 2 years. As an advocate, it will take you 1 year of pupillage. That program has to be accredited by the LPC. We have the aspirant prosecutor program. It's not accredited. Why can we not have it accredited? Why can we not make sure that it is delivered at a standard that satisfies the LPC? I mean, obviously, there needs to be significant input from the prosecution because prosecuting is not the same as litigating in other areas. But the whole idea with the LPC was to create greater parity. The third area is, so accredited, a proper period of mentorship, and then an exam at the end, right, that you have to pass. And it's an independent exam.
So the current exam process is not?
The aspirant prosecutor program, even itself, is a shadow of its former self. But I think what my experience is traveling around the world and looking at prosecution authorities and what makes them successful, you will never pay enough money to attract good lawyers in the private sector to the prosecution. It's never going to be about the money. There's that small percentage of people who from the womb want to become prosecutors. You've got them, don't worry about them. But then there's a large proportion of people who are casting around to try and figure out where will they be fulfilled, where can they apply their skills. What the successful prosecuting authorities do is the training they offer is top class, right? In the US, for example, the Ivy League schools, they first want to go to the prosecution. Then they want to go to be a clerk for a judge. Then they want to go into private practice. And the reason for that is it's known you will get the best training in litigation anywhere because the state litigates. If you're in a law firm or in private practice, you have to wait for the client to walk in with the right case. So there's a supply of work. And then excellent training. And that's what we have to do. We have to provide excellent training to attract people. I think we, thanks to Pulelani and a few others, the salary level at entry level is quite attractive, because you can get exploited in the private sector early on in your career. If you survive and you carry on in your career in the private sector, you can earn way more money than you'll ever earn in the prosecution. But we sleep better at night and we have other perks. So it is a lost opportunity to make sure that prosecutors are offered the best training. It's not a hard thing to do. It's not an expensive thing to do. And it just is something that will be in the interest of everybody. It's a systemic solution that ensures that you have these people who have to come up against people who have had this kind of training, are able to compete. And if you ever wanted to visit a country that has done this very effectively, I commend Zambia to you, because Zambia has required all prosecutors to go through the same professionalization process as private lawyers. And the caliber of people and Zambia has just they prosecute former presidents, first ladies get their asset seized routinely. So I think it does make a difference. And I think, for me, this is something I wrote many memos about when I was in the NPA. I read the NPA annual report every year to see where are we, because we have a crisis coming, because in 2018, advocates, before 2018, people like me could get right of appearance. If you, with just an LLB, you could become a legal practitioner. You can't do that anymore. So people in the NPA are stuck, right? I can show you many ways in which this impacts. Recruitment. We struggle to recruit. The attrition rates are low, but when we do appoint, it's internal, right? So we don't attract people from outside. Why is that? It's because when we advertise for a junior state advocate post and we say we want 3 to 5 years experience, right? We treat 3 to 5 experience in the district court the same as 3 to 5 years experience as an advocate at the bar. And I'm not saying they're not comparable at all, but I don't think they're comparable one for one. To get senior state advocates, we have junior members of the bar on display at the commissions, right? And
I've got members who would want to do a follow-up.
Yes.
As you wrap up
So,
on that part, yeah.
My point is, unless we create that parity, there are a lot of advocates who won't be able to go and practice outside of the NPA because they would have to do pupillage or attorneys' mentorship. And I suspect when that day comes, when this cohort of junior advocates in the NPA need right of appearance in the High Court, we'll make another special arrangement for the prosecution. Whereas this is not a popular, I've raised this issue with many prosecutors, and they will bite your head off if you discuss this issue, because there are lots of defenses, right? But I think it's an issue that must be tackled head on.
Mr. Mtlo.
Thank you, Minister. Advocate Kronje, I just want us to zoom in to your classification of this skills challenge. You classify it as skills catastrophe. Now, when you are at a catastrophic level, this becomes the worst level that you can think of. So the worst level would then mean that there is the controls or any interventions are non-existent. They're not there at all. It's skills catastrophe. Now, I would want you to think of it that are you not exaggerating the challenge by classifying it at that lowest level? And I'm saying this against the backdrop of what you've actually said in terms of those interventions that are there, such as aspirant prosecutors program. If it is there, it is a form of ensuring preparedness of new entrants into the space. So perhaps it could be an issue of revising that program to put in place other measures to put it at a level that is desired.
As I said.
That's one leg to it. And exaggerating classification of this challenge, don't you think it also sort of diagnosed the problem without having examined the challenge? I'm saying this against the backdrop of also that what does not come from you is that there are so many prosecutors, and we have identified as part of the skills deficit certain areas that they lack in, and as a result, there could be a need to come with an intervention, a training intervention. And this may come across as casting aspersions on even those who are capable and looking at it, and this may also go and have some unintended consequences of eroding public trust and confidence in the current crop of public prosecutors. And you gauge it against and this is what the outcome-based approach would talk to, that you gauge it against the percentage of conviction rate, for instance, with regards to matters that are being prosecuted. Are we at a level where the rate is so appalling and so low that it really justify your classification of skills catastrophe? I would like you to rethink of it, rethink this position, and tell me if it does not necessarily exaggerate the challenge that you are raising on skills issues within the NPA.
I take the point. I said I'm prone to exaggeration. I did start by describing it as, certainly in my career, I started off as saying, this is something we need to address right from the get-go. When I look at the training in the private sector compared to the training in the prosecution. When I started at the NPA in 2019 as the ID, I went looking for skills. I went looking for people who can do these serious, complex cases. I really battled to find people, and maybe, there are a lot of competent prosecutors who didn't want to do this kind of anti-corruption work. It's very career limiting. It's a lot of trouble. You can take a nice, safe job somewhere else. You don't have to do it. So maybe, people, I had to look for volunteers. I had to beg people to come and do these state capture cases, and there weren't many takers, right? Which is why I then asked if we could do an audit of where these skills are in the NPA so that, we can then approach those people and target them and encourage them and entice them to come and work in the NPA. But I really feel you shouldn't have to take my word for it, whether it's a crisis or a catastrophe or just a problem, right? You need the NPA to communicate that. I quoted in my responses some of the statistics, and I'm so glad you raised the conviction rate issue. It has been debunked year in, year out as an adequate measure of how the NPA is performing. Our enrollment rates compared to our conviction rates, what are they? I bet not even the minister can tell me, because it's not being reported on. Because if it were to be reported on, you would be agreeing with me. Maybe we have a catastrophe on our hands. People have made the public is frustrated with state capture prosecutions. They will continue to be frustrated with state capture prosecutions because I am not convinced that we have the skills. There are a lot of other issues. It's not just skills, but the skills to put together the kind of charge sheets, the kind of indictments that are needed, I don't know that we have in the NPA. And unless we confront that, I worked with colleagues in the US on the ABB prosecution and the McKinsey prosecution. We were working alongside one another. And it became very clear to me very quickly, we will just never be able to mount a prosecution of McKinsey in the way that the US DOJ was mounting a prosecution of McKinsey. So, okay, that's setting the bar very high. But, if we don't confront it, and I think the reason why I'm prone to exaggerating, because people are not taking the issue seriously. It's eminently solvable. You can address it, but you have to confront it. I do think that our performance has plummeted. And I mean, I can refer you to statistics. The NPA does not publish these statistics. It used to publish. In 2005 and 2006, we used to tell you how many cases we enrolled in a year, and then you get a sense of how many of those. So enrollment is where we say, as the NPA, there's a prosecutable case here, right? Of those, roughly half will get to a point where there's a verdict, not a guilty verdict or not just a verdict, right? A discharge or guilty or not guilty. Now, it's very easy to get a 98% conviction rate because, firstly, you incentivize prosecutors not to take risky cases. Don't take difficult cases. They'll keep sending the police back saying, but wasn't there like maybe a video? Isn't there DNA evidence? Isn't there something, the case will drag on forever until it's like, I take that case and they'll probably plead guilty on the spot, right? So we are not incentivizing prosecutors to take difficult cases to court because we're chasing a 96, 94, 98% conviction rate. It's unhealthy to have conviction rates like that. I don't know what you're prosecuting if you have those levels of success. But I think we need to relook at the statistics that we generate and to show performance. A study was done on SECUs. The absolute plummeting of performance, of productivity. In 2019, SECU prosecutors were prosecuting 6 cases a month on average. They're down to less than 1. We have more prosecutors now. We also have more crime now, but we are putting through fewer cases. That doesn't even start us on the delay problem, right? The Stalingrad problem that is described as this mysterious phenomenon that we are just at a loss for what to do about. If we are not going to prepare to interrogate the problems in the NPA and brutally look at what's working and what's not working and fix what's not working, then we are forever going to be disappointed. So I hear you, I should temper my language and not call it a catastrophe. I'm trying to get attention to the issue. But it probably isn't a catastrophe because it's fixable. I believe it's eminently fixable. I'm just frustrated that we don't take the steps to fix it.
Okay. Just a follow-up, Minister. Please, in no way do I even suggest that you should temper your language. But I'm saying against what is known and against what I have submitted to you, there is element of exaggeration. And if then there is element of exaggeration and the basis of this exaggeration is so that we are becoming alarmists. We want to draw attention, perhaps, and you want to draw attention because no one seems to be listening. And I'm looking at it from an angle that then says that this would become, it's actually a false alarm that is raised because of mischaracterization of the challenge. We don't have to exaggerate the challenge to grab the attention. That's
Fair comment.
Yes.
Fair comment. But the only issue I take is, you can ask, why am I back here if I think it's so disastrous, right? I do think that we are at the point in the country now where it's undeniable that we have serious problems in the NPA, and that we need to actually come up with a diagnosis. What is the diagnosis? Why? And I dispute the narrative that it's only in complex corruption cases that we're not doing so well. I utterly dispute that. And I think that if we looked at the data that is coming out of the courts, it's a problem across the board. When the Constitutional Court took away that lifeline that the prosecution used, which is to prosecute people for possession of dagga, our performance plummeted. We're still trying to recover. So tell me, I'm very glad to hear that there's a 96% conviction rate, but what are you convicting and what impact is it having on the society? So I am prone to exaggeration, and I really must take your criticism and your advice to heart, because I do think that is how people are alienated. But I feel frustrated. I feel like the boy crying wolf or something. I don't know. But I feel frustrated that we are not addressing the real issues.
Thank you.
Thank you.
Thanks, Minister. Thanks, Advocate. Oh, yeah. Thanks, Advocate Cronje. I hear you, and may I even add and say I feel you. But I'm just worried about your analysis. I know it's not a diagnosis, because a diagnosis you will be able to do effectively when you're inside. But your analysis from outside is very problematic for me. For example, if you say, young people from university see better prospects of success when they go to the private sector, it is a myth. Those young people, it depends on which university they come from. It depends on a whole lot of things, including their personal background. And those that make it to the Big Five sometimes end up after 7 years of never having set foot in the court, but having spent a lot of time on the photocopying machine, photocopying for their counterparts, being on antidepressants. So I'm worried about this rosy picture that we want to give on the one side, but I'm also worried about the total gloom and doom that we want to give on the outside. You know why I'm worried about the total gloom and doom? Our constitutional dispensation demands of us that we provide administrative justice, that we provide a responsive public service. And a responsive public service, therefore, needs us to have a mindset to know that there are different levels of people on this race. Some have been left behind, and therefore, the paces are different. It demands of us that we be aware of the different levels of need and how we can meet them. A simple advice center has a place in our society, and that advice center, we cannot then, present things. And I know you did not say that, but the interpretation and the dragging of your thinking could be, what then about advice centers? What then about sexual offenses, for example, that you are going to be dealing with, where at face value and through its manifestation, it has got nothing to do with corruption. But the tail end of whether somebody gets convicted or not has got everything to do with corruption. In fact, why women are more vulnerable, it could even be to a large extent because of corruption. So it worries me that we're looking at this conservative Lani definition of corruption. And I'm not saying that, I'm saying I understood it that way. That is why we say people at private sector have got a better prospect. No, the students who leave university after 7 years, they're depressed because those very private sectors have told them you do not fit. Or if you fit, you're going to fit in our terms. The people at the bar who leave and are in serious debt. You know, so I just wanted to say, please, if you could give that sensitivity to this. It's not all black and white. It's different layers and shades of gray. Thanks.
I accept.
You want to comment on that, or should I move to the next?
I will comment as I go. I take it as advice.
Thank you very much, Advocate Cronje. You were there at the beginning. You were there at the establishment of the institution of the NPA and its specialized agencies. At some point, you encountered all the challenges that you alluded to, and you quitted. Now you're coming back to an NPA which is facing even a bigger mountain with prospects that, given the number of cases that might be coming in future, you may be facing even more frustrations. Do you have the guts, the gumption, the stamina to take the punishment of the position? Because at some point you said, I tend to be impulsive at times. Will you?
Stay the distance.
Yeah.
I was asked when I came back the last time, in 2019, as I said, by someone who wanted to know, is it even doable, right? Because it was a journalist who had been reporting on the NPA for years and said, it's looking quite grim, right? And I said, well, I'm the kind of person who believes that it's an important institution. You know, I've been passionate about this institution. I've been away from this institution, but you can ask the people in the institution. The 7 years I was outside, I knew more about what was going on in the NPA than most people in the NPA. I've watched every parliamentary hearing that the NPA has been at. So when I left the NPA, it's not because I don't have stamina. It's because I am realistic about what can be achieved. I asked myself, where am I going with this? I was pretty clear that if I remained in the NPA, I would probably be arrested on charges for irregular expenditure or something like that, or doing something that, because I was frustrated. So I've never left the NPA to abandon the NPA. I've left the NPA and I've gone elsewhere. And I've continued to work on the NPA. So what I didn't get a chance to talk about is the work I've done with the World Bank on the NPA, the work I've done with STAR, the Stolen Asset Recovery Initiative, in trying to help the NPA recover the funds abroad. Most times the NPA don't want to work with me, but if the gap closes, the last year I spent working with magistrates and judges on why we have the kind of delays we see in criminal prosecutions, really trying to understand what is behind this problem and what are the issues what are the things we can do to address them. I've just finished writing a report on our recommendations that we have sent to the minister. And in January, we're going to have a workshop with the judiciary on what can be done to address the crisis. Is it a catastrophe? It's certainly a crisis. We have a crisis when it comes to postponements and delays. I believe that. But I don't describe these things in a way that I want people to be demoralized. So I'm worried that both of you have perceived me to be hopeless about this. I'm not hopeless. I believe that we have solutions to these things, but we're never going to implement them if we don't confront the reality. If we're going to pretend that it's all hunky-dory and, we can just keep carrying on like we are, we are not going to address it. And there's so much potential in the NPA. There are many good people in the NPA. Many of them have sent me messages saying, hopefully this is going to work out. There are also many people in the NPA who will do everything to make sure I don't get appointed. So it is.
Maybe just to come in, you said that NPA does not want to work with you. Is it individual, because I worry about
yes,
that.
Yes.
Is that individuals in the NPA, and what happens when you're appointed as the NDPP? Would you go back and say, you didn't want to work with me, therefore you're going? Or there'll be chaos, catastrophe.
Yes.
Just explain that so that we all don't take it in a context that you don't mean. So be specific about it so that we are clear from that word. Sorry, Prof, to come in because I just picked up that word and it worried me.
I think that's very fair. When I left the NPA, I didn't really have an opportunity to explain why I was leaving. A press conference was held and things were said. I'm very outspoken and I did wish I had an opportunity, but I also felt that I was so emotional at the time. I was so intensely raw that I was concerned about what I would say. Like many people are worried when I speak. What is she going to say next? So I thought, I needed time to reflect. I needed time to think about what happened in that experience because I did struggle with the management team. I really, not on personal issues, because some of my best friends were in the management team. Advocate Omar Abaji Rasitaba was my boss for many years, and I had a lot to do with her coming back to the NPA. So I have lots of people, I have very close working relationships. And I continued working with the AFU when other units in the NPA were not very willing to work with me. So nobody said they won't work, but I think people assumed, and certainly the media were reporting this blow-up between me and the NDPP, that if you want to advance in the NPA, maybe that one is a problem and stay away from her. But it hasn't actually impacted on me doing the work that I've wanted to do with the NPA. So I've done the work with NACAC, but it needed time. It needed time for me to...
NACAC is not NPA.
Yes.
NACAC is an advisory body of the president.
Yes.
That mainly would work even at the executive level with us. That's why the report will be with me, not with the NPA.
Yes.
So they would have consulted. So that can constitute, but I get your point. That what you are trying to communicate, at least I'm comfortable.
I mean, the NPA is also very hierarchical, and people, like to not upset the hierarchy. And there was a perception that maybe working with me would upset the hierarchy. I certainly...
Upset the NDPP, that's what you mean, because it's
Probably,
perceived.
yes,
that
it's perceived,
you had,
yes,
but
yes.
Like you said, the media reported
Yes,
that.
and I was
you
told
had-
by colleagues in UNODC that on asset forfeiture, they would have loved to work with me, but they don't want to create the impression that they're choosing my side over another side. So I think, it certainly was an issue, but I've been working.
This went as far as the UNDOC.
I do a lot of work with UNODC. So I do a lot of work around the country with UNODC, yes. But I have worked with the NPA on asset recovery issues. I'm supporting them in Doha next week again. So
I'm leading that delegation this
I'm
week.
aware.
Okay.
Thank you.
I took over from Prof.
Yes.
That part clarified.
But
Yes,
thank you very much, Chairperson. My next question, you did allude to the issue of the state capture, which directly impacted on the NPA. Can you walk us through that and indicate what impact it had and indicate the before and after? And you can also conclude by saying, does it still have the elements of that capture, or you just have an organization which have different kinds of leadership problems today?
So there are now new allegations of capture in the latest commissions. I think that an organization like the NPA will never be free of attempts at capture and allegations of capture. I remember working in asset forfeiture. Every case you did, you would be told, but why us? It's selectively targeting us when there's so many other people doing the same kind of thing. Why don't you target them? All you can say is, give us the evidence and we'll get around to it, but right now we're dealing with you. But especially corruption, anti-corruption authorities are going to be targeted because the NPA has the capacity and the ability to put people behind bars, right, and really upend their lives. So if you're being investigated, the higher up in the ranks you are, the more power you have to disrupt them, the more likely you're going to use that power. So again, we are not unique. This is a problem prosecuting authorities and anti-corruption authorities around the world face, right? That's why UNCAC has standards around issues like how to ensure integrity of staff, right? How to ensure that prosecutors act with professionalism, take decisions independently. For me, these are systemic issues that you have to get right. Because if you don't, you make the organization much more vulnerable to those inevitable attempts, whether it's the private sector, whether it's gangsters, whether it's organized crime, whether it's senior politicians. They all will target the NPA to undermine it so that it doesn't successfully work against them. So again here, there are examples of corrupt prosecutors. I uncovered a corrupt prosecutor that I had worked with for many years. And I was appalled to discover that this is actually far more routine now. In fact, a survey was held when I was still there among prosecutors about how many prosecutors had been offered bribes. It was a staggering 60-odd%. Offered bribes to make a case go away. Many of them, of course, said, we wouldn't take it. We wouldn't dream of taking it. The problem is, it's a crime. To be offered a bribe, a crime which you need to report. So the next question was, did you report it to your supervisor? And the numbers plummeted because most people didn't think that's something you want to, get yourself embroiled with. And then, did you report it to the police? even fewer people, right? Because that's the serious issue that must be addressed, right? So it's not saying that more prosecutors are taking bribes. It's saying there are more attempts to bribe prosecutors than we've been aware of in the past, and we need to take serious steps to ensure and secure the integrity of prosecutors. So we have to be bold. Yeah, again, another one of my disruptive suggestions. You have to have regular integrity testing of prosecutors, not because prosecutors are more likely to be corrupt than people who are not, because they are in an institution where chances are high that they will be subjected to that.
Would that include lifestyle audit
Absolutely.
as a compulsory element?
Absolutely. But, I don't know exactly what people mean when they say lifestyle audit. What I mean is that when prosecutors do a financial disclosure and they disclose all their interests, right, and there are red flags that emerge, either they have way more money than a prosecutor's salary can justify, there needs to be a basic investigation. And if there are credible answers, that's fine. The minister is talking about unexplained wealth orders that we can apply in situations where the disclosure and the tax declarations and the actual de facto income don't match up. Maybe we should have a 50. We need consequences all over the place, right? And we need strategies all over the place to keep ourselves honest. And it's not a reflection on the people who work there. It's a reflection on how easy it is to target that institution.
Thank you. I think the lifestyle must mean where we go into the accounts, not voluntarily. We go and assess their lifestyle, their assets, their families, because other assets are hidden under other people's names. That's what we must do. That's what I've called for in the NPA. Mfundisi.
Thank you, Mr. Minister. Good afternoon, advocates.
Apologies, I had said that she's next. Okay. I jumped. I think we take. Yeah, she wanted to come in on the same. My apologies, Mfundisi.
Okay, no, thank you, Chair. Advocate Kronje, I really feel you on some of the things you're raising. So you talk about, as part of your vision, the need to focus on performance in terms of planning, monitoring, reporting, and accountability systems. You talk about the risks around ethical conduct and integrity systems. You talk passionately, and I think rightly so, about the skills issues. I hear the hyperbole in your voice, but I think I associate it with passion and hunger for movement, right? You're looking to come back to an institution that you left because you were frustrated by a sense that there was a tendency for people to bury their heads in the sand. I think that those were your words. You narrate a story about significant pushback, because it's easy for people to focus on a fight between two people, but actually it sounds like there was a system that you were struggling with. You reflect on what you observe when the NPA goes to report through the normal accountability processes into Parliament and etc. A sense that the attention to these very things that you remain concerned about is not quite there. We say that the tendency to bury heads in the sand continues. So the very thing that frustrated you is still there. What's your sense about how you would deal with it this time around?
So as I said, what I found most difficult in the NPA the last time round is this sense in the NPA that we are actually fine. It's people out there who don't understand, right? They don't understand how things work and how it's not our fault and how it's many other challenges in the system. And not all, many of those are real. I'm not diminishing them. There are real issues that affect the performance of the NPA. But I don't think that it's possible any longer for people in the NPA, and I ran into some at the hotel last night saying to me that, I said what frustrated me back in the day is that people would not acknowledge the reality. And they were saying, no, I don't know what NPA you're talking about, because people now realize. Every day they read the newspapers, they get confronted at braais, they live in this country, and there's no hiding from the fact that there are challenges with the NPA's performance. But the NPA is also very hierarchical, and the tone is set at the top. So I'm here for this job, because I think with this job, you can change the culture, you can change the tone, not alone, right? So the thing I learn every time I leave is I need to build more allies, and I need to, get more of a groundswell of people to support the agenda that I feel so passionately about. I do think it's going to be a challenge when you can't fire anybody, you can't. Your hands are so tied at the leadership level to disincentivize people who are not willing to make the changes that are needed. So, I heard that the minister asks about management experience, and I think that it's collective management experience that's needed and collective action to address the management. So it's the minister, the president, and the NDPP that need to take a long, hard look at how the system works and how we can bring in fresh blood. As far as I know, no deputies left in the NPA. So it's the NDPP who will go, and the DNDPPs. There aren't any of the 4 DNDPPs will be there next year. So says my intel in the NPA. I see the minister is declining to nod her head. But so there is going to be a round of...
You are indirectly asking me.
As I said, I have good intel in the institution, and so all 4 positions are up for grabs. Firstly, I think those 4 positions need to be re-engineered, because I don't think they speak to the functions of the NDPP in the NPA Act. And so I would certainly refocus the role that the head office plays in providing support to the DPPs. You can't find out after the fact in an Omotoso trial that the prosecutor declined to prosecute. They sat down for 9 days for cross-examination. It was finished in 2 hours. We only discovered that at the acquittal stages, there should have been who was monitoring, who was managing, who was overseeing. And I think that's pretty systemic as well. These are examples of problems, but they're pretty systemic problems. The NDPP primary function is policy. It's setting policy and setting directives. I also look at the NPA Act, the annual report for what policy changes have there been. The world has changed dramatically since 2013, when I think we last changed our prosecution policy. Prosecutors need a lot more guidance and support. If you go online and you check the prosecution policy for the UK, Australia, the US, all these common law countries, you see guidance to prosecutors, extensive guidance, so that it's much easier when a prosecutor then deviates, either for a bribe or for just not being competent, to say there's been a deviation here. Why wasn't it picked up? So that role then, needs to be reinforced. The role of seeing that policy is being complied with. I heard the NDPP being grilled about, in either ad hoc committee or something else, about how do you find out about problematic prosecutions? And it's an interesting question, because there aren't systems in the national office. At some point in the NPA, there was actually a little bit of an inspectorate at head office that went around and just assessed different offices for compliance with policy, for performance problems, for challenges, so that you can address them before they become a crisis or a catastrophe. You just so you need mechanisms to monitor and manage, but I don't know, there are problems with managing those people. You have to use the instruments that are there, and those are instruments. I think that accountability is also about communicating about decisions you've taken and decisions not to prosecute that you have taken. And I think the NPA needs to become a lot more open about communicating what its strategy is. What is it trying to do in state capture cases? What is it trying to do in gender-based violence cases? The issue that has bedeviled the NPA management since the days of Bulelani Ngcuka is, do we prosecute each and every case that walks through the door, or do we select? Do we determine, articulate criteria that we're going to apply so that we end up having manageable roles, that prosecutors don't sit with hundreds of cases, none of them being prosecuted because they're just too many. So these are not easy decisions, and these are controversial decisions because people can reasonably disagree about approaches. But then you can't avoid having the discussion because you're going to get lots of disagreement and flack. You have to go and put the issues on the table, get the input, and then make a call, put your policy there, get taken to the courts and fought about, but, act.
I'm going to start managing the time now, and I'm sure even the candidate proceed.
Thank you so much, Minister. A lot of things what I want to ask has already been asked, but what is important, when you say that there are some people that are with and some people are against, which then says to me that within the NPA there is two sides and so on, or two camps or whatever we want to call it. But would you, if in the event that you may be selected, in the event that you are selected, how would you change, what kind of change would you bring? Because there are interpersonal skills that are there. Mm-hmm. There are people with human beings who are you have your systems that you can change, you've got your mechanisms and all other things that you can do, but you are going to work with people. And if people are in two camps, or even for trying to implementation will come and bring a stability amongst those that you're working with. And will you, for example, find a process or a way of saying, I'm back here, I'm just hypothetically speaking, I'm back here, let's work together. How do we work together? What can we do? And where can we do in order to make the organization a success? And will that be the order of the day? And thank you so much for your input. Yep. But I'm just worried about getting in there, and there are two camps. How do you bring them together?
Thank you. So this happened when we arrived in the NPA in 2019, that there was lots of talk in the public domain that the NPA had been captured. So the assumption is there's some captured people and some uncaptured people. So how do we proceed? And there too, I think, SARS had the same situation. And I think the example of SARS is instructive, right? What you need at leadership level is to be very clear, as I said, within the limits of being able to hire and fire, which is really problematic. You need to, as a leader, articulate what behavior was acceptable and what behavior was not acceptable. As much detail as you possibly can. I'm all for celebrating the behavior that we want to see amongst prosecutors. And there are prosecutors who exemplify that behavior. And that should be celebrated. And I think that organizations, people very much go with the flow, right? And if you change the flow, people will, by and large, adapt, and And of course, you need hand-holding and change management and all those good things. But I think you need to articulate a clear vision. People appreciate clarity above probably most other things. They want to know where you're going and how do I fit into this? And will there be space for me to give input or disagree with the direction that you're taking us? And that is my style, but I think that if you can't deal with the 20% or so who are not with you, whether they have vested interests for not being with you or whatever the reason is, right? Well, if there are legitimate reasons that they're not with you, you give them space to articulate them and you try and address them. But so I don't think it's a question of, are there two camps? Are there people who are for you or for the NDPP, like the media portrayed it? There are mostly people in the NPA who are there to do the work that the NPA needs them to do. How they do it, they certainly will take their cue from leadership and adjust if the policies and processes and procedures are being shaken up. I am encouraged because now more than ever, there is a moment where people recognize we have got to do things differently. We cannot carry on in the same way. And I think that presents huge opportunity. There will be people who think there is nothing wrong with the way we are operating. And you can engage with those people, but the time must come when maybe you part ways and you write to the minister.
I'm taking the last, you still have, and then we're going to because we've got quite a lot of the segment in the comments that we need to go through. It's substantive issues that we must process. And I'm worried it's really exhausting the candidate to that extent. Proceed.
Does the candidate
I hope you're still fine.
I'm
Please
full.
do indicate if you're not.
You have to stop me, that's the issue.
Thanks,
Okay.
Minister. I think I agree with the candidate. I've noticed that given an opportunity, she can address us for the whole day. And I take no umbrage about that, Advocate Kranja. Thank you so much. Good afternoon. I have many questions since I listened to you. I got more worried than getting somewhere. You say to the country as it watches you today that 2010, 2011, the appointment process in the NPA takes a shape that says we are now taking over the NPA by appointing incapable people whose job is going to be about a narrative, not the NPA. Did I understand you correctly? Mm-hmm. And then those people get appointed, even with your objections. Mm-hmm. And you write every memo that you can probably draft to the head office, and you don't get any positive feedback because then the people who are appointed were from head office anyway. So you were complaining to the people who are appointed in the room. Mm-hmm. And you stayed, you then left in 2012, 2011, 2012 beginning. And then you come back in 2019. Those people that were appointed in 2010, 2011 are still there. They have not resigned, they have not retired, they were not too old to retire, neither were they dismissed or otherwise, right?
Most of them were on incapacity processes, yes.
They were still there in different capacities.
I mean, the ones that I knew about were not in those positions anymore.
Oh, okay.
But I assumed that there were others in other positions. I don't know. Mm.
Oh, okay. So you then rejoined the organization, and what did you do to try and repurpose, at least to the extent of your understanding of the road, if that's what we want to call it? Mm. How did you then try and find a corner where you're going to repurpose your role in the institution?
So the role I was appointed in was to start an organization from scratch. There was no investigating directorate. The Scorpions had been dismantled, but not only had the people in the Scorpions been sent into different, the investigators went to the police and the prosecutors were dispersed, and actually many also left the institution. But the intellectual, the organizational knowledge that had built up in the Scorpions, I kept looking for policies, for approaches that had been adopted, because we were essentially going to do many of the same things. I kept being referred to some office there that has many files, and I'm most welcome to go and dig around in there. But my job, therefore, was to start this capability from scratch, which, was not an easy thing to do in a public service that was already very constrained. I wasn't necessarily, I didn't have the power to appoint people, so I had to go and beg, borrow, and steal people where I could to try and get them to work on something most of them considered career limiting, because they'd seen what happens to people when you try and take on senior political figures. So, I certainly, in the people that I recruited, have very high standards. And so I wanted to bring on board people who I thought had the skills. But I was a beggar, not a chooser. It's not like I was advertising and say, all comers, I'm going to pick. No. Literally, there were no volunteers to take on state capture cases. I had to go and entice people and beg them to come and do the work. So, I certainly had views on what should be happening in the rest of the NPA, but quite strictly, I had a lane, and I did have tendencies to stray out of my lane, which is why there was perceptions that there may have been head clashing, because I'm outspoken, I say what I think, and as you can see, it doesn't always go down well. So I certainly tried to, at management meetings, give input, talk about skills audit, talk about fixing the situation with the LPC, talk about how we can build this capability, how do we have integrity systems, but none of that was my job. My job was get convictions in state capture cases.
Can I just check with you? You spoke very well about or at length rather, about the training for the NPA or for the prosecutors, as they are called. Mm-hmm. Have you ever taken the time to go through their current training manuals?
Absolutely.
Do you agree with them?
There's a syllabus for the aspirant prosecutor program. I found it on the internet, and I went through it. It needs a lot of work. I'm not sure that the LPC would certify it. I'd love to hear if the LPC would accredit that syllabus. But I really think we should try, right, to get the LPC to comment on what it thinks about the syllabus for aspirant prosecutors.
The reason I'm asking you that angle is because I find it a little worrying that you were in the system. We have seen you are a very senior person that comes out of that system, having been part of the first people who worked in the NPA, and then we're sitting with a program that produces people who must work in that system, and we are still talking about it 25 years later or so, and we are not saying this is how we have actually tried to influence the trajectory in order for us to improve our service offering in that space, because prosecutorial actions are about service offering to our people all over the country. how best the rule of law is actually then upheld by everyone. So I get very worried when the conversation starts there. I do sit in the LSSA, we talk about the training for lawyers and all that every other time. We may not have talked about the prosecution line, but I can give you guarantee that we discuss these things because we understand the quality we want to produce for the members of the public to have confidence in the legal system. Lastly, Minister, and I wanted to understand this from you, is it your view that even with hindsight, now that you left in 2022, is it still your view, or is it your view rather, now with hindsight, that that NPA that you left in 2011 still exists as perceptibly captured as you would have thought it could have been getting captured when people who were not capable were being appointed and so forth? Is it still your view?
So on the first question of what had I done within the NPA, so when I arrived in 2018, 2019, the Legal Practice Act debates were raging around in the country, and I was listening with interest the role of the NPA in that dispensation, because I thought that was the opportunity. I thought this was government's policy, that it was going to create this sort of uniformity of legal practitioners throughout and have clarity about whether prosecutors could move in and out of other parts of the legal profession. I wrote memos, I'm a prolific memo writer, about the importance of the NPA having a seat at the LPC table to advance its interest in getting quality training. And my colleagues were attending those meetings. It was not my area of responsibility, so I could give my views and I could give my input from the perspective of my experiences in trying to recruit people to do serious corruption cases. But ultimately, it was the leadership of the NPA that was deciding how to address those issues. So could I have done more? My focus was on trying to get corruption cases through the courts. And I kept being told that I must stay in my lane and focus on that. And that was fair. But I think more should have been done. As to what the situation is now, it's hard to tell what the situation is now. We need to have systems that can give us these answers. You know, are there competency assessments? What did the skills audit say? You know, what is the skill level of people in the NPA? On integrity issues, you know, there's been discussions in the media, you know, are there still people operating not in the interest of the organization? As I said earlier, it's inevitable that there will be attempts to capture the NPA because it makes important decisions that can impact on the lives of people. Whether they're succeeding or not, we need systems in place to give us an indication. I can only give you anecdotally what I think. I see prosecutors being arrested for taking bribes. That's shocking to me, you know. But they're in the newspapers.
As you said, I'm going to start managing your time.
It's in the public domain. So I think that I can't answer you about whether the NPA is still captured. I think that we need systems that should give us those answers.
Thanks, Advocate. Thanks.
You're done with your follow-up. I'm looking from your side. You fine Mfundisi? From your side. Okay. Just one question from my side. You spoke about the powers of the NDPP to make decisions, especially in relation to management. Let me speak to my mic as well. In relation to management. Now, changing the laws, we don't know whether we'll change the laws to give the NDPP powers to discipline the NPP. Wouldn't you run away if that doesn't happen? Because you're not going to have those
Yes.
powers.
Yes.
If we decide that you are the NDPP from 1st of February,
Yes.
those powers don't exist. Now, listening to the explanation earlier of being frustrated, writing memos, will you not leave after writing so many memos that are not responded to?
So, again, a very fair question. And the answer I'm going to give may not be very popular. I have no intention sticking around if there's no space for me to implement what I think needs to be implemented. I will work very hard to get the cooperation, and I think that there's a will and a willingness at the moment, and there's a moment for us to move on these issues. But I don't believe in sticking it out, especially in this kind of environment. Part of the reason I left in 2022 is it could have just been me, right, that was not getting the memo about how things were being done and what the vision is, and it just was me not getting in line with that vision. And when the NDPP and I agreed to part ways, it was expressly with the understanding that we are not aligned in our vision for how things should change. And I should make space for someone that she has more confidence is aligned with her vision. But as NDPP, the buck stops with me. And I have the authority and I have the responsibility to implement. I did not run away from the NPA the first time, but you know.
Even in this case, you are NDPP, but the power to discipline your deputies will be with the president.
I think I would like to answer it like this in relation to another issue you raised about the ability to run your own budget and be your own accounting officer, right, as opposed to going to the Department of Justice. There are many things that can frustrate you in government, as I'm sure we all know. You know, there's bureaucracies that are often very disabling. The difference is, like on the issue of the budget and just the issue of independence generally. Personally, I don't think you get given independence, right? Independence is something you assert day in, day out in the decisions that you make. No one offers it to you. So by the same token, on the issue of the budget, you know, I think that if the NDPP articulates a vision for what needs to change, right, and is held accountable, goes to Parliament in the annual report, in meetings with the minister, articulates the vision. And the vision has a price tag, but everyone supports the vision, but not the price tag, right? Again, I think if the NDPP finds that government is undermining the NPA by not giving it the budget, you can be sure I am not going to be quiet about that. I exhaust all my options. So even when the last time I left, I took my issues everywhere. I took them to the minister, your predecessor. I sat down and said, these are the challenges. I took them to the president, and I said, these are the challenges. They asked for time, I gave them time, but in the end, I realized that it's difficult. The national director is the lead here, and she should be given the space to implement her vision, and I shouldn't be allowed to come here with my other vision that I want to implement. But I want to be transparent and frank with you. I have a vision, and I would like to have that vision implemented. If I find that government has no interest in implementing that, I'm not going to be here for 10 years battling the door down. But I certainly will give it my best efforts, and I will consult, I will work with people. I actually am not as hard to work with as the impression is created. Well, the media certainly has the profession that I don't make friends, and I'm not easy to get on with. But I certainly feel passionate. This institution I'm passionate about. There's no two ways about it. And lots of people know that once she gets started on this topic, it's hard to stop her. But I won't stick around if I don't feel that I'm still making a contribution that is valuable. I have skills, I can, apply them elsewhere, and I will go where I think I can make a better contribution. So I don't have an easy answer for you, but I can tell you that
No, thanks.
I'm not easily.
No, you did answer me before, because that's why I'm asking this question. You'd understand that the tenure of the previous NDPPs, they never finished their terms.
I think it's too long anyway. 10 years is
It's a long time, so we must.
And the
review it.
DPPs are there for life. I really think
that's another issue.
we need to address that issue.
Yeah. Let's hand over to Advocate Spanyambokhale on the comments.
Sorry. Advocate Cronier, you actually got 14 responses, and 9 were supporting responses and 5 were objections. But when I went through them, I actually realized that even out of the 9 supporting responses, 3 of them had riders to say but. So I'll just go to the responses, and then you can respond to all of them in a group, because I saw you have, your responses were quite detailed. The first one says, I'll go straight in, I won't read the whole thing. She left after a blow up with Batohi. You have addressed that, you don't have to worry about it. And reportedly also did not make many friends in the institution. But the good thing about this is it was positive. The overall of it was positive, except for this part. If you could just explain the last part. And then a second objection actually came from a person and an organization, which was saying, we should ask you, if you are to be appointed as NDPP, how will you regain the trust of those experienced commercial prosecutors on whom the NPA and the country heavily depend to address corruption and serious commercial crimes? Please elaborate on the reasons for your resignation from the NPA as the then investigating director. I think that you have addressed. Okay, so we can skip that. And then a third objection says, it was reported that during her tenure, the ID had not successfully concluded any high-profile corruption cases. You have addressed that. If you could go straight to it, it would help, because I saw your response is quite detailed, and that's I like that. It just closes it straight away. And then the last one was from somebody who is anonymous, and it said, have written futilely. I don't know what this, I suppose.
Futile.
Yeah,
I get the message.
You
yes.
get the message, yes. To address Advocate Cronier in the past with shocking and factual repealing via email and WhatsApp communication. 6 attempts on my life when a direct writing was done to Advocate Cronier. Received nothing, as in 0 responses. My state capture case at the Zondo Commission should have been referred to IDEC for investigation, but it mysteriously disappeared. I suppose it was not, so you don't have to respond to that because it's about Zondo. But the 6, the ongoing writing and no responses. Unfortunately, this is anonymous.
Yes,
Yeah.
which makes it almost impossible to address, because the person says they wrote to me repeatedly. I'm not able to check, is that the case, what responses were given. So I wasn't able to address that.
Yes, no,
because
I
it's
agree
anonymous.
with you, but I just had to
raise it
to mention it. And then the other one is from a firm of attorneys that says a respectful submission that Advocate Cronier's actions on the allegations, which she had to deal with contraventions. This is in relation to the Department of Agriculture, Forestry and Fishery matter that involved the DG and other people.
I did not get that.
You did not get that?
No.
Okay. Yeah, PCC 2, yeah. Where
Didn't we send that? I'm looking at that.
So
Yeah, I saw in the
a matter involving the Department of Agriculture,
Forestry and Fishery.
Where?
I think it was Western Cape or something, I'm not sure. You
Yes.
remember it? Okay.
Well,
You
it's
know
my
of
favorite
it.
famous case.
Okay,
yes.
all right, yeah. The allegations say there was contravention of section 1794 of the Constitution regarding independence, section 195 of the Constitution regarding ethical public administration, section 32 of the NPA Act, which prohibits interference, section 41(6) of the NPA Act regarding the disclosure of information and or documents in possession of the NPA, and the NPA Code of Conduct. It is respectfully requested that these matters be fully considered in relation to Advocate Cronier's appointment, and we confirm our availability to clarify any aspects hereof or to provide supporting documentation. The supporting documentation has been provided. It's quite a thick one. Annexure PCC 2. Yeah. And
It's not anonymous, so
yeah, no, this is
the
not
date-
anonymous.
the
yes.
identity of the complainant
Yeah,
can
you
be
will
revealed.
get to know. And the last one was basically a support, but like I said, with a but, a group of individuals and an organization saying one of the potentially good and better candidates on the short list. She has worked in the NPA for a number of years before in different capacities and has distinguished herself in the role that she has previously held. She has experience in asset recovery and financial crimes. It is not clear if she has staying power, which has been all of the concerns that were raised, where people were saying staying power, and will not resign if she is under pressure, like she did as the inaugural director of IDEC. Investigate. Okay. I should indicate the names. Or for all of them, Minister?
The record, especially those that
Oh, okay. All right. Oopsie, sorry. The first one was from the Daily Maverick about the blow up.
Yes.
Yeah. And then the second one about how will you ensure that trust is regained and all those people who had experience to prosecute commercial corruption cases was from chairperson of the SSAPSA. I think it's something Prosecutors of South Africa. It's the organization, I just forget the name. Society of State Advocates and Prosecutors of South Africa. So you have allies there already. They're saying we were there, we know what we were doing. How are you going to ensure that we continue or we get back? PCC 1 is our attachment.
Okay.
And then the third objection is that one that was anonymous after several attempts. And then the fourth one about the Department of Agriculture, Forestry and Fisheries, which is PCC 2, comes from B. Kulu and Partners Incorporated, a law firm. And then the last one is Mr. Pila Sitole and Dr. Ntokozo Lwandle and TEASA Marketplace Commission. That was raising issue of staying power. Yeah, okay. Thank you. Thanks, Minister.
Thank you. Thank you very much. So we agreed that you have an anonymous complaint that I wasn't able to address. I think that's the main one that I couldn't address. This one, I hadn't received any of these documents, but I know this matter very well. The complainant is Barnabas Kulu, and partners. This case has in fact been with me my entire career. It was one of the first asset forfeiture cases I did that involved over-harvesting of West Coast and South Coast rock lobster in the Western Cape. Benjes and Hard Bay Fishing was the company that were over-harvesting. I think we brought asset forfeiture applications to seize 3 vessels. Then Mr. Benjes fled to the United States, and again we worked with the US authorities. Eventually the Scorpions settled this prosecution, and as part of the settlement, we settled the asset forfeiture. I think it was the biggest asset forfeiture settlement at that point, and it was for 20 million. Which is now considered a laughable amount of money. But Mr. Benjes went to the United States and was apprehended over there. And we proceeded to provide assistance because in the US, the Department of Fisheries became a victim. And we were allowed to make a victim impact statement in the US proceedings to illustrate what the decimation of our West Coast and South Coast rock lobster resource did, so what impact it had. So we had gotten, I think, ECT to do studies to quantify the value of the damages Mr. Benjes's activities caused. He was ordered to pay South Africa. I'm going off memory now, and at the best of time, my memory with numbers is not great. But about 21 million US dollars was the quantified damage that we were awarded. Mr. Benjes had also, the US authorities had located assets belonging to Mr. Benjes in a trust in Jersey. And we, with the US government, were trying to preserve those assets to get them back. Mr. Kulu and his law firm were appointed probably by the NPA, but also by the department to recover this money. So it was a curious appointment because I was no longer in the NPA at this point. But in fact, I was briefed in a civil matter by the NPA where Mr. Benjes was suing the government of South Africa for the full 21 million because he said that he had already settled with us with the 20 million, and so therefore we weren't entitled to the full 21 million. He lost that case. Mr. Benjes lost that case, and he appealed all the way to the SCA, I think. But Mr. Benjes's role then was to, on his version, recover on behalf of the South African government the 21 million. Which, as I say, was curious because there were already orders in place that we were entitled to the money. But he and my former colleague, Knox Molele, traveled to Jersey and the United States and eventually concluded a settlement with that said we would take 7 million, not the full 21 million. And when I returned to the NPA, this is a matter I then investigated because the settlement, nobody authorized the settlement. It's an issue I raised with the NDPP. There were investigations conducted into the conduct of various individuals. Mr. Kulu, I think, was at one point ordered to repay money that he had received into his personal trust account. So Mr. Kulu is not a neutral complainant. He was a target of investigations at one point. He has been ordered to pay back substantial amounts of money to the department, who ultimately sued him. And I think his appeals have also been concluded. So I'm not surprised he's not a fan, but I'm not sure that I can address any further. I haven't had time to read what his actual complaint was. He says, I didn't deal with that matter appropriately. I will actually agree with him because there should have been prosecutions emanating from the matters. So it's a pity. So then on the other issues, so this about my popularity. One of the articles written about the split or my departure was that it was a cat fight, and I was deeply offended by that because it trivialized what I thought were important issues. And I wrote to the journalist and said, I happens to be a man, and said, would you characterize a disagreement between two male colleagues in this way, refusing to actually deal with the substance of the issues raised and just characterizing it as these women can't get along. He said he didn't mean it like that. But I accept that there wasn't a lot in the public domain for people, so people make up their own speculations. But there wasn't a cat fight because the NDPP and I actually left on fairly decent terms. I can disagree with people and still get on with them. Yeah. The people who said I did nothing while I was in the ID, I think one complainant said I didn't institute a single prosecution, so I clarified that that's incorrect. The bulk of a lot of the prosecutions that are ongoing were instituted by me. And I had a strategy that, I was advancing that, the Nolani case was an important, really important case because there haven't been a lot of serious, until Jackie Salebi, there hadn't actually been this very serious, high-profile prosecution. John Block was the other one, and both of those were a good 10 years ago. So there's very little incentive for anyone to turn state witness because you have a good chance that the case will just drag on forever. I'm just looking at you two to see if I'm being temperate enough in my language, right? But I'm sorry, I'm being unfair. I think that it is true that almost none, except, there was a bit of a vindication in Nolani, but the case has to be re-enrolled, so it's not really a finalized prosecution. But it was really important. When we enrolled that case, we got bail denied of one of the key accused in that matter. He was later identified as a key accused in the US prosecution. And, our strategy was that we were trying to do one quick case so that people realize that when we charge, we will prosecute and we will succeed. And so when we charge the next one, you realize that actually they mean business and they're likely to plea. None of these cases have concluded, which is why I spent the last year of my life trying to work out what are the systemic problems causing this kind of delays, and we've addressed those. I have referred here to a report done by the NPA after my departure that was submitted in Parliament that set out everything that I had done in the NPA, and it's available online if anyone wants to check it. It wasn't written by me, it was by the NPA who said this is what was achieved. But it wasn't enough, it wasn't good enough, and I could see that it wasn't going to change, and I don't think it has. I think we're still in the situation where we don't have a conviction. Well, we have one or two plea and sentence agreements with no jail time, but we don't have a conviction for a serious corruption case 3 years after I left.
Maybe just to come in, the mic. I do note that, as you said, the team didn't give you the documents, and I'll acknowledge that because I gave you out of my pack, but there's a memo that is written by Mr. Mulele to Mzinyati on the same case, the NDPP versus Arnold Morris Bennings. If you read that memo, it does give a different matter compared to what you have explained.
On it.
Yeah, this memo talks about, it actually says that the allegations were brought by Barnabas Xulu Incorporate. And they were actually the ones who assisted NPA to pick up these corruption issues. As I say, I don't know what happened between the team because they should have provided you with all these documents so that you are able to make a reflection. I wanted to put it so that it's not said because we were provided with all this information. And I don't want it to be created that we've deliberately put away a particular document and not process it here because we can be alleged to have done something wrong. Yeah, it's a bit of a difficulty because the team should have given you all these documents so that you can give. If somebody is objecting and saying, these are the documents that supports my objection, I was the complainant, I think, and all that. And as you say, you are responding from your knowledge of information, but not to having understood what the complaint is about. And I was, because that's one of the things I picked up, that you should have not seen it because it's not on your responses.
Yes.
You did make responses on others, but you didn't. And the other issue that, and which we should be able to go on record, I always like going on record some of these things as if it's, so that it doesn't tomorrow create us if we were hiding things. COSATU did support you, so it must go on record. But from a point of COSATU, yeah, signed by the parliamentary coordinator. So it would have been from understanding of the work in Parliament.
Okay.
That's what but I'm saying it must go on record that you've got that because it would be said that it's a political aligned, though it's a labor movement, but it's got alliance that could cause some unnecessary views that we should be able to go on. So yeah, you wanted to say something, Prof, on that?
I guess taking the cue from the chairperson, in the event there is a document that might have been missed, as a corrective measure, giving you that and a chance to respond so that as the panel, we have the same benefit as we have seen with the others. Thank you.
Oh. I would be delighted to respond to this.
That's why I'm saying I do apologize because they should have made sure. They sent the email, I don't know what would have happened.
I mean, the subject matter of the complaint was part of the charges that Knox Molele faced before he left the NPA. So it's, yeah, it's, he left the NPA, he reached a settlement with the NPA, but by then I had already left the NPA.
Also, you wrote a memo before. So
I assume so, yeah, yeah.
Oh, okay.
It's
And then later faced the charges in relation to this.
The charge he faced.
Let's give you a chance
yeah.
to read everything. I
Yes.
think let's be rather fair
Safe.
to you, Advocate
Yes.
Kurunya.
Yes.
Let's be fair to you. Look at the complaint of Barnabas. Look
Yes.
at it with all the documents that have been provided. Then you can give us an explanation.
I'll be happy to do
so that
that.
we have it as well on record. We don't want to prejudice you. Yeah, I must write. And
I'm
we
very
don't want
happy
to be seen as if we covering for you as well. So it's something that we've got to be quite cautious about from our side. With that, I'm happy to announce that we bring this session to an end with you. And thank you very much for coming through, sharing the views, and making yourself available.
I'm very grateful, and I'm sorry I seem to have exhausted the panel.
I don't think the panel, I didn't say them complaining, and if I didn't stop, I think the panel would have gone on and on with you in the conversation. As we say, it's a conversation.
Yes.
And you were open to have that conversation openly.
Yes.
So I think that's
Anytime.
what you did. Thank you very much.
Thanks.
We haven't had lunch, so let's have 30 minutes break. Okay, what time is it? Yeah.
Time it's 15:16.
It's 15:16 now, so we'll come back quarter to 4. Afternoon, Advocate Simelane.
Afternoon, Minister.
How are you?
I'm fine, ma'am. How are you?
I'm okay. Let's get your mic closer to you, and then we can get you settled. Did we run out of water that we put a bottle, this a jug now, not a bottle, closed bottle? Colleagues, please, let's sort that out.
I asked for it, Minister.
Huh?
I
Oh,
asked
you asked for that one?
Yes.
Oh, no, I want, because I don't want to be accused of biasness. So I had to be sure that, okay.
Yeah, no, I asked for it.
No, thanks, Advocate Simelane. We're going to process the questions through this format. We'll go through with you your questionnaire that we would have sent to you as we invited you to the interview. I'll take you through that. After that, the members of the panel, together with myself, will ask you questions. But in between, even through the questionnaire, there might be colleagues who follow up on issues that we have picked up. And then at the end, Prof. Fikeni will take you through the comments, public comments that we have received in that regard. Just going through your questionnaire, section 1, it's your personal details. I hope you've got the questionnaire with you.
Yes.
Okay, thank you. Section 1 is your personal details. We won't go into that. Safe to say you confirm that as your signature is there?
Yeah.
Okay. I don't think your mic is audible.
Is it better now?
Okay.
Thank you.
And then we move into the section that deals with your qualifications.
Yes.
If you can take us through your qualifications as part of the requirements for the post, how they are relevant and how they assist in the position of the NDPP.
Thank you, Minister. Good afternoon to you and good afternoon to the members of the panel. My name is Menzi Simelane. I'm an advocate I'm a lawyer and an advocate in practice. The qualifications that you see there are relevant in my respectful view because the position of National Director requires somebody who is a lawyer. So I'm a lawyer by training and I'm a lawyer in practice. As indicated there, I attended the University of Natal in 1990. I finished my high school in Harare in Zimbabwe. My family was exiled in 1984 to Lesotho. And from Lesotho, UNHCR moved us to Zimbabwe. So I spent my teenage years there. I attended Prince Edward Boys High School. I have a BProc and I have an LLB. And after completing the LLB, I came to Johannesburg and joined the Johannesburg Society of Advocates. I had already been admitted as an advocate at the time. I was admitted in Pietermaritzburg in the High Court there. And then in 2000, I studied at the University of the Witwatersrand for a management advancement program. I did that just to assist me better understand and better appreciate issues of management because at the time, I was at the Competition Commission in various capacities. So I believe that the qualifications that I have are appropriate and qualify me for consideration for this position. Thank you, Minister.
Thank you. As we move into the next segment, which I think you have started to deal with, your work experience in terms of where you've been. Firstly, I hope I'll read at some point because it's a written document, so I'll use interchangeably your CV as it comes out.
Yes.
Quite better. Handwriting is like a doctor.
Sorry, cockroach ran through
process. Yeah. It says 1999 to 2005, you were chief legal counsel in
Yes.
the Competition Commission. Then you moved to become, or then you became a commissioner as well,
Yes.
competition commissioner from 1999, 2000 to 2005.
Yes.
At that time, then you moved 2005 to 2009 to become the Director General of the Department of Justice and Constitutional Development. And then you moved 2010 to 2011 in the NPA as National Director of Public Prosecution.
Correct.
On your form, there is the NDPP 2009, which I couldn't find in your CV.
Yeah, that's correct. I may have missed it in the profile, but I first joined the NPA as a deputy for 1 month. I was, I think, a deputy for 1 month.
For 1 month?
For 1 month, yes.
Okay.
And then I
became-
acted, and then I became NDPP.
You acted for how long?
It was a very short while. I think it was also a month, if not less, and then I became NDPP.
Okay.
Yes.
And then after that, you became a special advisor to former minister who was at
Yes.
Human Settlements, or was
Yes.
in, yeah,
Yes, it was a human settlements, but I joined her when she was Minister of Public Service and Administration,
or Public Service Administration
Yes.
from 2014 till 2021,
about 2013.
2013.
2013, 2014, around
Okay.
about there. Thank you.
And then you've been an advocate. Currently, you are an advocate
Yes,
practicing.
ma'am, I'm an advocate in practice, yes.
Okay. That's fine. Maybe take us through how this experience is relevant in terms of your work. Looking at, so you've been at NP, and we'll come to the procedural experience. You acted for you became DPP for a month in
Yes.
2009, and then you acted almost again a month, and then you became
NDPP.
National Director for Public Prosecution for a year.
No, ma'am, it was just about 2 years, if I recall, from about 2010, beginning of 2010, until about when the Constitutional Court judgment came out in 2012.
Or in 2012?
Yes.
Yeah, your CV says 2011. Okay, that's where the
just an error,
form
yeah.
says until 2010 until 2012.
2012,
Okay.
yes, ma'am.
Take us through your experience, how it would be, and we'll deal with the issue of the Constitutional Court later.
Yeah.
But let's now, for now, take us through how relevant is this experience that you have. And I'm also looking at the fact that you didn't stay long in the NPA itself.
Oh, yes. No, absolutely. Well, how do I put it? I think I was a bit fortunate because I joined the Johannesburg Bar in 97, beginning of 97, January to be exact. And at the beginning of 98, the Department of Trade and Industry, as it then was, invited young black lawyers through the PLA to make themselves available on what was going to be looked into, which was competition policy for South Africa. So I put my name down, and after a while I was selected as one of the people that was going to be, one of the 4 people that was tasked with revising competition policy in South Africa with a view to creating a completely new framework. So I did that. I then took leave of the bar. I went to do it full-time in that task team. We were led by Dr. Alistair Reiters, who was at the DTI at the time. That work we worked on policies, went all over the world doing benchmarking. We finished, we came back, the department was drafting legislation, we attended to it. It was taken to Parliament. We engaged stakeholders as well. It was a very, very contentious piece of legislation, Minister, because at the time, the government of the day was still discussing with business the best way to take the situation forward, in the sense that what had been discussed during the CODESA negotiations, amongst others, was whether the South African position going forward would look at abolishing, well, not abolishing, but dismantling monopolies, because the South African economy at the time was oligopolistic and monopolistic. There were certain specific companies, I'm sure many of you know them, like SAB, who had been making representations and making submissions about the appropriateness or not of that approach, which was seen at the time as maybe being too soon for consideration so early in democracy. So we did all of that, and the law was passed. And when it was passed, obviously the institutions are established, then lo and behold, they needed to be filled with staff. So there was a discussion about how do we start filling the institutions by incorporating members of the competition board, which was there at the time, into this space. We engaged with everybody that was involved, members of the competition board, the staff employed there. The conclusion was that the people that were responsible for putting the institutions may as well be the first people to staff them. And there was a discussion where I should go, whether I should go to the competition tribunal or the competition commission. We looked at it, and it was felt that, well, I said, my view is that competition tribunal is making final decisions, and it sits, because it's a tribunal, it sits in an adjudicative fashion. I felt I was too young to be sitting to adjudicate matters at that point in time. I needed first to make sure I gain experience in the actual work itself. So it was decided that, no, then I'll join the commission, and Dr. Reuters became the first commissioner. I joined then as the chief legal counsel. I think I was the second staff member. He was the first, and then we filled it up. And then the responsibility was to then staff it completely from day one. And we spent a lot of time discussing what kind of people we want there. The competition board, everybody in this room knows the history of South Africa. The competition board, for all practical purposes, couldn't create a culture of competition in an economy under the government of apartheid. It just wouldn't work. You know, there were sanctions, there were all sorts of things. So it was a protective economy that South Africa was in. And because it was a protective economy, the competition board really did not rigorously, at least it was felt, did not rigorously enforce the competition law at the time. So it was, for all intents and purposes, ineffective. So what was happening with the post-apartheid government is that in the new democratic government, the idea was to completely create a competitive economy under the circumstances that were there. So the idea then was, what kind of people do you bring into an institution that is completely new, that is in an environment where there is the new constitution, everything is practically new. You're getting a blank sheet of paper, and you're being tasked to do as you please in order to make sure that you get the best that you can get, in order to make sure that the objectives of government are met. So we made a lot of decisions. One of the first things we did was to make a call that we don't want anybody over the age of 35. We were not going to recruit anyone over the age of 35, because we felt that it needed to start with a young crop of South Africans. Even if they're fresh out of varsity, we would train them from beginning. We needed fresh thinking, new ideas in line with what government intended, in line with the Constitution, people who were hopeful about their future, people who would go in there and work and not have everybody or somebody remind them how it was 5, 8, 9, 10 years earlier. Because we found that with officials of government that had been there for a while, the tendency whenever things were discussed, they would want to remind everybody of how things have always been done. Then it's difficult to effect the kind of change you want to effect in that kind of environment. So we felt that it's a perfect opportunity, new people, new training, new approach. So we started that way, and we started training people accordingly. We did incorporate a few staff members from the competition board, so it didn't become a problem because it was a very small institution. I think no more than 15 staff members at the time. So the advantage of that, which I'm happy to observe to this day, is that the systems that we set in there, the institutions practically run themselves, the institutions function, The institutions have legitimacy, they're accepted in society, and they are first world institutions. In fact, I can't remember the year, Minister. In fact, there was a time when the big problem with South African, well, not the big problem, one of the advantages we did is that in merger transactions, we were the only country in the world, we introduced, it was 4 requirements that had to be considered in merger transactions. We introduced what we called public interest grounds. Public interest grounds related to employment and any other issue of public interest that wasn't strictly economics. Antitrust law, competition law is about economic efficiency. And it's strictly, measure economic efficiency. Once there's efficiency determined that the measure is good to go, you should approve it. That's what is called the Chicago School type, very conservative kind of approach to industrial economics. But because of our unique situation, we introduced public interest grounds. And the many jurisdictions that we compare ourselves to in the West frowned on this, and they spent a lot of time persuading us to not go that route. And we stood our ground that, you've got to understand our situation, and it was accepted. So the public interest grounds continue to be used today. There's question about whether they're now relevant after COVID basically changed the international economic environment. Some argue that it's difficult to sustain because business needs to rebuild, but others say because of huge job losses as a result of COVID, there's still some merit in maintaining that. So I'm proud that the institutions remain effective as they are. Nobody, very few people, at least that I knew, were experts in competition law when we started. Right now, there's a whole lot of experts. And I'm quite proud to have been part of a crop that ensured that competition policy in the country, specifically for historically disadvantaged practitioners, is something they could start with at the beginning and grow into, as opposed to the traditional approach where historically disadvantaged graduates, law graduates, go to specific law firms with a view to acquiring experience or practice in the area of the economy. That's usually was the approach. In this case, they actually we started with them by employing quite a number of them. And most of them now actually are partners and directors in many of the law firms. So the graduation was quite seamless. What I'm also proud of is that unlike many areas of the law, it's one of the most de-racialized area of practice in South Africa, in that a lot of young white lawyers also got a lot of interest in competition law. And some did come and join, because we did recruit quite a number of white staff members. Others who engaged with the commission got interested in it, and they found ways of engaging with it. So the long and short of it is that competition law is one of the rarest de-racialized areas of practice in law in South Africa, and I'm proud to have been part of that particular setup. Then, well, obviously I was chief legal counsel. Then I became commissioner. Dr. Richards was only commissioner for 6 months. Then he was appointed director general. And I was interviewed for and succeeded in replacing him. I then became commissioner. One of the things then that we had to do, just to get back to the point I wanted to make, is that I think it was about 3 years later, the OECD put South Africa on the list of countries that were to undergo a peer review. So we had to prepare for the peer review and go to the OECD to be peer reviewed. So I led that team with other staff members, and Mr. Dave Lewis, as he then was chair of the tribunal at the time. We sat like this at the OECD, went and sat at the front, and all the other countries were there. And they practically peer reviewed us to check if we were a jurisdiction that practices antitrust law, as it is called, or competition law, as some call it, in the manner that meets the standard of the OECD. And we did very well there. And I think, if I recall, that first assessment put us in the top 25 in the world of the countries that practice that law. Then from there, I was invited to make myself available for the position of Director General at Department of Justice. On the 1st of June, I joined the Department of Justice as Director General, 2005. Well, you know, you've got to look at, for context, that administration. If I recall, it was the second, if not third administration. There were a lot of things of a policy nature that were taking place in the country across the board, from dealing with access to ARVs, all those conversations, dealing with the medicines. I started dealing with them while we were at the Competition Commission. There were issues about smoking, banning smoking, that was coming from the Department of Health. Also, the Competition Commission was pushing very hard on breaking barriers. So that period was quite robust, if I can use the term. In the area of law, it was probably one of the most difficult and most robust areas, because we're talking transformation of the judiciary. It was even before the Constitutional Court got set up. It was still, I think, setting up very slowly. The primary focus was still Bloemfontein in the SCA. So as DG, I was part of the processes that had to create the apex court in the Constitution. Transformation of the legal profession, we did a lot of that. For my sins, I pushed a lot of things that I think are following me to this day, and I'll deal with them briefly. How did we do it? Through pieces of legislation. The Legal Practice Act was something we started at the time. We conceptualized it and we said, when you look at the legal profession, obviously through the input of many stakeholders, we needed a legal regulator in South Africa, or a regulator for legal professionals that would be controlling overall, as it were. Remember, just like the DPPs in the NPA from different provinces, we had law societies in South Africa, so there was an argument that there must be one. So we put in the legislation that there must be, or in the policy discussions, that there must be a legal practice act that would deal with all practitioners and the Legal Practice Council. And some of the biggest fights there were about what the legal practice form in South Africa should be going forward. For my sins, I was one of the people that pushed for the abolishment of bars. I argued that South Africa doesn't need the various bars as we know them. We must fuse the system. I was a believer in the American approach to legal practice, that we should not rope, we should not have these ritualistic, traditional things that you see in the legal profession. You go to a courtroom, you robe, you dress the way you dress, it's cold, it's dark, and it just didn't lend itself to making people feel that there was justice. Everybody walks into a courtroom, the first thing they do is freeze, because it's just so cool and dark, it's hard wood, and all of those types of things. So I was part of the group that believed that we need a different approach, and I pushed for that. And it didn't sit well with a lot of people. There was a compromise. We were instructed that the compromise is, let's keep the tradition as is, but let's push for or put in place hybrid practices to say if people couldn't become advocates, but they wanted to be advocates, for some reason they couldn't pass the exams and do all of the kind of things, where would they want to practice? So hybrid practices, that's how they came in, to say lawyers can be employed anywhere, in accounting firms, in law firms, provided there were firewalls in place to separate, because the advocate's profession must be independent. So I lost that debate, accepted it, and that's how we moved. That's why you have the Legal Practice Council today through the Legal Practice Act. We also conceptualized the Solicitor General position to say let's have, in the same way that we're having an NDPP, who would attend to civil matters on behalf of government. So again, I looked at the US approach, I kind of liked it, and we promoted it in the department, and it was felt that let's have it. By the time I left the department, the framework hadn't been, the legislation hadn't yet been passed, but it was accepted that we'll have a Solicitor General, amongst other things. Then we rationalized the courts in the Superior Courts Act. We worked on the Superior Court case with Advocate Johnny Delange was a deputy minister at the time. So we looked at all the courts in South Africa, district courts, regional courts, and the high courts. There are different areas of jurisdiction, the magisterial district, to reconfigure them, to try and make them match what government believed at the time was what was needed. it was interesting to me that, in fact, regional courts were established in 1977. And it was interesting that they were actually established to respond to June 76 happenings. So when you learn that kind of history, you get to see the logic of what the government at the time was trying to do. And you try and look at it and say, is this what you need going forward? Or can you take what you are inheriting and work with it to where we are today? So the approach was, we work with what you find. In any event, that was part of the 1994, the Codesa settlements, that the legal system is accepted as it was, structured as it was. We follow the common law and the Roman Dutch law, and then we have the constitution, which will support them. So it wasn't really a problem. So that's how.
So that regionalization happened.
Regionalization did happen in the sense that we rejigged magisterial districts. Again, because there were new provinces. I think there were 4 provinces initially, so they were expanding. All of a sudden, there were 9. So we had to look at how, for example, in Pretoria, there were issues about former BOP, which was now part of Pretoria. And so we had to redo the whole jig. I don't remember it 100% now, but it was all redone. Overall, the 300 courts that we ended up with in the country encapsulated that type of rejigging. With that came with jurisdictions, civil jurisdiction, what jurisdiction to give. Over time, it grew to the point where I think, family courts and family law also got dealt with from the black divorce courts, CDC, to the magistrates courts. So we did all of that, increased the jurisdiction, gave the regional courts more primary jurisdiction for some serious offenses in the same way as the high courts. So that's why you find that you can be prosecuted for murder in the regional court and equally in the high court. And sometimes people don't get to understand. It's just a split of jurisdiction to accommodate the volumes that are there so that matters are dealt with as speedily as possible, at least it is hoped. The majority of criminal cases, close to 60, 70, if not 80%, take place in the lower courts. So those are the primary, really important courts, as it were, despite the thinking still remaining that the high courts, the high court, the high court. The reality is that it's actually the magistrates' courts that matter more, in my respectful view, than the high courts. So I got involved in all of that. There's so much. Dealing with judges was probably one of the biggest issues and transformation, because the legal profession is generally conservative, extremely conservative. And there was a general view at the time that the Constitutional Court judges were political judges because of who they were, irrespective of their stature. Those were the undertones that were confronted with in engaging, that the Constitutional Court judges, those are not real judges. If you want to be a real judge, you go via the SCA. So in this debate around the apex courts, one of the views was that leave them as they are. A strong view, which I would say was associated with pro-transformation advocates, it was that remove the SCA, we don't need it. Take it and make it part of the constitutional courts, polis, but win out those who would be resigning or retiring until you have the acceptable number. There was a big debate on that. After a while, the conclusion was that, no, let's leave it. Let it be an intermediate court. Let's cut out the fight. Let it be an intermediate court. The constitutional court would deal with matters from there. So it was interesting dealing with different types of personalities, different judges, others very strong-willed, others okay, others, like everybody else, can be not so pleasant. But one, by virtue of the position, I had to deal with that and assist the executive as best as I could. And the stakeholders, naturally, it was a good thing working with them, with all those different views. So that mix of pushing that transformation agenda was quite interesting, and dealing with the prejudices that were there at the time. Then the next level was about the appointments of judges. So again, a big debate about appointment of judges. It was quite a serious thing because most black practitioners and most black judges felt that the crop that was there didn't welcome them and didn't want them there on the basis that it felt they are not yet competent, they are not that ready. So there was this traditional view that you go through the ropes, you take time, you must be, sort of supported by certain people before you moved on. So the transformation advocates weren't as patient as some of the suggestions seemed to be, and there was a big push. So there was a lot of difficulty and a lot of fracture in those relationships. And again, I was in the middle of that because as DG, you had to make sure you provide resources to all of them, you had to engage with them and accommodate them. It covered all nitty-gritties, really, including the cars they get, which, Minister, you'll be aware, judges take very seriously what they considered were their perks. We rarely even thought about perks because many judges felt, I already have these, I'm already used to it, it's a perk. If you take it away, you're taking away what I'm entitled to, there's going to be a problem. So just like, you know what, you have it, it's your right, you're entitled to it if that's what you want. So a lot of movement back and forth was the issue. Then there was a push for arbitration. Others in the private practice said, well, we want arbitration, courts delay and all of that. And black judges felt offended by that suggestion, that now that it's us coming in, we are pushing for arbitration, which takes matters out of court. So we had to get in the middle and start debating that to say, really, is it taking matters out of court because the new crop coming in is being undermined, or is it really just an issue of volumes? We decided that it's not necessary to resolve it either way. The fact of the matter is that there's huge volumes. Arbitrations are not a bad thing. They're an international thing anyway. Let's find a way to deal with this. And the judges that you accept, we have that particular framework now. Yeah.
So the involvement here from the department point of view, was it from a policy point of view, or the judiciary had allowed, as the constitution will call for, the independence of the judiciary?
It hadn't got to that stage, Minister. The department was still hardly involved. They wouldn't move without the department. They couldn't move without the department. That was the inherited culture that we found, that the Department of Justice was central to everything the lower court judiciary and high court judiciary did. So they'll pick a call and say, DG, we need you here, and I'll quickly drive up or go meet. We arrange those types of meetings. The issue of independence started coming in a bit later to say, look, how do we ensure that there's independence? Because even that was a big fight, and it's still going to remain a big fight because there are no, well, I think it's getting settled a bit better now, maybe to be better going forward, but there are still views about how much independence. On the side of the executive, the concern was always judges can't handle money. They're just like public servants. They can't handle money. You give them money to handle. To what extent are you making them vulnerable in the sense that when it's time to account, would they go to Parliament and account? It's not going to happen that way. So let's, as the side of the executive and the department, be a little bit firm in not moving very fast in that direction. But the engagements continued around independence. I think it went well because I think it was accepted. Many judges, that I engage with, many of whom are my friends, would say that we like this arrangement because we want these benefits, and if there's something to account, you'll take care of if anything happened. In fact, with cars, many times one would go and find that there's a judge in a spot of bother because somebody who shouldn't be driving a car was driving it and it had crashed. So somebody had to clean that mess up, and we took care of that business, and amongst other businesses we took care of. So we protected the judiciary a lot as part of this transition for good reason, and I think it's a good thing to do. But we're right at the center of it. And over time, Minister, as you would know now, the decentralization has gone to the point where it's at now, where it's a department and so forth and so forth. So it's a bit different. But the issues is that then as DG, one dealt a lot with clerks of the court and registrars and deputy registrars who perform quasi-judicial functions. And it's an issue that will be looked at going forward, and it must be looked at because those judges make orders, but when you get the document, some of them the registrar is signed, which is an official in the public service. So in other words, what is a registrar? Where is the registrar located? The registrar or a clerk of the court in the magistrate's court is located in the executive, but they're signing documents of a legally binding nature that belong in the judiciary. What does all of that mean? So it's an inherited culture, but it's still there and slowly has to be looked at to see the impact of that. So I dealt with that on that side. We dealt with the master's office. I know a lot of people look at the master's office as a place where you go get a stamp and get a letter of executorship. But my respectful view is that the master's office is an economic department in a way. It's an economic unit because what is logged in there is economic value. The reason why people want to go get those letters quickly out is because they want to access money so that they can spend. So we dealt with that as well. And one dealt with the state attorney's offices, manage those and all the troubles that are there. I can talk for days about the issues that are there. But by and large, Minister, that experience as a DG, I covered a wide range of topics. I won't remember all of them now. But I also I co-chaired the JCPS cluster. If you're a DG of Justice and the Department of Justice co-chairs the cluster with another department, at that time it was the police. So I co-chaired the JCPS.
Still the same even
Still
now.
the same. Some things don't change. Well, I'm sure it's better now. But I co-chaired, so my co-chair was National Commissioner Jackie Selebi at the time, and we dealt with all the issues that the cluster entailed. And I also sat in the National Security Council of DGs that dealt with those kinds of matters, and we reported accordingly. Post-TRC matters, when the report was accepted, Cabinet sent it to the Department of Justice to manage. So I was tasked with the responsibility of creating the infrastructure for those matters to be dealt with. So we established the TRC unit, and the executive authority at the time looked for an appropriate level person to head it in light of the sensitivity of the issues. And the late Ambassador Dr. Sekwe were able to have his resources available, and he headed the TRC unit. And then we capacitated it with the relevant staff, and they ran with the reparation side of the business. The prosecution side of the business naturally went to the NPA, and it was dealt with in the PCLU. And talk about the NPA as DG, I was responsible for, at the time, everything, until 2008 at least, or roundabout. I know the PFMA is a 2008 legislation. I can't remember when exactly it came into effect, but before the PFMA, the Director General of Justice was responsible for both the public service side of the department, as naturally we are head of department. You are responsible for all the programs. And also the financial side, in that you follow the Exchequer Act in order to deal with finances. When the PFMA came, it made things clearer that the head of department is the accounting officer for the department in respect of finances, and you run pretty much the whole shebang. What that meant, obviously, for the NPA is that I was responsible as well for the NPA in respect of everything, except decisions to prosecute or not to prosecute. But in respect of everything else, the Director General was responsible. I had to make sure that the NPA got everything that it needed. And in order for the DG to account, I had to get all the reports from the NPA that were necessary in order to account in respect of finance matters and in order to account in respect of public service matters. The one exception at the time was the Directorate of Special Operations, because it had its own legislation. It had its own legislation, and in terms of its own legislation, it was for all intents and purposes independent. So I had nothing, as a DG, I had nothing to do with the DSO. But for everything else in the NPA, especially what would be a corporate services side of it, I was responsible for. Then also I was responsible for reporting purposes and overseeing some of the entities that the department was responsible for, primarily legal aid. It was Legal Aid Board at the time. It's now Legal Aid South Africa. So with Justice Mlambo, who was chair for 10 years, we worked very well together, together with Vidu Vedulanka, who was the CEO, to change the way legal aid was perceived by the public, and also how legal aid itself, official staff perceived themselves, and so forth and so forth. Because it had a board, it had people, I was a few steps away from it, but we provided all the necessary support that needed to be provided there. Then, come November 2009, after which I'm sure we'll discuss, you're looking forward to it, the removal by National Assembly of the National Director of Public Prosecutions at the time, I was then I was appointed as deputy, and I went there, and I subsequently got appointed as...
You were appointed after his removal?
Yes.
Okay, as deputy.
Yes, he was removed. Then they were acting there. Advocate Mshe acted, if I recall, for a while.
Okay.
And I remained as DG officer at the time. Advocate Mshe acted. And I think I then got appointed as deputy. I worked under Advocate Mshe. And then I was appointed national director.
Okay.
So that's how it worked.
Oh, you moved from the department to
the NPA.
To the NPA.
Directly, yes. Okay. That's how that worked. So, well, just in terms of the staff that one managed, the Competition Commission didn't have a lot of staff, not more than 300.
Now get to the NPA as your work before we come to management.
Oh, okay.
We want to hear your tenure at NPA. Yeah.
I had an advantage, I believe, because when I went to the NPA, I already knew about it while I was DG Justice. I pretty much knew everything that was going on there, the good things.
Because you were the accounting officer.
Because I was the accounting officer.
Okay.
I knew the good things, I knew the bad things about it. So all the controversies around the NPA at the time, I already knew. I had the information. Also because I was chair of the cluster, so in the cluster we would discuss all these things. So I already knew. The troubles that were there with the DSO, I already knew. In fact, when I was DG, one of the responsibilities post the cabinet decision was that the DSO must be disbanded. And I was tasked as DG naturally with the necessary putting in place of the legislation to disband. And the department prepared the legislation and it went to the National Assembly, it was passed, and the DSO was disestablished on that basis. That was my job as DG to do, to follow instructions as they were given. So I was already...
During that time, were you involved in stuff, because there was DSO staff, movement of staff? To what extent were you involved?
Yes, yes, I was again very, very involved in that, because I think this establishment was around 2009. So when I moved to the NPA, it was still in that sort of transition process in Parliament. When Parliament passed the law, I think I was, at the time, I was acting NDPP. I was acting NDPP. So as soon as when I landed there, it fell in perfectly, because I remember one of the first things I did was, when I became NDPP, they came to pick me up in these jeeps that they had, some black jeeps, very popular jeeps that the Scorpion used to run around and chase after people. Jeeps, I think they're very special jeeps. They're called Jeeps Cherokee SRT, stands for Street Racing Technology. So if you stop off the range, I refused to get in there. I said, I'm not getting in this car, because I no longer have the authority to utilize it, because it belongs to the DSO. And in terms of the dissolution arrangement, the NPA no longer has investigative capacity. So I can't touch anything to do with investigation, because the NPA no longer has that. So the question was, okay, so what do we do now? Because this is the situation. A lot of files are here where they're stored in the NPA. There at VGM building, there's a place where they store stuff. Based on the stories I used to hear, I was afraid to go there. I never went there. But stuff was stored there. So I simply said, you know what? With all these cases that you guys were investigating, I think Dramat must handle them. So I went to see
Dramat was heading
DPCI.
DPCI.
Because when the DSO was disestablished, the police then had to establish the DPCI. But because the Department of Justice was at the core of disestablishment of the DSO, I was intricately involved in that, in the design of the DPCI. They drafted the legislation, but we had almost like regular joint teams to discuss what the DPCI should look like, because there were different advocates for different models. We favored a model where the DPCI head would be at the level of National Commissioner and would report directly to the Minister of Police. There were debates in the police, there was a pushback, and the argument that won the day was that, look, you can't do that because the Constitution makes provision for a single police service. If it's a single police service, there must be one head, so you can't create two. We fought about it, but we looked at it, we're like, okay, no, it's fine. It seems to make constitutional sense. So that's how the head of the DPCI becomes a DDG level person. So we removed in the structure, in the design, the head of the DPCI reporting directly to the minister, and we put him under the, or her under the National Commissioner. But their function, we designed it in such a way that we tried as much as possible to retain the architecture of the DSO, to say they shouldn't be really the same, because the intention originally behind the DSO was always to have a specialist kind of unit, as many would know, a la FBI or Scotland Yard and that type of thing. But it just didn't happen that way for a variety of reasons. So that's how we end up with the DPCI structured the way it is structured. So when I got to the NPA, it then had to inherit when Dramat was, General Dramat was appointed. So I just drove quickly because they were next door to him and said, no, Chief, I didn't say Chief really, but I said, you know, we have this situation. I've got all these files, I've got all these things that I need to handle. I don't have legal authority over these things. I'm dumping them with you, starting with these vehicles. So I just asked the guys, drop these vehicles here. So we left them there. So he accepted, he knew the situation. He said, okay, no, I'll deal with this thing. In the NPA, Willie Hofmeyer was one of the deputies.
But was that a proper handover process?
No, there was a handover process that was
because
proper.
The way you are sounding, advocates,
no, okay, I understand.
Just went to Dramat and dumped the cars and say the files are there. You know, it sounds scary.
No, there was a proper process. No, I went to him. We arranged that the first order of business is that the vehicles we don't need. So, and he said, no, let them be dropped here, let them be parked here. We'll attend to them. So, in an orderly fashion, the officials of the NPA went and parked the vehicles over there. With respect to the files, we agreed that the DPCI must take over the files and that a designated person would be responsible for that. So in the NPA, I asked Mr. Hofmeyer, Willie Hofmeyer, to attend to that process. Why? Because it was natural. He had been there, he was head of the AFU, he knew all the guys that were in the DSO, as many as possible, they were comfortable with him. And I just thought, coming from the department, having dissolved and dealt with all manner of things relating to the DSO, it's best if I step back from the process. And I said, Willie, please take care of this situation.
Willie Hofmeyer was one of the...
He was one of the deputies. He was my deputy at the time.
Okay.
So I said, please take care of this thing, all the files, you know everything, whatever needs to be done, it needs to comply with the law and therefore move over. With that, there were fights. Guys in the DSO, now where do we go? The point was, you choose. You decide where you want to go. You can go to the SIU if you want. You can go back to the police if you want. The conflict, not the conflict, some of the difficulties some of them were beginning to experience is that they were in the police first. That's how some of them ended up in the DSO. When they left the police to join the DSO, they were junior in the police. In the DSO, they got promoted. Now, when they had to go back to the police, they had to go back at an equivalent rank. And they were immediately senior to most of their former colleagues by up to 2-3 ranks. And the police would have none of it. They were like, there's no way you're going to leave my junior and you're coming here, you are now my senior, and all of that. Anyway, it eventually got managed to say, look, there's nothing anybody can do, it must be done. Fortunately for me as NDPP, not my monkeys, not my circus. The police dealt with that matter on their own. The issue for me became those who wanted to go to the SIU, to say, look, we want to go to the SIU. And there were issues. Why you want to go to the SIU? Well, we're comfortable with this framework. So Willie Hofmeyer came to me and said, NDPP, what do we do in this situation? I said, let everybody make a choice and go wherever they want to go. Nobody must feel they've got nowhere to go. So because others were having difficulties in the police, the majority of the DSO guys went, well, not say the majority, almost 50-50 really. Others went to the police, others went back to the SIU. So that tradition carried through in the SIU. At the time, Willie Hofmeyer was in two positions. He was Deputy National Director responsible for the FU, and he was the acting head of the SIU. So he attended to that, and then they also attended to the transfer of files. But what they tried to do, which I got resentful about, was they initially didn't want to transfer the files. They said to me, NDPP, please sign these prosecutions. And I said, what prosecutions? One of them was, I think it was Busasa. They said, no, we've been investigating Busasa, can you sign off on this? So I refused.
Busasa?
Yes, Busasa.
Company?
Yeah, Busasa. I don't know what, I can't remember what it was before the name change.
Okay.
But there was something to do with it. So I said, no, I'm not signing anything. Why? We're ready, please sign this thing. I said, no. Why? Because firstly, serious suspicion. You know, I knew the kind of things that the TSO was accused of doing from many quarters, in the sense that as DG, the executive authority received a lot of letters of complaints. I got sight of some of them, others I didn't, but there was a general complaint about the TSO. The nature of the process of removing the NDPP at the time was also quite a contentious and very unpleasant process for everybody, for a variety of reasons. Within the cluster, the issues that we discussed there of a national security nature, to the extent that we could discuss them over there, others would discuss them in a closed forum under the National Security Council of DGs. Really unpleasant thing. So when somebody or some people come and say, please sign off on this prosecution, I was like, I'm not signing. These were memos and so forth. So I simply said...
Let me just ask something,
yeah,
and clarify. When you say that you wouldn't sign on the basis of what was being said, wouldn't the responsibility be to sign on the basis of the docket and the merit of the case? Would you have looked at the case itself rather than what everybody is saying, the JCPS? Because, I mean, if you come to us, even today, if anyone asks me about a case, I'll have a view. But I don't know the content of the docket.
Yeah.
Now, the NDPP would have to make a base decision on the basis of information inside the file.
yes.
Now, I get worried the way you are classifying your
Yes.
reasons for this.
No, that's correct. No, that's correctly that. Because when I then asked questions, well, it was the manner in which it was being done as well, in the sense that, you know, there's no formal meetings being set to say, look, let's meet and discuss and look at all these types of things. It's talk as we attend to other things. You need to sign off on this or sign off on this. So I simply said, I'll gladly sign. One problem. These matters are not ready for prosecution. You guys are still investigating. Yes, we're still investigating. So I said, well, on that basis, I can't sign anything that is not going to start a prosecution. These are matters that are still under investigation. You're not finished. I don't know how far you are from being finished. So I don't have authority over investigations because the NPA no longer has investigative capacity. So please take these to Mr. Dramat. Well, I didn't have them with me. They didn't give them to me. They just mentioned them by name. I said, please take all of those files, take them to Mr. Dramat with all the trunk, I can't remember what those things are. That's where this stuff, documents, things were. I said, no, take them to Dramats. They'll attend to them as a DPCI.
Maybe let me re-ask the question. So are you saying at that time where these files were brought to you, you had this inclination or you believed that these colleagues were disingenuous, were not genuine, were acting irrationally?
Correct.
By bringing this because they had not done, and they were rushing to bring it to you so that the files don't go to the other side?
Correct.
Which shouldn't have been, and that's the basis.
Correct.
Is that what you are saying to
Correct.
us?
Yes, I was very suspicious of that.
So they were
particular
dishonest
process.
in their conduct? Because
Well,
if they've done that, that's dishonesty.
Well, I'm going to be very careful about my wording because last time some suggestion of that nature was made, I said, yes, I got into big trouble.
Oh,
Let me put
okay.
it this way. We'll deal with it, Minister. The issue was, can I go a step back? Let me go a
Yes.
step back. What was the problem with the TSO? The problem was simply this. The legislation of the TSO gave the TSO intelligence capacity. So they had a mandate to gather intelligence. The problem operationally is that there were then multiple agencies in the country that gathered intelligence. And on the ground, they couldn't work very well together. There were various suspicions for a number of reasons, mostly historical, pre-1994. people on this side, new people on this side, they didn't trust each other. So all those legacy issues found expression in the actual work of these institutions. And because of that, you know, it was so bad and so difficult that in one incident at the airport, we got a report as the cluster that the DSO and the police agents who were undercover following some suspects almost shot at each other because they didn't recognize each other, that they're after the same target. And the question was, but once you're talking, why are you after the same people and not know about it? No, it's because these guys work with this way, these guys work this way. So it became ugly. It got to the point where the president at the time appointed the Gampepe Judicial Commission of Inquiry to look into the manner in which the DSO was dealing with intelligence issues, because it had reached a point where arguments were made that there is a national security problem because of these kinds of issues. Those who were closest to those issues, I didn't. Those who were closer to those issues, it was NIA at the time, together with the Secret Service. There were still two at the time before they were amalgamated and they've now been separated. Those two DGs there raised these issues with the crime intelligence and the police. Also, DI got involved in it. But that whole mechanism of trying to explain to the executive what kind of problems were there with these kinds of duplications led to that point. So again, as the Department of Justice, we took responsibility for supporting the Commission of Inquiry. My officials provided that. The minister was responsible, obviously, to make sure that the commission functions properly, attended to her responsibilities accordingly. And evidence was led and all sorts of things. And the Gampepe Commission reports came with an acknowledgement that indeed there is an unsatisfactory manner in which intelligence information was being handled by the DSO. And primarily, some of the allegations were that they were infiltrated by foreign intelligence and they were continuing to work in an unauthorized fashion, or at least in a way that it wasn't through protocols as intelligence environment would require. They were doing these things on their own. Their argument was, read our law, we have a mandate, we could work, amongst other arguments. The long and short of it is that by the time I went to the NPA, I was aware of all of these things and the fact that some of the people complained about were in the NPA and how they were managing things. So by the time Vili and some of his staff made these suggestions, so they didn't bring the files like this, Minister. We're just talking to say NDPP, there are files, they're over there, you can see them if you want to see them. They need to be signed off on for prosecution. So for me, I was like, no, red flag based on what I knew. But the cleanest way of dealing with it and to say is that, you know what, they're just not ready for prosecution anyway. So let them go to, and that's how they moved over to the other side.
I think Mr. Mtlung has got a follow-up on this matter.
Thank you, Minister. Advocate Semilani, I just, on riding on the question by the Minister.
Yeah.
And it appears that you relied on a verbal report in terms of a request to sign off. Wouldn't it have been prudent of you to seek or to request the docket or any documentation just to satisfy yourself? I understand the issues around mistrust and so on and so forth. But as the head, wouldn't you have perhaps insisted on satisfying yourself, particularly taking into account that you considered the process, or rather the investigations to still be ongoing? The investigation was still ongoing at the time, according to the report, the verbal report.
Yeah.
But you did not satisfy yourself.
Yeah.
Was it not prudent of you to actually go further and obtain all the necessary information to satisfy yourself that the decision that you were making was the correct decision?
It was the correct decision. It became unnecessary to even go that route for the simple reason that to the extent that matters were still under investigation, the NDPP has no investigative authority by law. the NPA has no investigative authority by law. There's nothing further for the NPA to investigate in a docket in the manner that those matters still needed to be attended to. So those matters were matters that were supposed to be handed over in a formal handover to the DPCI for further investigation. It didn't even become necessary to even go that route. In fact, it would have been improper to even go that route, because what authority would I have been exercising in law? These are open dockets under investigation. What would they be doing with the NDPP? What law would you be using to look into them? So these were just unfinished matters. They needed to go. That's why for me, even the suggestion that I look into them was annoying. Like, no, I can't. I mean, what do you think I am? So that's how we did it. So that became unnecessary. So I asked Mr. Hofmeyer to just attend to the necessary and do the handover. I delegated the process to him. So he attended to that in the normal course.
Was it the head of DSO who said you must look at the file, or was this investigators?
No, it was Mr. Hofmeyer.
It was Mr. Hofmeyer.
Yeah, he was handling the process for me.
So he was handling that, and
Yes.
then he says, no, I've got this file.
Yes.
I need you to sign.
No, not this file. We've got these unfinished matters.
Okay.
Yes, they were in boxes or in trunks stored somewhere. They didn't bring them to me, but he wanted to say some of them need to be looked at and you may need to sign some of them. So when I asked, okay, what would need to be signed, what's happening, what's the progress, these are matters that are under investigation. And
So not like prison, so all of you didn't go file by file?
No.
Because ordinarily you'll have to go through the file and say, this is file so-and-so, like Busasa. How did you know the Busasa one?
They mentioned it.
They mentioned,
Yeah, they
to
mentioned
say
by
one
name.
of them is this.
Yes, they mentioned
And
by
then
name.
amongst others.
Yes, they mentioned
And
by
that
name.
one they were saying they are ready to go, please sign.
Yes.
And you said, no, I can't sign.
Yes, because the patent,
You asked-
when you ask a few questions, they say, no, we're still investigating, we still have to do that. Like,
Oh,
so
okay.
why are you asking?
So
You
it
know?
was on the conversation that
Yeah, it
you
was on the
started to say,
conversation.
okay, you want me to go and get those files. Therefore, but are you done with your work? And then they say, no, we're not
No,
done.
we're not done, yes.
We were still investigating.
Yes, precisely.
Okay.
Then I said, no, then if that's where you still are, then we shouldn't even be having the conversation.
Okay.
So in essence, then, Minister, that experience, I take it that the part about the removal of the NDPP, the general inquiry, I want to deal with later, because that was when I was DG. I know it came up in the objections. I don't know if you want me to deal with it now. Or?
Not yet.
Okay, no, that's fine. Segment. No, that's fine. Okay.
Remember, we're looking at, sorry, my apologies. We're looking at your tenure now.
Yes.
As the NDPP.
Yes.
Compared to all the other candidates, you're the only one who has been
Okay.
even at that. So others will look at them from where they've been in the NPA and their role. So we're wanting you to tell us, why must you come back?
Okay.
You've been the NDPP, what is it that you have done? So your career that time, your tenure that time.
All right. When I got there, as I said, I already had a pretty decent idea about what's going on in there. One thing that which one am I going to start? You get there are deputies, and then you have one deputy in charge of NPS, National Prosecution Service, one in charge of AFU, one in charge of this. So
You had three deputies. The law allows for 4
I
maximum.
think I had 3 at the time. I don't remember 100%, Minister,
Okay.
but it was AFU, it was
AFU,
NPS,
NPS.
it was Dr. Ramaite was there. I can't remember what you were responsible for. Yeah, there may have been 3 at the time.
You found them there.
I
You
found
were
them there.
one, and then you got appointed.
Yes, then I got appointed, yes.
And then you replaced yourself. Did you eventually get
Yes,
replaced
if you want to put it that way, yes.
in the 2 years?
Yes, indeed.
Okay.
That was the order of things. So when the issue was like, okay, most senior staff, so I need to have a meeting. So I was told, no, you're going to meet the deputies, and that's the exco of the NPA. So we had our first meeting, but I looked at it as like, okay, so where are the DPPs? They said, no, DPPs are not part of exco. They answer to the deputy in charge of the NPS, and you get your briefings via the deputy head of the NPS. So I looked at that with a squint, and I said, I don't quite understand this because I didn't understand the law to be this way. I said, if you look at the Act, my understanding is that the DPPs are the ones in charge of their areas of jurisdiction. That's what I know. So, and they are the ones who institute proceedings to prosecute or not. You know, the NDPP has the power, but hardly does. You know, it's very rare. But the law authorizes the DPP. So why would they not be here? They said no. The NPS head does it, and I said no. To me, this feels a bit uncomfortable in the sense that structurally it just doesn't feel right that people who are responsible, with primary responsible for taking initial decisions, and that as the NDPP I have authority over, I should hear from them via a third party. So I said, look, it's fine, I don't have a big problem, but I'd like to change the arrangement. From now on, the ExCo of the NPA would be the NDPP, supported by the deputies, and all the DPPs. They must come to ExCo and explain how they function in their areas of jurisdiction. Deputies didn't have a fundamental problem with it. There's a bit of uncomfortableness in it. I said, you know, we'll all see the benefits of it. So the first ExCo with the DPPs present went very well, and everybody was happy. The principle was, you are in charge of a jurisdiction. It's what we called it was, it's a federation kind of environment. You do by law what you're empowered to do. That's your business. I'm not too interested in it. But you come here and you account for whatever you have done or not done. So I expect you to brief me directly. Then I realized that there were no performance agreements, because the question was, okay, how do these people report? So I insisted right there and then. I asked one of the SPPs who was assisting me to say, please take the performance agreements of my former DDGs in the department, have a look at them, and create for me a performance agreement that I can have with the deputies and the DPPs, because I need to find a way of managing it. So that's how I introduced performance agreements at that level in that environment. Then I turned to other things. I think I've got here some of the stuff that I did. What I then found as well was that there were a lot of legal issues that came to the NDPP. And I asked around to say, who handled these things, process them before I see them? Because they were coming directly from various offices and the PA and that type of thing. And it became a bit unclear. So I established what is called LAD, which is the Legal Affairs Division. I said, no, but I need some lawyers. Let me get a few guys from within who are legally qualified. Can I form a small unit to be Legal Affairs Division? And I got me Advocate Gerard Nel, who was there at the time, to basically, was the most senior, was an elderly gentleman, to go on retirement. I said, because he's an elder, can he just supervise these youngsters and be in charge of LAD? Basically, their job was to get all material that is distinct for the NDPP, have a look at it, and advise from time to time on legal issues. So I established that unit. It exists. I think now it's headed by Special Director, Mr. Advocate Maga. Then, as part of the discussions, one would then get informed, obviously, of a number of complaints about your typical labor relations complaints and complaints about officials. And I got to learn that there was a unit called the Integrity Management Unit that was tasked with investigating NPA staff generally for any alleged transgression. So one looked at it, and I got to learn that there'd also been discussions about how that can be improved. So I looked at the Act, and I realized that there's actually a provision in the Act for kind of like an inspectorate, a body that would investigate the conduct of prosecutors. I think it's, I think I provided these documents, if I can just remind myself quickly. It's a complaints mechanism that would be established. It's provided for in terms of, I think it's section 22.
Is it the Office of Ethics and Accountability?
That's what they call it now, but at the time, we were calling it a complaints mechanism. You know,
Okay.
We're still initial stages of creating it. I don't know how it currently functions, but the IMU, Minister, would investigate anything, like in any department with an internal investigative division. That's what it should do. So this one dealt with everything. But what Section 22 of the NPA Act envisages in mind, has in mind, is a different kind of body. If a prosecutor commits misconduct in the course of prosecution, who should investigate that prosecutor? At the time in the NPA, it was the IMU, the Integrity Management Unit. But if you look at the legislation, it suggests something different. So what you have is that you have officials in the IMU who may be labor specialists or specialists in something else, effectively investigating the conduct of a prosecutor. So basically, they're investigating the conduct they don't understand. That, for me, was a problem. You can't investigate a function you don't understand because you're not qualified, you're not a prosecutor, but you're investigating whether or not a prosecutor acted properly or not. So the Motoso case, for example, would have been a case to be investigated by another prosecutor to assess on a peer-to-peer basis whether the matter was handled correctly or not. If it is not investigated by that kind of person, you're not going to get an accurate account of whether something wrong happened, because all you're going to get is somebody who doesn't have the same appreciation of the issues, doesn't understand how a prosecutor thinks. So if you're to be asked the question, what made you not call this witness? A labor relations practitioner would hardly have a clue how a prosecutor would have exercised a discretion to not call a witness or rely on this evidence or that evidence. Only a fellow prosecutor or lawyer at least would be in a position to ask the right kind of questions. So this is what I was then pushing for, to say, no, we need a complaints mechanism. And the document I provided were the initial stages of a consultant report towards what that complaints mechanism body would look like. So by the time I left, we hadn't quite yet finished with it. But we had engaged on some drafts, and I'd already indicated to the minister at the time that something of that nature was coming up. So that's that. And then as you work, you go and you meet units, specialized units were there. One of the things that also was brought to me, to my attention, obviously I knew about it, was the work of, continued work of the specialized unit. So one of the things I asked was, let's start with the SCCU. Who's in the SCCU here at HQ? And I was told there was a special director. I'm not, if you don't mind, Minister, I'm not going to name his name. He left the NPA. He's there. If I recall correctly, there was Advocate Breitenbach, Glenis, and there was somebody else. So it was like 3 people or 4 people or so. So like, okay, what do they do here? And like, no, they handle SCCU cases. It's like, okay, what are they doing that for here? Because the SCCU, as I know it, is in the areas of jurisdiction of the DPPs. In Pretoria, Advocate Mzinyati had his SCCU unit. There's an advocate there who's in charge of it in Joburg. There's another deputy director in charge of the SCCU in Joburg. So what is this SCCU doing here? What kind of cases are they involved with? Well, they call it cases, they have a look at them, and decisions to prosecute are made here, but they work very closely with these officers. So for me, I became uncomfortable with that approach, because like, okay, if you're here and you take decisions to prosecute here, what happens to the DPP? Does the DPP know about it? So yes, we engage, we know, we discuss. Long and short of it, I'm uncomfortable with it, I don't like it. If there's going to be dockets taken from heads of SCCUs for whatever reason, whether for thorough check or whatever the case may be, and they come to headquarters, which is basically my office, the NDPP office, and out of that check, a decision to prosecute gets made there, then I'm not going to have it, because what it means is that my office and me basically is making a decision to prosecute. And the problem I would have with that is that you are excluding the DPPs from that decision, even if you talk to them. They are the ones who should run these particular matters, make decisions. My powers will largely be review powers in terms of 179. So I'm feeling uncomfortable. It said, no, this is how it's always been done. It's not it's not an issue really. The DPPs really know. I said, I don't understand. I don't have a problem with it. I get it. I just don't like it, and I don't want it. So my suggestion is that these measures that are here, there are not so many as well. I said, please take them back to the relevant jurisdictions. But if you want to work on them, you could stay. But if you want to work on them, then I suggest you go and work on them in the relevant jurisdiction. So you can go to Pretoria under Mr. Mzinyati, or you can go to Gauteng under Advocate Kanyile, acting DPP. So
maybe just to ask there as well, was there a review that you had done to evaluate the work of this team to see if, based on head office, yes, they are there doing the work they've done, obviously, before you arrived, some work where you presented with like a review to say this is what, so that when you almost implement restructuring,
yes,
which you're saying that they must, yes, go to the provinces.
Yes.
Therefore, you would have seen that it has value. What was the basis, yeah, of that conclusion?
The basis was purely legal. Mm-hmm. It was purely legal to say, in the past there may have been decisions taken, but in my time, I would not want to be the one taking a decision. So if my predecessors were comfortable with it, that's also okay. I don't have a problem with it. But I have a difficulty with it because I see a legal problem, at least coming up in the sense that, firstly, one, I would be undermining, or I'd be appearing to be undermining the DPP's consent. And most of the cases were largely Joburg and Pretoria. There may have been one or two from other jurisdictions. So I don't want that. Let them handle the cases and deal with them themselves.
But when you say legal, Advocate Simelan, are you saying, because legally you are giving an impression that your predecessors would have taken illegal decisions by having those. There was nothing in the Act or in law that did not allow for that. You just felt uncomfortable to have it. Am I correct?
Well,
but in law, legally, there was nothing precluding the national office to have such an arrangement, to have that team operating.
I wouldn't say in law there would necessarily be nothing preventing them, because I know that the national director can institute prosecutions. But what that informed me about was that these were cases that basically collected as part of monitoring the SCCU units. They would monitor the statistics, all of that stuff, and then when they see in the statistics and in the reports a matter that they felt it's necessary to have a further look at, they then ask for the information and the docket and they have a look at it. So my argument was, well, when you do that, you can't either take decisions here of a prosecutorial nature, let those matters go back to the offices that were responsible for them. And I did have discussions, informal discussions in the offices, and everybody understood that to be, that's just how things are. There's no issue. Then when I said, well, I wouldn't like this, Ms. Kanyile, Mr. Mzinyati, I'm going to have these matters sent back with the people that want to handle them, if these guys were handling them. If they don't want to handle them, you'll then reassign them, and I'll see what I do with them at HQ. That's effectively.
So you disestablished it at that time? Because we do have Kanyile heading the SSU.
No. Kanyile was the acting DPP in South Gauteng.
No, I'm saying now, it's Kanyan, it's SDPP. Special Director, Public Prosecution.
Ms. Kanyane was there, she remained in my office.
No, I'm saying you disestablished, I'm just saying currently, this unit is back into national.
Yes,
it's also existing.
After I left, they reversed my decision. My decision was reversed.
That's the context I was saying to you. There's nothing illegal about it being in national. Because before you, it was there, you felt uncomfortable and said it must go to the provinces.
Yes.
After you left, it was brought back.
Yeah. There's nothing illegal in that. You can have it there to analyze statistics, because you get all manner of information. There's analysis, there's strategy information, you analyze, and if you're specializing in analyzing SCCU information, That was never a problem. I said, I don't have a problem with it. Where the problem comes in is when you're then going to have a docket that you're going to be looking at and investigating and deciding on the docket here. But if you're analyzing information, it's no different to analyzing normal prosecutorial statistics for purposes of informing strategy, planning, measuring performance, as the case may be. So that wasn't a problem. All that moved were the actual dockets that were there at the time. Yeah. So I did the same thing with soccer to say, to the extent that there's a sexual offences unit where prosecutors were there for purposes of taking decisions on prosecutions that were in the Tutuzela care centers. I said, you shouldn't be here at HQ. You should work in a Tutuzela care center and take decisions there. Here, you can sit and analyze information and do all of those kind of things. So what I then did was I put together a memorandum, submitted it to the minister with a recommendation that this be done because only those kind of things can be approved by the minister, at least as a final decision. I submitted that and there was an approval and it was implemented. Yes, there were people who were unhappy with it. There were, in fact, the special director at the time said to me, well, I'm here, what am I going to do? I analyze, if you're saying I must go to the DPP office and run a prosecution, I haven't done that in a couple of years, I'm happy doing analysis. My argument was, I don't have a problem. You can be around as long as you don't take decisions to prosecute. Also, don't have a problem. You can pick and choose where you want to go and work. I really don't mind. That is not the issue for me. The issue is I want to be protected so that as the NDPP, when I have to make decisions to review when representations are made, I don't want to be put in a situation where I can't do that because an earlier decision had been taken in my office or had been taken with my knowledge. Because if I did that, the way I saw it, if I was part of taking that prosecutorial decision, or it was taken under my authority in my office, and then a party put representations to the DPP and escalated them to the NDPP, I'll then be functus officio because I would have been part of the initial decision making. So my view was that let me protect myself from this and take a step back and allow the DPPs to work. And part of the reason was that when I engaged with DPPs, as we did in EXCO, I learned that they had been uncomfortable with not being part of EXCO, that they were uncomfortable. They were more comfortable that they were part of the executive committee and reporting directly to the NDPP themselves. They were always uncomfortable reporting to somebody else who would speak on their behalf to the NDPP. They felt that they could do that better themselves as the primary people responsible. So it resolved itself in that sense, but I was able to manage the relations between the officials. Fortunately, they were all really good people. There was no issue at all. The matter resolved itself in that way. So that's what I did at that particular time. Then there were a couple of cases that we handled. Handled in the sense that the nature of my relationship with the DPP's minister was that you do as you please. It's your job, it's your power. All I do is hold you accountable. There's a performance agreement. If there's a complaint about you, that's where I come in. But you take all the decisions. There are certain matters that are referred to as high profile for whatever reason. I never understood why. It didn't really matter to me. But you make those decisions. But if you want my support, it's in your interest to keep me informed and briefed so that I know what you're talking about. And if the NDPP were asked, I need to be able to also respond and give the most accurate information. You exercise, I either refer the people to yourselves to talk to the issues, or if you want my support with whatever decision you make, it's better we have a relationship where we brief each other more often. More often as in more than the scheduled briefings of EXCO meetings once a month. So some DPPs took that up, others really didn't. It didn't matter, it didn't affect our working relationship. As part of that work, let me just find these cases that I mentioned so that I deal with them. What I used to do, the question then was, okay, what does an NDPP do if you're sitting in your office and the DPPs are doing all this work by themselves? So I had to think about what the best way would be for me to not only keep myself busy, but try and identify things that would be critical to attend to. Now, I'm just trying to get my files, if I can have your indulgence quickly. So what I would do in the mornings, I would read the newspaper. I read the newspaper, and then I finish reading the newspaper, pick up something that comes up that would be of interest, and follow up with the DPP office.
Okay.
One of the matters that was in the front page of the Sowetan one day was a matter of, over the weekend, some young people had allegedly been drunk and allegedly had taken some drugs, and they decided to race cars in Soweto. And during that process, they, because of their condition, they ran over some pedestrians. I think one or two, if not at least one, pedestrian died as a result. Another was paralyzed. So I took that and I immediately called.
Is that the Jub case?
Yes, the Jub case. I immediately called the acting DPP in Joburg. I said, "Have you seen this newspaper?" She had it and said, "Okay, let me just get it quickly." And she got it. Says, "Yeah, I see it." I said, "This is a problem. This is interesting in the sense that the way this thing happened, how can you drag race in Soweto? I can't imagine what street it would have been in Soweto. I'm not a Sowetan person, but I've been in Soweto. So I was trying to imagine where they could have done this. So I requested, I said, "No, Oli, can you send a prosecutor there, find out which courts these guys would be appearing in? And let's find out what happened and let's talk about this, because for me, this is murder. We should have this as murder." She said, "Murder, really? Okay, no, it's fine. Let me go have a look and then we'll discuss." So
You were having a discussion with who on this matter?
the acting DPP in
Okay.
Gauteng. So she went to speak to prosecutors following their process, and then we started having a discussion about it. And the question was, "No, but it's not going to be murder, because generally in drunken driving, we charge with culpable homicide." I said, I'm not so sure. We had a long debate about culpable homicide. I said, "No, I'm not so sure. I'm not convinced. If what is reported is correct, that the individuals drag raced, it means they must have had a conversation about racing. And if they had a conversation about racing, it means the race was intended. It was intentional. It was an intentional decision to race from one area of Soweto to another area of Soweto. So for me, that is intention. Why would you say it's just cup?" So I said, "Well, it's never happened this way. It's difficult." So I said, "You know what? Perfect to do a test case. Let's do a test case with this. Let's charge them with murder as a first charge, so that if we fail on murder, we get a competent verdict of culpable homicide instead. Because if you charge with murder first, or culpable homicide first, and you don't succeed for whatever reason, you have problems." So we discussed, and we're like, "Okay, let's do a test case," because all the elements were there. It's the kind of case in law, if you want to test the law and have a test case, the general rule is that you must find the best facts for that to do. You don't use difficult facts, because it doesn't work very well. Find the perfect set of facts, and then you can go and test your theory in courts.
At this point, Advocate Simelane, you are having this discussion on the basis of a Sowetan report.
No.
Not what
This was now a couple of
investigate-
days later, because
Okay.
there had been further engagement between the prosecutor dealing with the case with the police and all of that stuff, getting information, statements from people. But
Yeah,
the
because you didn't mention that. That's why I'm
Oh,
worried.
okay. No, I understand.
Because you're saying you saw a headline
Yeah.
on Sunday. You called the acting DPP
Yeah.
to say these people, if they drag race, as the report of the Sowetan says, therefore it means
Yeah.
it could be. And that's why I'm worried about that basis.
Oh, yes. No, I understand. No, this was a couple of days later, as I was getting more information about what happened, number of people involved, who the individuals were, where they were coming from, what is suspected is the drugs that they're taking at the time. But the principle about how we would consider approaching the case, yes, I'd looked at this Sowetan to say, based on what is reported here, I think we can start looking at this principle. But when all of that was done and the information was ready and docket was ready, we then tested to say, please have a look at this and have a look at it and let me know if it is indeed the kind of case where we could have this test case. So they looked at it and said, no, actually we can. There was additional information subsequent to that they obtained, eyewitness accounts, some of the people and the friends who were there. Their account of information strongly suggested that there was an element of boasting between the parties about who drives better, who can race better, and all of that stuff. So it fitted the elements. So the conclusion was, okay, we'll try it and use a test case for this purpose. And it went, and fortunately the conviction went very well, and the rest is history vis-a-vis those individuals.
I want to move on from this segment. You still have something that you want to say?
Okay, let me be quick. I then dealt with because there's 1, 2, 3, 4, 5, 6 cases that I specifically was involved in that may be worthy of mention. Then the second case was what was referred to, I can't remember the name of this case, but State versus somebody else, but it was referred to in the media as the Naomi Campbell Diamond case, if you remember that. The issue about it was that somebody had been given by the supermodel Naomi Campbell a diamond, and it was alleged that Naomi Campbell or somebody had obtained this diamond from Charles Taylor in Liberia and so forth. It became a public ugly thing. Now, the interesting in this case is that, well, it was in court. Then it was going to run, and I received representations. I received a call from the late advocate George Bezos. He said, Menzi, we knew each other. He knew me. He knew my dad, and he knew me. He said, Menzi, I need to see you about this case. I act for this individual. And I said, no problem, Mr. Bezos. Whenever you're ready. He said, I'll come to you. He came.
So he made direct representation to you without the DPP?
Yes, he came direct, yes, without the DPP.
Shouldn't they have gone to the DPP?
Yes, well, they would have. I think they did, in fact, go to the DPP, but he first wanted to speak to me about the case to let me know that he's involved in this case. I said,
so before meeting the advocate Bezos, did you ask for a report or meet with the DPP to understand? Because my understanding of the process is that representation will be done with the DPP. You will be the reviewing process, isn't it? If the decision by the DPP is asked for you. So in this case, you are saying to us, Advocate Bezos comes to you directly, having not gone to the DPP.
Correct.
To afford the DPP a decision-making process which is allowed by law.
Yes. He was not asking to make representations. He was asking to see me about the case. So almost like a meeting, but not really a representation. So I said, no problem, we can come through. Then I arranged for one of the...
In the middle of a case, which you could have powers to review, Advocate Smelan.
No. For now, I was just asking for a meeting. So the question was, okay, I hear you're representing this individual. We can meet. So for me, I was curious to say, okay, what does he want to say? Let me hear him out.
You were aware that he's representing an individual
he said so.
On a case that is before court.
Yes.
And your DPP has not come to you to say we want to engage. What was the basis of you agreeing to that meeting?
Yes, I did inform the DPP that there's going to be a discussion. I'm going to meet Mr. Bezos. For now, it's just to hear what he has to say, because I don't know what he's going to say. The matter wasn't running in court yet. It hadn't started running in court. I think there was an appearance already, and I think the gentleman was given bail or something like that.
The case was before a DPP who had made a decision to prosecute.
Yes.
But don't you think that is irregular?
No, it's not irregular, Minister. What I then did was I then asked the prosecutor...
You know why? Let me finish.
Okay.
You just said to us, you decided to remove the soccer. You decided to, because you felt that you didn't want to undermine your DPPs.
Yes.
You wanted to ensure that the powers of prosecutorial decisions are with the DPPs, not with the NDPP. So if the dockets are sitting with you at national, it would have meant that you are undermining your DPPs. Therefore, you wanted the dockets to go to the provinces, to the DPPs, for them to make a decision. Now, in this case, the docket is with the DPP. A representative of an accused is requesting to come and see you while the case is being dealt with by your DPP. Isn't that not an undermining of your DPP, which you intentionally, when you arrived, felt that you needed to give them powers? Was it not counterproductive for what you were doing and what you saw as a vision of your tenure?
Not at all. This was purely going to be a meeting to say, okay, we are going to meet. What do you want to discuss? What are the issues? What I then asked for from the DPP was the prosecutor who was dealing with the matter to say, because there's somebody who's dealing with the matter, can somebody be here so that also I'm not alone? So I want somebody to be here with me so that we have this particular meeting, which did happen. So there was a prosecutor there who came, and Mr. Bizo said, you know, are you going to proceed with the prosecution because we are going to be making representations about it? So I said, no, it's fine, you can make representations. What is the issue of concern? Then what he indicated was, well, you know, for us, we would argue that this matter should not be prosecuted. Then a debate, why should it not be prosecuted? He made arguments to suggest that it's de minimis, you know, we're going to be making.
At the stage, you are now engaging representation.
Yeah, he's starting to, yes, you know, he did. He's starting to say, well, this is, we think it's de minimis. So I said, well, I don't think it's de minimis, and I don't agree with that. My suggestion is that we're going to proceed, you guys will do whatever you want to do and make the representations. Then he left on that basis.
I've got colleagues who wants to follow up. Prof, and then advocate, the two colleagues.
Thank you, Chairperson. Advocate Melania, you invoked something when you were making changes to your office that you wanted a federal type of arrangement.
Yes.
Which expressly would mean you give your deputies direct power. So by accepting this invitation to meet from, you know, Judge Bezos, was it out of respect or was it out of what? Because surely when you already know that the case is being handled and he'll be representing the other side, you would have known through your judgment that there's no way the person is going to just come, sit, and you chat around this particular case. Because this seemed to be counterintuitive to the very logic you introduced when you were making changes.
No, I don't share that opinion. I don't share that view. As NDPP, I met a lot of people who would ask for meetings about many things. Others would want to just share their views. My condition was, of course, not a problem if you want to meet. Obviously, one would create the appropriate framework for it. In this case, I'd made the DPP know that there was going to be this decision, and the prosecutor involved, can he be there so that we can listen to what is being said, and then we'll find out what is being said and then take it from there. So indeed, it was partly out of respect, but he's not the only one with whom I've met with prosecutors. But it was really to hear what the issue would be. So beforehand, I didn't know, but when he came, he said, well, this is what they would argue in their representations. Then I said, no, it's fine, then I'll deal with those when they come, but I'm not inclined to not want to have the matter go ahead. And then the meeting ended on that basis.
Thanks, Minister. Good afternoon, Advocate Miller. With all things considered, me and you would know as part of the other lawyers in the room that there's a good reason why we create a rule. And the reason we create a rule, we would expect it also to be followed, probably hierarchically by everyone. Your expectation when you were at NPA would have been that a public prosecutor at a district court would not willy-nilly accept representations without the participation of the SPP or at least your DPPs in the provinces until either the decision is then reviewed by yourself. And that's a rule you made. Wouldn't you have been comfortable that nobody would have gone against that rule?
Would I not have been comfortable if?
Would you have been comfortable, rather put differently, if anybody went against that rule? Say, for instance, somebody started with the DPP and went back to the prosecutor down there without that prosecutor and the SPP having had an opportunity to make the decision on the prosecutorial nature of the matter that is before them.
No, in the sense that on the ground, people would speak to anybody. Representations are made formally,
Yes,
generally, right?
true.
So when they're made formally, they follow the process.
Yes.
But outside of formal representations, people want to meet to explore attitudes. Sometimes they would say, look, we just want to explore an attitude. We want to consider raising this issue or that issue or that issue. This was that kind of meeting to gauge what your attitude would be to issues that we would want to raise. So come and raise those issues. But it's not the formal representations, because remember, the formal representations, more often than not, they are written. So this was not a case where there were written representations that needed to come.
No, it's fine, Advocate Miller. I'm making a simple point of a simple principle of a rule. And I want you to take us into your confidence that in receiving this meeting request from Advocate Bezos, as he then was, in his lifetime, you were not creating an opportunity to be clouded. Because at the time that Bezos calls you, it's not that the case is not yet in court. There has already been an appearance. He tells you even over the phone, Amka, I want to see you. I'm representing this person. From that moment, doesn't it occur to you that then Bezos is using proximity to you in order to get this possible added advantage? Does it not occur to you at the time? And I'm just looking at it, colleague, from a point of hindsight.
No.
I mean, you took the decision at the time. You can't undo it now. So reasoning it may not need to be on the basis of, do I think I was wrong? And that's how I'm looking at it.
No. On the principle of the rule, you are correct. But no, I didn't see it that way.
No, that's fine.
I spoke to the DPP.
No, that's fine.
It.
Thanks.
Mr. Mutlu.
Thank you, Minister. Advocate Similani, the challenge I have as well is that what you were avoiding in terms of you having to disestablish that arrangement, the arrangement that you found to be uncomfortable. The basis of that, according to you, was to avoid being functus officio. Now you get a call from Advocate Bezos, and on the basis of that call, an arrangement is made and a conversation takes place, and you actually expressed a view in that meeting, where your view is that there is a case to prosecute, and you are not going to accept the representations, irrespective of whether they are formal or informal. But you took a decision then. So in that way, if Advocate Bezos was to proceed with a formal representation to the DPP, you would, and the DPP takes a decision that, or a view that they are proceeding to an extent that he would have to escalate that decision or challenge it to your office. You would have technically excluded yourself from the process and created a situation, an environment that would be unfair to the person who was making representations. Thus, you would become functus officio, a situation that initially would have
Not wanted to have.
avoided. You agree with me?
No, I don't agree with you because I don't share the way you're characterizing that meeting. As I indicated, all that was indicated at the time is that I just want to discuss this particular issue with you to raise certain propositions about how we intend to approach the particular matter, right? We want to see if we can see you for that purpose. So I said, yes, you can come. I could have said, no, put everything in writing. So I said, no, it's fine, come here, if you want to come here. So that's how that meeting was. It wasn't a meeting in which that kind of discussion would take place. So it wouldn't follow the logic that you are submitting.
But then you make a request through the office of the DPP that the prosecutor handling the matter must come along to discuss the merits of the case.
No, not the prosecutor handling the matter in courts. It was a gentleman, I don't want to mention his name here.
But to discuss the merits of the case?
Not the merits of the case, to be there with me so that I have somebody else with me, at least who's familiar with the case.
Yes, to discuss familiarity with the case, to delve into the merits of the case.
It was not to discuss the case. It was to hear. Remember that not indicated what proposition they would want to take forward or what they would want to argue. So I said, okay, I'll hear you. It was only when he had arrived that he said, we want to make representations and we would want to make representations in terms of which we're going to argue that this is de minimis.
Yes.
Yeah.
And you took a stand there, a position then that that issue was not de minimis, that in actual fact you would, the prosecution will proceed.
No, I said I would not deal with that matter on the basis that it would be de minimis. The matter will go to court and be dealt with there because that's where it already is.
So had this matter now been formally, or those representations, if they were formally presented again to you, would you have considered them, or would you have been or become or rendered yourself functus officio?
No, because there would be no decision. To make a decision as the NDPP, I would have to formalize it. So what would have happened if, to follow your logic, I would have had to say, let's say he's there, say, let me hear you. Goes into the full details or the merits and all of that stuff. I would also then need to know what is in the detail of that particular docket. At that time, I didn't know. I would need to be on all fours on that particular docket and then formalize a decision in the way of writing. So all of that was not even in question because at the time, I didn't know the details of the...
So just to avoid dialogue, so you considered that decision to be an informal decision that you communicate or conveyed to Advocate Bezos?
No, it's not even a decision. I mean, it's simply saying...
It's an expression of a view.
Yeah, that I guess I would need to be involved in the matter at that stage, yeah. You can call it that, yeah.
While other colleagues are coming in, Advocate Simela and I have a difficulty here.
Good time. Oh.
You call a person who's involved in a case. If it was just listening, why didn't you take somebody from your office, in head office, to sit with you to listen? Why particularly you had to call somebody who was familiar with the case, coming through from being there to sit in the meeting, if the intention was not to deal with the case itself?
No, the gentleman is in the NDPP's office, but I'd asked him to go and speak to the prosecutor at the court about the particular matter to find out.
No, but you are changing your versions.
No.
And there are two things that you have changed. One, you've said that you've asked the person responsible, you spoke to the DPP, because I asked. You said you spoke to the DPP, you asked for the person who was familiar with the case to come through. Now, if you are saying it's somebody from your office, so does the people in your office familiarize themselves with all the cases? At what point was this person in your office familiar with the case? Did they go to the, so I'm confused there. The second area of confusion I have on the statements that as we ask the question, it seems to be changing, is the issue around what was, because you initially said, I told Judge Bezos, we're not gonna take representation. And you're saying it's not a decision. But for me, sitting here listening, it's a decision. You are the highest authority in the NPA that makes decision. No one else is going below you would be able to take a decision that contradicts the NDPP. We know the authority of NDPP in the NPA. Now, if you say, I don't think DPP was who's acting, would have gone and listened to a representation. For me, that's where the issue is. Understanding your level of authority in calling the people, calling this person. So if this person was not involved in the case and it's person in your office, how did that person become familiar with the case?
No, familiar in the sense, Minister, that, you could say to an official, please go to that court. I'm trying to understand where this matter is at, what is going on, what are the issues about. Official goes to that particular court, speaks to the official handling that particular matter, and comes back and gives one feedback. It is different from the engagement where you need the information for purposes of making a formal decision, because that comes through the formal route via the DPP. So this was really to get a hang of what that matter that is reported in the media about.
But if the intention was never to discuss the case, why would you go to an extent for a person in your office to go and familiarize themselves with the case?
Just so that
because
I know.
The issue is, you are saying to us as a panel, you had no intention to discuss the merit of the case because you had no docket, and you had not been briefed by the person that was supposed to be briefing you, who's supposed to deal with the case. Now, why would you not then get the information and get the DPP to brief you rather than send a person from your office to go and get the case?
No, not to go and get the case, Minister. There's nobody who was going to go get the case, because that suggests something different. All that this individual was going to do was to go and find out the elementary facts about the case, so that when the meeting takes place, one is familiar. And then I hear what the advocate was going to be saying, and then have a discussion from that perspective. So it is different from a formal engagement. It's not mechanical in that way. So I'd let the DPP know that there was going to be that meeting about that case.
I've got Mfunis, maybe just to ask, was this the modus operandi, where you'd have informal engagements? If somebody calls you and say, I want to see you, there's a case, you'd agree, have this. Was this an isolated incident or just the normality?
Can I just follow up on that? That's exactly what I wanted to ask, Mr. Minister. Advocate, good afternoon.
Good afternoon.
My view is that, is this a normal practice? Was the once off? And did it happen again? Or was just because of Advocate Bezos that you've done that? Or is this normal practice, and has it done before? And did that practice continue doing that? And isn't that a prejudice? And isn't that a bias? Isn't that creating an opportunity for somebody to come and kind of use it as a bargaining or something like that? But is it a once-off, or is it, and was it normal practice? Thank you, Minister.
This one happened, it was a once-off, but about this case, it wasn't the only one. Because after Advocate Bezos left, he never came back. He never came back at all.
I'm just trying to think if we're not getting into a slippery slope where formal and informal seem to overlap. What if those reporting to you had started this practice of allowing for expression of view as a precursor, and those below them, and this became prevalent because the rules, the lines are beginning to be blurred? Wouldn't you worry if that was happening, that now you do have this expression of view prior to? Or would you just trust that you are the only one doing that if this became widespread?
So if I get it correctly, Prof, you are saying if those reporting to me, which is the DPPs.
Yes, and even prosecutors below, they start saying, no, nothing yet formalized, let's meet.
My understanding and my observation is that people do meet and exchange views and engage about the approach to the case, about what they would want to see the prosecutor do. There are informal discussions, even in the lower court. But if it is about trying to get the institution to take a final decision on a point, then that must be formalized, because there must then be consultations. So the generalized back and forth discussions, as far as I understood at least and I observed, do take place in the lower court. It's not an issue. But if somebody now wants a decision to say, this is our view, normally prosecutors would say, please put it in writing and send it so that, and you motivate it so that we see why, and it follows the chain. Because by the time it gets to the NDPP, for example, you have a trail from where it started, how it was responded to by the people at a local level. It goes to the higher up to the DPP, who comments and also puts in writing. So by the time you sit as an NDPP, you have 2-3 stacks of interveners' opinions on the matter, and then you deal with it on that particular basis, because you are reviewing a decision that's already been taken by others. That's how it works.
Thank you, Advocate Simelan. I think you are right. By the time it gets to you, it would have been a decision that is taken by others. But what protections would you give to the system that the person, when they go back to come up with the value chain, are not actually saying the NDPP has seen this, or I've expressed my opinion to the NDPP, in that way, bearing weight on them to look at it in a particular way, almost like you do not have a choice because this matter is being handled by the, or even outright, I've spoken to him on such and such a day, you know, that kind of thing. But I just want to refer us to the Code of Conduct of the NPA under professional conduct, which says prosecutors must strive to be and to be seen to be consistent, independent, and impartial. So there's the issue of perception there. Yeah. And it worries, because once you call somebody in your office, when there is somebody defending another person who's accused, it gives a perception. And then it will come back, like you say, now formalized. And it comes back to you as the final arbiter or somebody who is supervising a final arbiter.
Right. The good thing is that it would never, ever happen that way. I can assure you that in the NPA, whatever you may have heard, prosecutors follow strictly the channels. It's SPPs, it's control prosecutors, it's the deputies, it's the DPPs, it's the head office, when formal decisions are being taken. But when there's back and forth engagement in a court, they have those engagements as often as they need to have them. But when it's time to make a decision, you put it down in writing so that you understand it, and also so that you consult about what the attitude is, up to until the absolute level. So the concerns you have can never ever arise in the normal course of operation of the NPA. It doesn't work that way at all.
Okay. I want us to move on to the next segment, Advocate Smiller, into the legal background. You indicate in terms of
Into the legal?
Pardon?
I beg your pardon.
Yeah, section 2 of the form. Around, maybe check us through your exposure in terms of legal work. I see you've got criminal law.
Section 2, yeah.
And we're saying not a lot. Administrative law, constitutional law, labor law. Maybe just take us through that exposure.
The section 2 paragraph.
It's on paragraph 2.2.
Oh, 2.2. Oh, no, these are the areas of law I practice in. Yes. I do varying amounts of work. Mostly it's admin law and constitutional law. Done a little bit of labor law. It's not a big area of work. Criminal law is not incidental enough. Compared to what one would expect, I haven't done a lot of those types of matters. I've done a few of those matters. I've done a few family matters, family law matters and Hague matters, but it's mostly admin law and constitutional law.
Then we move to section 4, managerial experience, having led NPA.
Can I ask one question?
Okay, you want to ask on that section of legal?
Yes.
Okay.
Thanks. Advocate Smilani, just so that I don't miss this part that you just said. You said criminal law matters, you have not done so many.
Yes.
Does this answer include the period prior your appointment then, moving into the period now? And I understand that as counsel grows in practice, people don't go to do bail for every matter everywhere. But does this also encompass the part, perhaps, of prior your first appointment?
Prior at the NPA?
Yes.
No, I did quite a bit before.
You did
Yeah,
quite
I did
a bit before.
Yeah, quite a lot of matters before. Yeah, I did quite a lot of protests.
So you can easily answer to the question. You had adequate experience in the criminal court.
Oh no! Before
space.
I went into government, yes.
Yes.
Before I went into government, yes.
Okay.
Yes.
No, that's...
Okay. No, thanks. Moving into the managerial, I'm not worried about how many staff you've overseen,
Yes.
having been the head of NPA, but I'm interested in your management style and your leadership style. I see here you wrote in terms of leadership, you advocate and practice the African Asian approach, which fosters community and village. As a person, I think I'm reading it correct, it's part of a whole. Maybe explain that and also what you see as your management style.
Yeah, it's collective engagement. I don't do top-down. I don't manage people top-down. I believe in communal kind of engagement where you meet the people with whom you work, even if you are superior to them, and you share ideas. That's how I've been managed. It's the only style of management I know. I've always been, from the first time I worked formally at the Competition Commission, it was always group thoughts. We meet as a group, we meet as a collective, we set the plans, the strategies together. Naturally, the leader will help identify the priorities, but we sit together, we agree, we are assigned a role, you come back, you share that role, and you report to the team on a regular basis on your work. Decisions get taken collectively. You decide on what others do, others decide on what you do. So that communal approach, I found that for me, it quickest enables buy-in. You don't have somebody feeling left out because they're just getting informed after the fact that something was done. So when you're together like that, then that's how it works. So the EXCO style is that. What I do when I say I don't manage people, I manage process instead. I set timeframes and dates. So for example, in the Department of Justice, I would say to the DDGs, we're only going to have 12 meetings a year. One meeting a month, which takes place in the first week of the next month, so that to discuss the month prior, so that we collect all the stats for that month and then discuss them the following month. In between, I don't need to see you because we've already agreed on the strategy, the objectives, the plans. Just go and execute and just give reports. So I hold people to account on the timeframes set, the targets set, and then off we go and make decisions that way.
And I want to come to that leadership style. One of the candidates in the
My apologies. I think it's a long day. I want to come to the leadership style and acknowledge what you are raising about inclusion, participatory of staff. But one of the candidates earlier on spoke about you being able to undermine those that you lead with, as far as sitting even in panels of junior officials in the appointment process.
Oh, Hermione? Ah, okay. No. No. She's correct about that. That I did do.
Mm-hmm.
The context was this. I raised an issue in the organization. I said, guys, or incidentally, we know each other very well with Hermione. After the meeting, we're busy chatting there. I was telling her, how dare you say this about me? She says, well, you know who I am. I said what I had to say. So I told her to say there's no... I absolutely accept what she said, and it's correct. I did do that. Again, you arrive in an institution, and you get on with work. As you know, for many of those that work in institutions, officials then come and give reports to the new people to say, look, there's a problem. It's of this nature. Dissatisfied with their work environment. And this was AFU. Some people in head office complained about it. Just basic petty stuff. So I was like, nah, I'll talk to you. So I tipped Vili. I said, hey, there's grumblings I hear about in your area. Just keep a close eye on it. Then a while later, I went to address the team just to meet them and see them. And we discussed work in the normal course. Again, nothing hectic, nothing unusual, because I was just loitering to see if I can pick up some stuff on a consistent basis that I could raise formally now with Vili, because he was a good colleague and a comrade. I just thought he needed to be aware ahead of time that there was something coming up. Then when I looked at the work of the units, I asked just informally, why are there no black people in the AFU? Why is the representativity or representation so poor, comparatively speaking? The initial discussion, we're sitting like this in a room. The initial discussion was, yeah, we're looking, we're advertising, we're recruiting. So I said, okay, no, that's fine. The meeting ended, normal course, no biggie. Then we had another engagement with the units, and I raised the question again. I said, no, but why is this issue coming up? And this time I started raising it formally, that I'm getting negative vibes about the place, that this is a preserve. There's no inclusion in this particular unit. And the formal answer that I then got was, we can't find good black candidates to join the AFU. So I said, no, I don't understand how that could be. What do you mean? He says, no, we get CVs, we interview, we don't find appointable people. It got on for a while, then I involved another official, Advocate Chiba, senior official. I said this.
Oh, they're asking that you bring closer your mic.
I asked Advocate Chiba to join me in some of the meetings. I can't remember what she was responsible for at the time, but I asked her to join. I said, no, I hear this thing, what is going on? Then I received a formal complaint from an AFU official to say Vili of Meyer is racist. So I dismissed it. I said, no, you're joking. No, not Vili. It can never be, I know. I said, no, he's racist because we are being made as blacks. There had been then some recruitment of blacks. We are being made to write an English test. So I said, what are you talking about? You're being made to write an English test. I said, no, I'm being made to write an English test. So I didn't believe it. I said, it's not true. Let me see it. So a small sheet was brought to me, and I spoke to Vili about it. I said, Vili, what's going on here? This is what I'm getting. You know, at University of Natal, where I went, it had a program of assisting students for whom English was not first language. And as part, it was a bridging program. It was called English Language Studies, to help them bridge before you do English 1, 2, or 3, if you wanted to do that as a major. This was worse than that. I called Will, I said, Vili, this can never happen. I can't get this from you. It can never, ever, ever happen. He said, no, we're just trying to do basic tests. I said, it can never happen, because it creates the perception that I've had. I know it's not true what they're saying, but that's how they feel, because they see this kind of treatment. He says, okay, no, then I'll stop it. I said, no, don't worry about it. Let's not go ahead with it. I'll go and engage with the officials. So I went and engaged with the officials, and I basically indicated to them that whatever their perceptions were of him, it really, I understand why they would feel that way, but it definitely was not what they were describing. He's absolutely not like that at all. They understood, they said, we understand, but we didn't appreciate the manner in which we're being approached, because there's this general problem in the AFU. So what I then said was, well, you know, and I spoke to him, I said, well, in the next set of interviews, I'll come and make sure that we're able to see if we can find candidates that can fit the bill. So I spoke to Vili. There were appointments being made in the Western Cape, and I said, I'm going to be in the Western Cape for something, so we're going to be participating in this. He didn't have a problem, right? But then I asked him that, well, if you can speak to your officials about it, so that they're not surprised when they're there. So we arranged with HR, and we went to the Western Cape, and we handled that. In other words, the process was run, people were interviewed. HR had handled everything already, so we just came, we had a look at the pack, we sat and went through interviews, and candidates were appointed. And my submission that we found the candidates that could do AFU work. My argument, Ella, with Willie, when he said we can't find people, I said, tell me what's so difficult about AFU work. I just want to understand it. Because by that time, I'd also checked that when it comes to briefings to counsel outside to go to court, a pattern was that we largely briefed, almost majority, white advocates. I said, this is what I want us to engage with, right?
Maybe so, just to ask yes. There, why particularly go with Advocate Jiba, who was strategy and operation, and not go with the head of FAU? And I'm going back to the theme, because you introduced the theme of ensuring that your heads have power. Your heads don't feel undermined. Now, if it's the process of rectifying, you're wanting to support Vili in finding, Advocate Hofmeyer, in finding the right candidates and also ensuring transformation. Wouldn't it have been better, or why didn't you go with Advocate Hofmeyer, who was the head of FIU? You went with Advocate Jiba, who was not responsible for that unit.
No, he didn't want to go. He said he didn't have to go. At the time, remember, at the time, he was also running the SIU. So I spoke to him about the positions they were filling. And we actually discussed them, that, okay, I'll be going to the Western Cape to go and participate. He said, no, it's fine, you can go. I'll speak to Hermione about it, and you guys can attend to it. It's not a problem. So we had discussed it.
Advocate Cronje was responsible at the provincial level, because our understanding, she says that there were two people that she reported to, which you jumped from your level to come to her.
No, I don't know those two people. It could be true, I don't know. But the arrangement for those interviews was arranged with the head of the AFU, sorry, it's Asset Forfeiture Unit. And I went there on that basis to join those that were there. I don't know who else would have needed to be there, how they had set up the process. All that they just needed to know is that the NDPP would be participating, I think NDPP, I think at the time, would be participating in these particular proceedings with HQ.
And when she wrote a complaint?
I've never seen it. I've never seen it.
The report that she wrote to raise her dissatisfaction.
Never brought with me.
You never knew about her not happiness.
First time I hear about it today.
It's your first time today.
First time I hear about it today. What would have happened in any event, Minister? HR was there. ran the process. HR ran the process together with some of the admin people who were based in the Western Cape office. And what would have happened in normal course is that if anybody would have raised a problem with the process, it would have gone to HR, maybe not there. Let's say, I don't know, I'm trying to imagine that she probably, let's say she thought, let me do it when the acting NDP has returned to Pretoria. That would have gone somewhere. To HR, it gets to HR in HQ, and it gets looked at. And if, for example, somebody is complaining about the NDPP, acting NDP at that stage, I'm imagining that they then would have found a way to take it to an appropriate environment for it to be addressed.
Yeah.
So what would have happened is that it would have come, they would have looked at it without my knowledge, for argument's sake, and they'd have taken it to the department in HQ, where HR reports anyway, and it would have been submitted there. And I'm imagining that should have been asked, is it a formal grievance, for example, or is it just an information issue? Let's assume, worst case scenario, it's a grievance. It would have been a grievance that would have really raised the, let's say, the DG's attention, the DDG, they would have taken to the DG to say, DG, you know, this is what is happening, can this be followed up and taken up? So I'm imagining if there's a complaint of that nature, that's exactly how it would have worked. And if it was not satisfactorily done, I'm imagining that whoever feels strongly about it would have escalated it to the executive authority, because that's a grievance framework in terms of the public service, and it would have ended up in the Public Service Commission to the extent that somebody would have felt aggrieved. But Mr. Hoffman never raised it with me at all at any point in time.
So you said in the interviews, were you part of the shortlisting process?
I don't recall if I was part of it.
So you only said in the interviews?
I think when I got the pack was already prepared there.
Who shortlisted, in your knowledge?
Oh, I don't remember who would have shortlisted.
The reason I'm asking it because it makes that process irregular if you didn't shortlist.
I just don't remember.
The requirement of a recruitment process is that you would advertise, a panel will be appointed, that panel must shortlist, and the same panel that have shortlisted must be the one that interviews.
Yeah, I don't remember how it exactly worked. I may have been part of actually the shortlist because it was an intervention specifically that I was making, but I just don't remember the details. I don't want to commit, but it's verifiable.
Advocate Smela and I have a difficulty with that. You are a former accounting officer who have run the Department of Justice and Constitutional Development as an accounting officer, who would be familiar with HR processes. Because as a Director General, you'll sit in interview processes. You'd oversee the process of recruitment in terms of public service and administration. You'd understand the law and the regulations that requires. I find it difficult that at this point, you would not know that I can sit in an interview if I've not shortlisted, or you do not remember whether you shortlisted. I've been a minister since 2017. I've been a public servant. I can tell you where I've sat in an interview.
I've sat in many interviews.
I've sat in many.
No, I understand. And that process you are describing is exactly the process. I just don't want to, I'd appreciate if you verify it. I just want to, I just don't remember.
Let's take a step back and park that one.
Yeah, okay.
In terms of public service and administration, as a former accounting officer, you would know the levels of delegations. That at this level, as an accounting officer at a department, you'd have been given, okay, at this level, administrator to this level, non-SMS. These are the delegation that would operate the appointing and all that process. SMS, this is where the delegations and all that. For example, DG, DDG, we go through cabinet. It's delegated powers by cabinet to ministers, and therefore the panel will be ministers. Non-SMS based on public service administration and delegation by the executive authority, which again, in the NPA, the delegation as well are linked to the minister. Now, at the time you sit with this, did you verify the delegation authorities that you could sit in that, or you are violating those delegation of authority?
That I could sit as NDPP?
Yes.
No, I didn't get that far. No, I don't. No, definitely. No, definitely, because the NDPP would not have the delegations for HR.
Exactly.
Yeah, no.
So you shouldn't have said in the interviews, because there is nothing that gives you that authority to sit in terms of the delegation and functioning, how NPA functions and the department, especially on human resource processes.
Yeah, no, I take that point, yes.
Thank you. Okay, let's move to the next one. In terms of the questionnaire, we move to, you've dealt significantly in terms of your significant contribution, where you've gone into detail in how you have explained your role in establishing the Competition Commission, the tribunal, the work in conceptualizing the DPCI. Anything else you'd want to say in that regard? This is section, I must go in paragraph 3, same under section 4. If you've gone extensively, but I don't want to pass in case you've wanted, because you covered it when you started the process. But I don't want to be unfair and jump that part. If not, we can move to the next segment.
Yes, Minister, there's a lot that I've done.
The next section deals with financial and business interest. You indicate that you've got 2 companies. We did receive your letter. Thank you very much. Where you have additional in terms of the company that is also dormant that you'd forgotten to indicate. So that is received. They are currently confirmation that you are currently deregistering them. Thank you. And then we move, the issue of health, no health issues that will impede you from holding the position. And then we go to the issues around, have you ever been convicted? No. But the issue of legal bodies, any complaint, have you ever found guilty of any professional or disgrace conduct and any complaints against you? Do you want to take us through that process, those issues in that segment, where there's complaints, issues that you'd want to bring to the panel and your explanation of them?
Oh yeah, that's the Johannesburg Society of Advocates matter. Yes, I indicated that matter that took place in the process started in 2015, it finished in 2017. That arises out of the Chinwala processes. I don't know if you want me to start there. Do you want me to start there, Minister?
You have an opportunity to explain to the panel.
Right.
And I'm giving you that opportunity.
Right. Okay. Now, this matter followed the Chinwala inquiry, which got completed in 2008. There, it was an inquiry relating to the fitness for the NDPP at the time. As DG of Justice, I then assisted the minister with that process at the time. The way the terms of reference were set and the way government decided it would approach Chinwala was to make a submission. Dr. Chinwala asked those submissions. The reason is because it is initiated by the president at the time. They therefore needed a submission to be made that would be considered. That submission was prepared. It was submitted. In its preparation, because there were no directives as there usually are with the judicial inquiries, this wasn't a judicial inquiry, but there were no directives. There was a due date for government to file a submission. So all information had to be put together. The department was instructed to find legal representatives for the minister and the president. So in the normal course, I facilitated that through the state attorney. The state attorney made available a state attorney to represent them. And through the state attorney, counsel was found for the minister and for the president. And they engaged and took instructions accordingly. They met often. In some meetings I was invited, in some meetings I was not. But the long and short of it is that government therefore needed to put together a submission. So the nature of the issues is that the president would make the inputs in relation to his views to the issues, and the minister would provide inputs in relation to her experience with the NDPP. And this was on the basis that the minister had advised the president that her relationship with the NDPP had broken down. So she needed therefore to have collated and put together all the information that she was going to rely on to demonstrate that. So the department was asked to put together information. We did that. The other departments that were involved were asked to do the same thing. NIA was asked to do the same thing. Crime intelligence was asked to do the same thing at SAPS. So there was a collation. So what I was responsible for as the DG in the department was to coordinate the meetings of all the departments that were involved in that submission. So I arranged meetings with SAPS to tell them when the meetings were taking place, what was required of them, so they would come. Inside the department, those officials who had dealt with the NPA and the DSO, amongst other things, I'd asked them to bring that information. So they all came and would meet and then would brief the lawyers and show them what information we have. And the drafting of the submission, therefore, was done by them and would make inputs periodically. And we discussed it, and up to the point where they then needed to go back to clients, discuss it further, and finalize it because the submission date was imminent. So that got done. So that was the end of my contribution to that process. And the next time the information came back was that the executive authority and the president had finalized the submission. It was now going to be filed. And the legal representatives were responsible for that, then did file the submission with Jinwala. It wasn't the department's responsibility. So it was submitted just as a submission. And then when it was received by Jinwala, naturally it was considered. We then got information back that, or before it was submitted, there was then a letter from the attorneys of the NDPP asking for information. They asked specifically for a letter. Well, they didn't specifically ask for a letter, but they asked for all information, if I remember correctly, I'll paraphrase, that the department had received, the ministry had received, the department had sent, the ministry had sent to the president. So either of you would have sent to the president or whatever either of you would have received from the president before 15 September, if I remember correctly. So we attended to that. I was instructed to then obviously assist, prepare a response to that particular letter. And I did prepare the response to that letter. But at that time, the minister indicated that indeed she has a letter from the president. She had received a letter from the president relating to Pikoli. And she suspected that the president was going to be making a decision soon. She didn't show me the letter. She didn't give it to me, so I didn't know. But the discussion was the reading and the letter from the attorneys is asking for information in relation to the prosecution and arrest of Mr. Selebi. That's how, Mr. Selebi. That's how it was phrased, if I remember the wording correctly. So the point made was that we know nothing about, well, I hadn't received anything as a department. In other words, the department hadn't received anything from the president and hadn't sent anything from the president. So this didn't naturally concern the department. It clearly concerned the ministry. And the minister's view was that I don't have a letter that talks to the arrest of anybody, let alone Mr. Selebi. So that's the response that needs to be sent to these parties to indicate that there is no such. But what was there were all the other reports that had been submitted by the NDPP. So I drafted the letter along those lines, and it was sent. The submission then got submitted to Chinwala, and I was informed that the legal representatives, when they got there were engagements with the legal representatives of the NDPP, and it was in relation to what they still needed from the department and the ministry, respectively. In fact, they'd also asked, I can't remember when, but at a different time, not in the same letter, that asked for opinions that the department had obtained, and the department claimed privilege over them and said, no, we're not going to make them available because they're privileged. So in the meeting with Dr. Chinwala and Secretariat, there was then a discussion about what the other side needs to start. I wasn't there, so I don't know what happened, but this is the feedback we received. When it came back, the feedback was that, well, between the parties, because the process would need to start soon, some direction was given by Dr. Chinwala, and it is that, and this was agreed by all the parties, that they would exchange what they need from each other. So let there be a discovery process, in terms of which what the other side needs, the department and the ministry must make available, and the other departments as well. They must make available, and if anything is needed from the other side, the same must be done. So with the officials, we put together the information, specifically the two opinions that we had claimed privilege over, and we waived the privilege, and we gave them to the state attorney. The other departments did the same, as far as I recall. And then those were given to the legal representatives, and they attended to their filing with Chinwala. A couple of days or a week or two later, then the process started. So that's how it started. Or in fact, before it even started, part of the feedback was that the legal representatives of the NDPP said the government submission covers too many things in one. And because there's too many things in one, can there be a breakdown of which department is raising what issue and which person in that department is raising what issue? So it was segmented, and myself as head of department, I was then, and that parties must then also put affidavits. That must be done in affidavit form. So I then did an affidavit to cover the areas that related to myself as head of department and accounting officer. I explained the issues that I'd reported to the minister about in relation to the NPA, that I was having difficulty about with the NPA. Basically finance reporting issues as accounting officer. And as in terms of Public Service Act, it was in relation to one or two disciplinary matters, and the building Innes chambers that had been acquired by the NPA, for which they needed money to refurbish. I put those things and the general issues between NPA administration and departmental administration, where staff were heckling each other back and forth about reports needed to be submitted that were not submitted. So my affidavit was basically circumscribed to those issues. And it was filed. I think the minister, if I recall, did her affidavits, and the other officials from the other departments did theirs. So those were filed, basically discovery. So discovery was done, and the documents went through, and then the process started. Then we went through it. I was cross-examined on my affidavit, at the end of which, naturally, I was excused and I left, and those who were remaining proceeded with the process. The next thing I see this, I hear that the Chinwala report is ready to be released. We all waited for it naturally, and it was eventually released and it was attended to. So when I got a copy, I then saw these comments that were made by Dr. Chinola in relation to myself. I was obviously shocked by them. I was like, wow, why would these comments be made? Because not only do I not agree with them, but I didn't get an opportunity to be tested on them or comment on them. So how can this be? Processes just ran forward with the removal of the NDPP in Parliament, and this issue got left unattended. And things basically continued in the normal course. Then I got alerted that somewhere in 2009, I heard that somebody had filed a complaint, but initially I didn't get that information, and it sort of died out. But in about 2011, 2012, somewhere around there, then I got information that, no, indeed, you were right, there was a complaint that was filed by an advocate, Ellis, who had filed a complaint with the Pretoria advocates saying that the comments made by Ginwala needed to be investigated. And that matter was then referred to the Johannesburg Society of Advocates around that time. At that time, the judgment had come out and I was at home for a while. Then around 2013, I then went to join the Public Service and Administration. And that's when the Johannesburg Society of Advocates then contacted me and alerted me that, look, we've got this complaint about you, can you just comment? So I commented and explained myself. Then they said, no, we believe that we should take this matter forward and there'll be a disciplinary process. I said, no, that's fine, I'll come and explain. It started in 2015. We had exchanged representations which they're not satisfied with. Then in 2015 it started, and we completed it in 2017. Found guilty on the way the charges were framed. They were in line with the comments made by Ginwala, that you didn't disclose to Ginwala the letter of the president. You didn't follow the advice of the opinions. You got yourself involved in the NPA and therefore exceeded the role of the Director General in respect of his responsibilities for the NPA. You were condescending and arrogant to the NDPP. You accused the NDPP of dishonesty, and then you conceded.
Away from the mic now.
Then you conceded on an accusation you made, and I find that it was without merit. So those comments were mirrored in the charges, and they found me guilty of that. And they recommended that a strike-off application be brought. That was in 2017. Then within the 14-day time frame set, we filed an appeal to say, no, we're filing an appeal with the GCP in terms of the Constitution, and let's attend to this. Never heard from them ever since. Never heard from the JSA ever since. So 2018, 2019, my attorneys engaged them to say, look, we need to have this appeal set up. We filed and everything is ready. When it's going to happen? No acknowledgement of receipt, nothing. They do absolutely nothing. So my attorneys say, no, let's wait. Maybe they will come back. So we wait. I continue with my work. Then reach a point at work in 2022 where I thought, oh, well, I think it's time for me to return to practice. So naturally, I went back. I applied for membership to a group. I got it. And then I went to take up chambers, around about March 2023. And I started phasing out my special advisor role. But my chambers were set. Then, around March 2023, I saw, in a totally different function, the chairperson of the GCP at the time, and I just reminded him, I said, you know, there's this thing outstanding. Since we filed that time, we've never heard from you people. He said, oh, you know what, I remember the thing. You know what, we'll respond to you. A few weeks later, we got a response that GCP doesn't have jurisdiction on the matter. They're like, oh, okay, they don't have jurisdiction. Okay, that's interesting. That was about March 2023, April 2023. Then around June, July 2023, I'm not so sure, the JSA then sent me a letter to say that, look, remember this matter? I said, yes. Said, when I have a look at it, can you give us representations on new issues that you would want us to consider as we consider that matter? So that looked strange to me. I was like, okay, I'm not sure what procedure this is, but okay, let me do so. So I got my counsel and my attorneys to put submission. We put a 40-page submission, practically expressing concerns that, look, here's correspondence, we've been engaging with you guys from day one, you've not been responding, you've not been acknowledging, you know, these are the views we have. Put a full submission about, you know, the prejudice that's there, why is this thing taking so long, why didn't you move on it? Then after submitting them, I was then informed that the Bar Council would be meeting around October 2023, and that I was invited, if I was interested, to come and meet the Bar Council and come and make my presentation there based on what I'd written. Naturally, I took it up. I said, oh, of course, no problem. I need to come through. So I went. So went with my legal team. We sat there. Everybody was there in the Bar Council at the time. And then they said, well, we're here, and this is the only agenda. We'll receive your submission. We just want to find out if you have anything else to say. So our approach was simple to say, first of all, tell us what process is this in terms of the constitution of the society, because we've looked at it. There's no provision for this procedure. So what procedure is it? I need to understand what is the purpose of this discussion, because all the decisions have already been taken. The only thing left is for the appeal to be set and be heard. So what is this meeting? And they all looked at each other and said, oh, we're just trying to find a way in which this can be amicably resolved. Words to that effect. So on our side, we said, no, but what procedure? You know, we can engage in a discussion if it's in terms of X procedure, but what procedure is this? Because we're not aware of it. And what amicable resolution can there be in a matter like this? Because an appeal has been filed and it is there. It just needs to be processed in accordance with the relevant clauses of the Constitution. So I went on as well and told them what the prejudice is. And I specifically told them, I said, you know, the problem with this type of thing is that this thing is hanging. And if I need to go and do something, this thing will always need to be explained. You know, I gave them examples in the public service of positions where fit and proper is a requirement. I said, for as long as these things are there, this thing will always be hanging. So you need to finish this. And you've been prejudicing me for the past 8 years, as the case may be, by not attending to this. I said, no, we realize that. We will we'll consider this if there's nothing else to say. So there were further arguments. I don't need to repeat them here, but really premised on the fact that that process and that meeting was just a non-meeting in the sense that what did it have powers to do as far as we're concerned? We wanted to understand that. We didn't get an explanation. So I said, we'll come back to you. So we left. Never came back to me. They never said a thing. I said, oh, okay, these guys are quiet. Then lo and behold, this process starts. The president puts out a panel. It's in the media. And, you know, that advert or that gazette in the paper, if I remember, it was a gazette, but it was basically the panel. It was put in a WhatsApp group I'm in. And somebody in the WhatsApp group, it's a WhatsApp group of many people really from different parts of the country, different political parties. And somebody in that WhatsApp group said, Menzi, I expect to see your name in there. Words to that effect. I think it was on early in the week, Monday or Tuesday, somewhere thereabouts. I don't remember. It's fine. Then same week, I go to Chambers on a Sunday to go pick up a document I needed to read. And I open my chamber, I get in there, there's a huge box. And I thought it was the document I was expecting. So I go and have a look, and I open the box. It's the strike-off launch papers. They're on my desk. I'm like, okay, what is this? I look at it and I see it. I'm like, oh, okay, this is what has happened. And then I attended to it. So I was trying to think what was actually going on. Then it dawned on me that, oh, okay, actually, this is, it appears to be a preemptive move on the part of somebody in anticipation of something. And I left, obviously, and engaged my lawyers accordingly to say, can we look at this thing? These guys have, since 2023, October, they've only come back now with this application. So we checked, obviously, when it was stamped and served so that we comply with the timeframes, and we attended to responding to it. So I spent some time thinking about, okay, what possibly is happening. But because they'd moved in this way, my thought was, okay, obviously I'll defend it and see them in court. We will proceed. And we prepared the papers, and we filed since accordingly, and they've since responded. And we've put a counter application to have the matter dismissed. And they haven't yet. Time hasn't come to file their answering affidavits because they asked for an indulgence to file in January, which I acceded to. But they haven't filed their reply to my answering affidavits, and they're out of time. So they indicated that they will ask the court for condonation when they file. They were due to file their reply on the 26th of November. So we're waiting. That matter is sub judice for these purposes, Minister. But that's basically what happened in this particular matter. Now the issue is, to get back to Ginola, what actually did Ginola say? And is she actually correct? Because after the reports were released, her report was released, and it went on, the matter went to court, and it was set aside. Based on the judgment, I then engaged government to say, okay, we need to attend to what the judgment says. And the responses I got was that, no, it will be attended to. We'll attend to it. We'll have a look at it. So in the meantime, the first
Court
thing,
set, you mean the ConCourt setting
ConCourt.
aside your
The
appointment,
yes.
not the report?
No, the appointment, the report, I didn't challenge because I had no local standard to challenge it. It was a comment, those were comments made against a witness. So I had no interest in that inquiry. So in law, I wouldn't have local standard to set aside a report. I was in a process I wasn't a party to. So that's what basically...
But the report makes a finding. I find it difficult, Advocate Milan, that you would say you had no local standing. If a commission finds something against you, I find it difficult to say you couldn't challenge it. You could challenge and review where it makes provision about you.
No,
Not the entirety of the report, but because it made observation about you, and you didn't challenge that part about you.
Well, that's the
And
advice
that's
I
why
received.
I'm responding to the part where you say you had no local standing in terms of challenging. You do, because the part where it makes reference to you, you could have challenged that part. Not that you didn't entirely have local standing.
Well, first, the position was, there's no findings being made about you, firstly. It's not a finding. These are obiter comments, right? That's the first thing. And if there's no findings against you, it doesn't affect you. The report doesn't affect you. And to the extent that obiter comments were made about a witness, and because you're only a witness, you wouldn't have locus standi, and you don't have locus standi to try and set aside the report on that basis. That's the
But the
legal advice I
Ginola
received.
report did make a finding about you.
It did not.
The issue of dishonesty,
It's not in the findings. It's obiter in the body of the report. It's not a finding. It could not have been a finding, Minister, because the inquiry was not about me. The inquiry was about somebody else. I just came as a witness to talk to specific issues. So the chair of the inquiry, for whatever reason, found that I'm not happy with this witness. She makes a general comment in the body of her report.
But there was an issue that President needed to act on those.
No, not in the Chinwala report.
The Concord says that.
No, I'm going to get to the Concord. Okay. No, so the Chinwala report is simply about a witness and the dissatisfaction of the chair with the witness. It also happens in courts where a judge can say, I was unhappy with this witness or that witness or the other, right? And then continues to give judgment in relation to those before the court, right? So the issue is as a witness commented on, can you go and appeal that judgment or review it? You can't because you're already a witness. So same applies here, that you're just a witness, it was obit, it wasn't a finding against you. So there's nothing for you to challenge. It's just unfortunate negative comments about you, but they are not findings, right? So that's how that matter was left by myself. Then in the CC, the mistake, and I've got the judgment, I don't know if you have it because I want to show you where I think the error and the confusion arose. In the CC, Justice Yaqub says, of the judgment. Yeah. On page 34 of the judgment, the first error that is made is that at the bottom there you see the heading, Chinwala Commission findings. It's the first error because the justice there says those are findings when they are not findings. They were not findings. You won't find them as findings in the report. Comments about me are made in the executive summary. They are not findings. So that's the first thing. And on that paragraph 50, Justice Yaqub correctly says, in the executive summary of the Chinwala report, Dr. Chinwala said of Mr. Similane. Then on the next page he goes on. But that's in the executive summary, it's not in the findings. But for whatever it is, whether technically there are findings or not, the point of the matter is that what needs to be addressed is the negativity thereof, so that it's responded to.
That's why I could have picked up, because the Concord does make reference to it as a finding.
No, I understand, yeah. And as a result of that, I think the media then also reports accordingly. So Justice Yaqub deals it in that fashion. Then on the next page, paragraph 51, correctly says in the report of the Chinwala, he calls it a commission, it wasn't a commission, it was an inquiry. And there is a legal difference between an inquiry and a commission for reasons that we all know. Then he copies those comments. But on paragraph 51, if you go to what is quoted there, the last paragraph, which reads, with regards to the original government submission, the issue there is that when Dr. Chinwala makes the comments, she makes reference to the government submission. She's talking about the government submission. She's not talking about my affidavit. So what is the difference? When she talks about the government submission, as the DG, I'm not responsible for the government submission. The parties responsible for the government submission would be the executive authorities with their legal representatives. I'm not responsible for that. Right? That's the first thing. So that's how a wrong view starts to get created, because Dr. Chinwala herself makes reference to the original government submissions. As she says, many complaints were included that were far removed, and she goes on and on and on. Then she then says, this further reflects the DG's disregard and lack of appreciation and respect for the import of an inquiry established by the president. So Dr. Chinwala makes an error in that she makes the government submission my responsibility, which it wasn't. It wasn't. It was the responsibility of the executive authority. So that all gets covered. Then let's deal with the specific.
There?
Yes.
Let me just reflect for a moment. In the Ginwala report and in your response subsequent to that, you make a point that this is just the government submission, not yours. And you become a passive actor in the process. I put it to you that in everything that you have presented, you are an assertive, decisive person. And you said earlier you coordinated submissions from different government entities. So I would find it difficult when you say I'm a passive victim, not an active player, in a sense. So to me, I just want to come straight to your view on the issues, because right now we could be sliding towards the technical aspects of the report. Fair enough. The bedrock of the role, whether a DG or the National Director of Public Prosecution, they put the issue of ethics and integrity. And the operative term there in the NPA Act is the one to say to be fit and proper with regards to the experience, conscientiousness, and integrity. And there's a reason why for these particular roles they put the issue of integrity, of ethics, because right now we might be playing with the technical aspect of the report itself, right? So to me, there are observations made in the report about you having withheld some documents, not cooperated, not being a reliable witness. Those are very specific. Whatever technical term we can use, those were made there. And you would have said, let me challenge that particular aspect in a report because it impugns your own integrity. Would that not be the case?
You are wrong on a number of fronts, Professor Figin. There's no technicalities that was getting into. And I resist your temptation to want to avoid the issue because I want to make these issues that Dr. Ginwala raised an issue for you as this panel to think about. So I'm not going to accept your characterization of the issues I want to raise as technical issues. I'm not going to accept that because if I accept it, what's going to happen is that this issue remains unattended, and it's been unattended for 18 years. So I'm not going to allow you to go that route. That's the first thing. The second thing, that I'm not sure where you're getting this expression passive victim, because I never said that. So I believe that let's not do that. What I'm saying is the submission of the government submission, the filing of the government submission to Ginwala is a responsibility of the executive authority responsible to make that submission. That's a legal issue. Who has responsibility to respond? It's the person responsible for that. In the same way that the minister currently should be responsible for the substantive work of the Madlanga Commission and the Khampepe Commission, as far as representing government as the executive authority, not a DG who is a functionary administratively. In the submission, contribution to the submission, I was definitely an active player because, as I said so, I don't know if you heard me, as the DG, I was making contributions in relation to the issues that affected myself as DG and as head of department in relation to the NPA. So I made those contributions in that particular submission. Similarly, with the inputs from the international relations officials of my department in respect of mutual legal assistance, I provided that information to the legal representatives towards the submission. So the submission contained that information. So I can't be passive under those circumstances, but I'm contributing to it. Now, once that is done, the question is what then happened? And what happened thereafter is that the executive authority and their legal representatives then finalized the information and finalized the submission to their satisfaction. That process does not involve the officials, and it didn't involve me, despite having contributed to it.
Let me come there. Understanding the role of the accounting officer, Advocate Simelan, I do find it a bit odd, unless if that minister acted, because the director general in a department is the advisor of the minister. They, like the same, where the minister becomes an advisor, or you call it a counselor, to the president.
Yes.
Now, you are saying this work excludes you. It's that of the minister. It was the minister working with her advisors. Is that what you are saying?
No, that's not what I'm saying.
Okay.
I'm not saying. There were two processes.
Okay.
The first process is first compiling everything that's there. Government must make a submission. Everybody that knows something, bring whatever you have. Got involved in that. I was part of that. I coordinated that. Everything was put together. We have these regular, it was more than one meeting of officials together with the lawyers. How do we frame this submission?
And justice is the lead. Because if there's a coordinating, for example, it takes the format of in ministers, it will be an IMC, where then the minister who chairs that, because there's always a lead department. So in this regard, you'd be the lead department as justice.
Yes,
to
because,
coordinate all this information.
yes, to become
collate.
lead department because the inquiry is run by the department.
Yes.
As you know, Minister, all
Yeah.
inquiries are run at justice. They can't
Yes.
be at Home Affairs. So it follows, as a matter of course, that the lead department and the lead minister would be the Minister of Justice. It's just the way it is.
Technical point of
And
view,
then technical
it's
point
you
is the
who
Director
becomes the
General,
lead.
yes.
Yes.
Yeah,
Okay.
so the Director General facilitates at official level everything that's needed. So that's the role I played. Yes, and got everybody together, made sure that what was needed, they come with. So I talked to the other officials, make sure they bring the information and that they come where they were required. So all of that I did. So I was leader of the officials of government towards that particular
Okay.
process.
That would have led to what the minister will dispose of or deposit. Because you'd collate all this information, the minister will sign off what you are providing to the minister to deposit to the commission.
No, we'd give it to the state attorney and the legal representatives because they needed that to start drafting. Yes, so we'd give it to them, and then we started the process of drafting. So the draft, in other words, they indicate that this is how they propose. After taking instructions, this is how they propose to do the draft. As officials, is this correct? Is this not correct? Is this what happened? Is this what happened? And then they did it. Then they finished with the draft. Then they indicated that we will now leave with this draft and go and take further instructions around finalizing it. So the question was, is there anything else that is needed from the officials? And the answer was no, and this would be finalized. But I was in the process of, basically up to a draft, I was involved in that with the officials. We were involved, yes.
So the minister finalized alone without your advice as the accounting officer?
No, remember the advice is contained to say we as the officials believe this is the best way these issues can be presented. Then the ministers and the president can then finalize however they want to finalize. But by the time the lawyers go, they've already taken our views and they've already indicated this is how this thing should be basically handled and submitted. So we would have made a contribution. So clearly I'm not passive in the way
No,
that
the issue
it was
is
suggested.
coming to, because maybe I understand, that's why I want to be clear, because maybe I would be operating differently as a minister, because there's nothing I would do without my director general.
Yes,
Nor my department.
yes.
Everything that I need them to give me a go-ahead, that this is accurate, this is, if they say no, I would not sign. So at this point, there's information going to the inquirer, the Ginwala inquirer. You are collating information. And I'm linking it to what Ginwala says is insufficient information and how you would be linked. Because you are delinking yourself to say, if there's insufficient information, that would be the executive authority, not me. But I'm arguing that the executive authority's ability to be able to submit sufficient information, it will be because of you. If there's no sufficient information, it's the Director General and the officials in the department. Unless if you are to say to me, no, at that time I was on leave, there was an acting Director General who then had to do this work. But if you were in office, that's your duty as a Director General.
Yeah. No, it didn't work the way you are describing it. Definitely putting together the information towards the draft, all the officials were involved. I was part of that process. The legal representatives they produce a draft, and we discuss it that this is what is going to go there. Does it reflect the views of the different departments? We all confirm that that is what it will review. For in relation to myself, these are the issues that concerned me, for argument's sake, and the others would do the same. Then the legal representatives would then say, we will now go and get further instructions on this issue, and we'll finalize this document, and then it will be signed off and submitted accordingly.
My argument, Advocate Simelan, is that your role, because you're advising the lead ministry, doesn't start and end with the department, because it's a submission that is overall. If the executive authority, that is the minister, it was not different ministers that were submitting. If it was different minister, I would understand. But here you have one minister who is submitting to the commission. Then your role will be to include the department, but also to oversee overall as a counselor of the minister to ensure that what the minister submits is accurate and complete.
I'm not sure where we're missing each other, Minister, because what I'm saying is that the legal representatives on brief indicated that based on the terms of reference, the submission is just supposed to be a submission. So that submission was prepared and it was submitted. There was no issue there. We're all involved in that. I was involved in that in the draft. What I wasn't involved in was its finalization and sign-off, because that was done with the lawyers and the principals. But the draft that went to the principal to say, as officials, this is what we believe should be submitted, subject to the principals adding whatever they want to add. This is it. You know, that's basically what went. But when it went, it was at that time that these outstanding things that the other side needs to be attached. And what I'm submitting here is that then got done as part of the discovery process. So by the time the Ginwala hearings commenced on day one, everything that Dr. Ginwala says was not disclosed was already disclosed. Everybody had it. And in fact, the opinions were used in my cross-examination. The error.
Minister, thank you. Advocate Simelan, so you are saying the Ginwala's opinion was actually not about the content of what you had submitted, because the impression from my reading, when I was reading, it was almost like she is drawing an opinion on the content of what you submitted, not only the process. You're right. There was also the process, etc. But somewhere I thought it was also speaking to the correctness or the truthfulness of the content submitted by you.
No. Okay. Oh, sorry. Can I?
Yeah.
Oh, okay. Sure.
Thanks.
Sorry. No, first thing, I didn't submit anything to anyone. That's the first thing. It was not my job. The legal representative on brief are the ones who are instructed to file. So the state's attorney filed the submission. That's the process of filing. You file through your lawyers, right? What is approved as client. Is that not so? And I wasn't client. Client was government as represented by the executive authority. DG was not client. So that was done, right? But after it was done, the other side then said, we await outstanding information for us to prepare. And that information was then provided. So the content that related to me was the opinions. The opinions were not discussed, but the issue was were they submitted. Ginwala does not say they were not disclosed. She says you did not take the advice off. And my argument is there is no legal obligation to take advice of a legal opinion, and especially when you disagree with. An opinion is an opinion.
I just wanted to paint a picture here as a political context of the time, because we might be dealing with this in an abstract. At this time, there is a move to remove the director, the National Director of Public Prosecution. It's a different process. It's a political context. Around the same time, there was a move to charge Jackie Silebi,
Yes.
who was the co-chair in your justice cluster, right?
Correct.
So that these things are not seen in abstract. I just want to ask you rather directly, was there a time when NPA, even before you joined it, experienced undue political influence?
While I was DG?
No.
Oh, in
As
my
you
time.
observe from the beginning, and the times when you were DG and the time when you were inside, was there a time, some have said state capture, some have called it different names, was there a time when you would say there was this intensity to influence the NPA?
No. The only time it arose while I was DG was in the context of this minister letter, but other than that...
No, in your general observation.
No. Not.
So there was no time
That
when
I personally
they-
observed, no.
You never observed
No.
anything? Okay,
No.
Thank you, Chair.
Thank you, Chair. Advocate Smelane, I just want you to disabuse me of what I may have heard. I hope that I didn't hear you wrongly. You are saying this scenario has been lingering for long and you would want it closed out. For the past 18 years, it has been hanging on your, hanging as a cloud over you, and you would want it finalized. How should I understand you? Should I understand you to be saying that you would want this interviewing panel then to come to certain conclusions about processes which were undertaken, one by the Ginwala Commission, and then two by courts, in whatever way that there are errors that you are actually then projecting out of the CC judgment? And then thirdly, the third leg of it becomes the JSA process, which you would be the first to accept that it is not for this committee, obviously, to deal with, including the other two legs that I'm referring to. Are you saying you would want somehow this interviewing panel then to come to a conclusion about those issues as you raise them? Is that how I should understand you? Just for my clarity, so that I do not then sit with a worry of what your expectations of this committee is.
Yeah, I think my expectations are clearly that, well, you don't have to find that Ginwala was wrong or what. What is important for me you do is that in relation to the issues you have to consider as a panel, to the extent that reliance by objectors is on what Ginwala said, you satisfy yourselves whether she was actually correct or not. So for example, and that becomes important for me because if the objectors say the Constitutional Court said we are not fit and proper, all I'll say is simply look at paragraph 91 of the Constitutional Court judgment. And note that as a panel, we note that the Constitutional Court does not say Simelane is not fit and proper, because that's factual. That's factual. There's another example, because Ginola said about 3 things or 4 things. In relation to the opinions, she said, you failed to follow advice. And she has a problem with it. This panel must note that a legal opinion does not bind a requester of it. You'd know that as a lawyer. It doesn't. So to the extent that an objector says, because Simelane did not follow the legal advice, don't consider him, you'd know that it can't be. That must be noted, that that's actually correct. 3, Ginola says, these things, these documents, were not disclosed to my commission. They were not in the submission of government. I'm submitting to you that you should note as this panel that the things that Ginola says were not submitted to her were actually discovered and were submitted as per her directions. So non-disclosure does not arise where a discovery process is carried out as required. Where is the non-disclosure?
Thanks for
That's
that
what
clarity.
I'm basically saying.
Minister, just 1 second. Thank you. No, just 1 second. I'm interested in how you summarize whatever. It's easy to go to a court judgment and say, this is not in the decision. Whatever is said obiter may as well has been said obiter. But this is not the reasons for the order or whatever that anybody can come to. And I'm raising this in context so that members of the public should be able to understand the responsibility of this committee in context and its duty as it is intended to advise the president on the suitability of any of the candidates that we would have interviewed on behalf of the president. Now, whatever conclusions that we may reach, in whatever context that we may reach them, it cannot be on the basis of our imagination of what we hope Ginola should have said. What we can say to you is, this particular objector says the following. What is your answer? And you give us your answer as you understand it.
Yes.
And in our report, we would be able to say to the president, this is how we understood all the candidates. It cannot be, advocates Simelane, that it becomes our job then to say the objector was wrong or right. That is not our point. We gave you an opportunity to answer to the objector, and that's why we're going to give you an opportunity again in front of everybody. I think as Prof. Fiken is going to do towards the end, to say to you, objector X says the following about you. What's your comment? If you want to repeat it, you'd repeat it. But it cannot be that the expectation that you carry says that we must actually then make a finding of some kind that says our conclusion is, because that would be remiss of us, because that is not our duty. So we cannot be called upon to make a conclusion on an issue that we are not called upon to make a finding upon. So I just thought, let me and you clarify each other on that point so that we don't misunderstand you to be saying these issues that have been hanging are now going to find closure of some kind. But what should actually worry you, maybe in furtherance of your argument, should be the fact that if the JSA, sitting wherever they are, in whatever form that they have decided to proceed, whether you believe in their process or you don't, you are their member. And the way I understand it, from the fact that you are their member and they may have started a process which you know sits in another forum in court, it would not be correct of us to make any comments about it for as long as you agree with me that that matter then remains sub judice. So to that extent, it would then not be correct for us to say whether Ginola, whether your submissions would have been complete or incomplete in whatever form at the time. because that was not our space, neither was it with our participation. So it cannot be expected from yourselves, at least of us, to say, reach the conclusions that you just summarized to me. And that's why I was asking you, is that your expectation? If it's your expectation, what do you base it on?
Yes, it is my expectation, and you're absolutely wrong. Your responsibility as the panel is to tell the president and advise the president that, President, we looked at the requirements of the legislation in terms of its requirements. We looked at the candidate, we looked at the objections, and the candidate gave us responses. Our assessment of the objections and the candidate's response, based on what he showed us, demonstrates that the candidate is either correct or wrong, in law or in fact. Not that you say that publicly, but the president is expecting you to advise me. What do you think of Advocate Simelane? What are you going to say? No, he's not fit and proper. On what basis? What are you going to tell him? That the objector had said this, and the president's going to say to you, what did he say? And you're going to tell him. Then the president's going to say to you, so what do you think? And what are you going to tell him?
That is fine.
Yes.
That is fine that you map it out. I'm saying I wanted us to be on one page of your expectation, because that's the part I didn't understand from you. So it's fine that you that's how you understand it, and as a panel will be able to decide on
No,
it.
that's fine.
Thanks.
No, that's fine, yeah.
Proceed.
Thank you, Chair. Advocate Simelane, I do hope that the pending litigation that is being pursued by the JSA does give you every opportunity to get the type of remedies you're seeking. What I'm curious about, though, is that in your papers you also concede that this has caused you reputational damage and has been something that's been carrying, kind of like a bit of baggage with you for almost 2 decades now. If you sort of, no doubt you've had a lot of time to think about it very deeply. I'm curious about what you might be thinking about, what you could have done differently. If you sort of go back and say, where could I have acted differently to either prevent or quickly remedy this thing so that I don't carry it for this long? I'm just curious about that. Any thoughts about any missteps or missed opportunities?
Well, first, there are no missed opportunities. So that's important to clarify. When you say remedy this thing, it's after the Ginwala report, what did you do?
It's open. Either before the issue, after the report, after the Concord findings, after you went back to the bar and the matter started to come up, at the time that you're engaging with the GCB, at the conclusion of that conversation, just at any point, what are your thoughts about what you could have done differently?
There's nothing further to do, because I definitely engaged government to say this needs to be resolved, and there's correspondence to that effect, and that it to be attended to. So that was sorted out on that side, but nothing came of that process. So if nothing comes out of that process, there's very little I can do. So all I was then left with was, being in private practice, I then deal with the stuff that the JSA is dealing with, and that will be attended to in the normal course. But on the government side, there was no process set. And if you read the judgment correctly, the judgment says that you can still be appointed, but before you are appointed by anybody, or by the president in this case, he would need to have addressed these issues as well. So that's what it means. So to the extent that this process goes forward, and assuming that, for example, my name is one of those that's taken forward, what Justice Yakub was saying in the Constitutional Court was that if anyone, the president in particular, is inclined to consider this name, he must then reflect on the issues that have been raised. And that is why I'm saying to the gentleman that is why the president would then ask this panel to say, to the extent that these 3-4 issues are raised and they were answered in front of you, what do you make of it? And that's where this panel would give a view.
Thank you, Minister. Advocate Simelane, you made a point earlier on the impact of the delays in processing this matter by JSA, that you've been sending correspondence to no avail. And you also made a point that there is prejudice that you would suffer, or that you are suffering, particularly where fit and proper is a peremptory requirement in certain positions that you may seek to, or which you may desire to apply. So is it then your view that the issue of fit and proper, which is a peremptory requirement for this position, would be a factor, as you made that point earlier?
Yes, the prejudice is not only in relation to this, it's in relation to everything else that's out there, as Ms. Manduleke indicated, it's reputational, right? Because there's an outstanding issue. But it fits in here, in that this panel can say, we'll put him forward as one of whatever number of names the panel put forward. What I was submitting to the gentleman is that this then becomes current and present in this matter, because a deciding authority would then have to say, if I am to consider this individual, what do I make of these comments that were made in the General report? And the question would be, the purpose of this particular panel is to indicate that if we are inclined to do so, in respect of these comments that were made, this is our view. Because we heard and saw what the objector said, and we got the response of the affected individual, and therefore this is our view. So I would expect that yourself or anybody who's a lawyer here would say, President, nobody is bound to follow a legal opinion, especially if they don't accept it. Standard.
Should we move from this now? From this? Just to get into the point where Advocate Simelane, you would have seen what is happening in the NPA as a person who's been there.
Yes.
Your vision of NPA. What would that be? How would we envision the NPA under your leadership?
Minister and panel members, the NPA is a unique institution because it comes from a history. You will never be able to understand the NPA properly if its history is not understood, simply because whatever is happening there today is partly a legacy issue. Most of the issues there are legacy issues, right? So my vision for the NPA is to assist the public servants there to not allow legacy issues to dominate their day-to-day work so that they're able to focus on their work. That would be the most important thing.
Explain that.
What I mean is the legacy issues, if I understood correctly, Advocate Cronje explained where the NPA comes from and how it's ended up here. I won't repeat that. The problem is, just like you have in any other government department, we have people from different backgrounds, from different histories, they have different histories. And they view things differently. And to that extent, many would want that which they are comfortable about based on what they know and what they understand best should be. So you have to unite the people around a common vision of what the purpose of the NPA is in modern day times, which is the NPA is rooted in the Constitution. It's a constitution that takes the country forward. You remind the people of the preamble to say whatever you may have done prior to that, to the establishment of the NPA, to the establishment of the institution, let that be. You focus now on what the Constitution says, you go forward and you do your work in that context. What does it mean? Then it means, if you understand the Constitution properly in terms of the values and so forth, I think that can be done. Your role in the country is to therefore ensure that you conduct your prosecutions and solve cases that are opened by taking them to courts and securing convictions. That's how the government of the day is fighting crime. That is your role as a prosecutor. Get the information, work on the information, take it to court, present it, take the criminal out of circulation, and move on. There are obviously many other different ways. That is the important thing to understand. Because once that is understood, then people know why they are relevant, why they are important, why they need to do what they do on a day-to-day basis. So you need to nurture good lawyers in that sense. Because as a NDPP, we are not really conducting prosecutions. We are providing leadership and a vision, and people must understand, why are we here? Where do we fit in the JCPS cluster? Where do we fit in the broader government? As the NDPP, you give that vision. You show them where they matter. So that's the first thing. So how do you do that? You've got to skill the officials concerned. They're already qualified lawyers. They already know how to run cases, but they're not skilled in everything that they need. Practice continue to be trained on trial advocacy. It's something the NPA needs to do. Just because you repeat something over and over doesn't necessarily mean that you are up to date. From time to time, you need to meet your peers. From time to time, you need to be trained to upskill yourself. So those things will need to be done. That is the important thing. If that is done and they understood the vision, then the external factors of influence become diminished. They'll always be there, Minister, I can guarantee you, they'll always be there. But they become diminished because what you would have built is a character of individuals that understand their purpose and they understand what they are there to do, what they are there about. They understand what is expected of them by society as a contribution. Then they resist any attempt to make their work difficult, whatever way. In the strongest possible way, maybe subtle influences, but once they know what they are about, that gets avoided, right? So when you do that, what are you hoping to get at the end, going forward, looking back? You want to find a prosecutor that's compassionate, that knows that we're in the business of conducting prosecution of individuals that have committed a wrong. The Constitution requires us to still make sure that that is done in a dignified way, because those individuals have rights as in the Bill of Rights. So we must be compassionate to understand that although you are a serial killer, you're still human and we'll treat you with dignity. That's at least the minimum you deserve. Equally, they look at the victims and the survivors of crime. They must be compassionate to them, understand their expectations, understand that they expect to be treated in the manner that demonstrates that there's an understanding about how they feel about what has happened to them. So which means the burden that you place on an individual that we call a prosecutor is an enormous one. And in order for that individual to be able to perform those two conflicting tasks in a way, because that individual is complying with the Constitution, that individual must be appropriately skilled, trained, and assisted to function at that particular level so that they can carry that on their shoulders. So that is the vision. So when that is done, you then target the cases that need to be targeted in their various forms. I think the annual report demonstrates exactly what needs to be done, and there are many of them. As the NDPP, what one would have done with management, deputies and DPPs, would have had as a matter of course, because there's nothing new, everybody knows what they're doing, is sit and identify that at this point in time in 2025, what are the priorities that we need to focus on. There's a lot of cases, so there needs to be some prioritization, right? So clearly, as has been indicated in the public domain, there are cases that relate to certain activities, state of capture, the commissions, GBV, rape of minors, especially statutory rape of minors, rape of adults, as the case may be. And we start working on those cases and identify where we can make interventions. And I have some thoughts about that because these are targeted prosecutions in a way. My experience, and it's part of organized crime, but others may not see it as organized crime. Supply chain management is where, in many instances, organized crime begins. In other words, it starts small, and then it gets big. It starts small with three-coach system that gets abused. It grows according to number until it runs into billions. We tend to treat that as, it's a simply PFMA issue, fruitless and wasteful, irregular expenditure, blah, blah, blah. That's where organized crime actually begins. And I'll show you why I say that. How do you get a three-coach? You go to any annual report of any department or information and you ask them to show you all the payments that have been made just below 500,000. You get them in February or January, plenty of them, right? What does it tell you? Other than the fact that they may have been dumping. It means around that time, some individuals would have set and have used the three-code system to just stay below the radar, 499,000, 450,000, 480,000. And they do that multiple times. And in some cases, upon further investigation, what you find that it's a small group of people, but they run multiple companies, but they use the same approach. It's easy because it's three codes. So in order to do that successfully, what do you need to do? You need to have somebody that calls for three codes in the department. Somebody who says, can I have a code from you? Can I have a code from you? Can I have a code from you? In some cases, people who do that, they call people they know that it's the same person, same people who have these companies, and they just deal with them. So supply chain is an organized crime business. It is not a PFMA offense. It's an organized crime. So that has to change in terms of how it's approached. And how you deal with it is, again, not very difficult. You know why? Every year, Ms. Manulege and the team produce reports in which they tell you where there's PFMA contraventions, or at least they're suspected. So all you have to do, if I were to be appointed, starting, let's say, March, there's 40 departments in the country, roundabouts. You take all their annual reports that were just published now in August. They contain all the information. And it's useful because they contain the information that has been prepared by experts. You look at it, you start investigating. Who do you need as your witnesses to come and say, this is what happened? You go to the AG and say, the auditors that worked on this report and produced it, they have all the information. They've analyzed it. They can talk to it. Can we have them as evidence leaders to come and lead evidence to demonstrate that this is how the contravention has happened?
Wouldn't that be a duplication with SIU's work?
No. In law enforcement,
clarify that. That's what I'm asking, because currently that's what they are referred to SIU. And I say this in the context where we are dealing with duplications, as you know. We're trying to rebuild and recorrect the infrastructure of the justice system, especially dealing with corruption.
Yeah. In my respectful view, when you present a case in court, 2 experts are better than 1, 3 experts are better than 1 to make a case. What the first one in this case would be needed for is that as the Auditor General with the stamp of approval of that office, that witness would say, we have done this work and this is what we have found, and I, as the auditor, I conclude that the following wrongs were done here by the following individuals, and these are my reasons for doing so. And they'll even go further and say, before I finalize my report as an auditor, We sent the draft, we sent a few comments, and we received management comments. We looked at them, analyzed them, attended to them, and we still conclude that on these ones, there's something wrong. That's valuable because what it does, you immediately put the other side to bring their own experts, similarly qualified, to disprove that. That's the first thing. The SIU will bring another expert. If the SIU had an auditor as an expert, that auditor may need not deal with the PFMA issues because the AG auditor would have done it. That auditor may deal with something else, financial information and other things. So there wouldn't be a duplication necessarily in that way. So that's how you split your experts in terms of the point to which they talk.
The issue why I'm raising duplication is because you spoke about if I'm NDPP, I'd bring the investigation. And my issue is that, but currently, that's what SIU investigate. I'm not saying NPA does not have a role, because currently as SIU, as AG does the reports, refers to SIU, SIU then does a further investigation and concludes, and then hands over those cases to NPA. And what I picked up was almost like a change of this process. Is that my correct understanding and reading of what you said?
No, unless I wasn't very clear. In my respectful view, there'll always be a difference between what the Auditor General stands for. Tactically and strategically, what you need in court for the Auditor General is the stamp of the office, because it carries power. So if somebody is a credible witness from the AG's office, concludes in a way that is not refuted, that's a slam dunk case as far as PFMA contraventions are concerned and those criminal offenses are concerned. That's done on its own. What the SIU side does, the SIU goes further and looks into other things. So that can relate to other charges. And in respect of those charges, they'll have their own expert witnesses to attend to whatever they need to attend to. And I believe this would even help in the sense that PFMA charges stand on their own. So if you want to create a culture of compliance, I would say let's just start with those. Even if you're investigating corruption as well, continue investigating it. But in the meantime, if we can prove fruitless and wasteful expenditure or irregular expenditure, we get it done and dusted, and we get a conviction. Even if it doesn't, in fact, I think it, depending on the amount, I suppose even if the amount is a little bit high, it may not necessarily require a custodial sentence. It's enough to get a suspended sentence. But what we got is a conviction. That's what matters. Because by the time you appear for corruption, fraud, and theft, you're already a convicted person, which helps in the context of sentencing, because you are then able to say to the presiding officer, this one was already previously convicted. And that changes the game altogether. And nobody wants to be taken to court to be charged and stands a chance of being convicted for the second time, because they know that sentencing gets worse if you're still within the suspended period. So that type of targeting of prosecution, in my respectful view, is important. But there's another side that is not always thought about. The BBEE Commission, where fronting is criminalized. I don't recall enough cases being looked at. Maybe it's because there isn't enough fronting. But I would imagine that where you have a body that conducts investigations of that work already, and they produce a report in which that body concludes that in this matter there is fronting, there's very little further investigation to be done by EDAC if it's EDAC, or the DPCI if it's the DPCI, because experts in the field in that organization have already got the reports that says exactly what you need. You clean that up, you go and prosecute that, and you get the results. And the impact of it is that once you get a successful result on fronting, you deal with the systemic issue of fronting generally as a whole. And you assist small business to partner with people that truly value their skills, as opposed to people that partner with them for purposes of renting their skin color. That is important of dealing with it. Thirdly, the Competition Commission amendments were made a couple of years ago, where certain behavior was criminalized. Collusion, certain restrictive business practices, abuse of power. I don't remember a prosecution being run on the basis of a concluded investigation by the Competition Commission that abuse of power has been run. So the point I'm making is that we already do have bodies with qualified experts that do the actual work and produce the content that's required. But for some reason, we seem to be missing that. It may be that because of the volumes of other matters, it's an issue the NPA sees a little bit further down. But the impact of it is important. It's economic. It affects small businesses. Yes, it affects big businesses, but the biggest beneficiaries of success in that area are small businesses. The PFMA issues deal with governance and conduct within a department. You can even go further than and go to a municipality and go to an SOE, as the case may be. But if you just start in a department, you're done. In that you begin to create the culture that you need that changes conduct. If you change conduct in the department, the outsiders who are coming in to exercise influence start finding resistance, because these people here on the inside know that when our report comes out, there's going to be a bunch of guys that are going to look at the annual reports and start working on it, and we get implicated. It's that simple, amongst others. So for me, it is that.
Advocate Simelan, just
Yes,
a
ma'am.
second.
Thanks, Advocate Simelan. You earlier raised issue of skilled, trained, and targeted
Yes.
interventions. Now, I just want to know what additional skills. I hear you that from the respective areas of focus, there would have been foundational work and outcomes secured, or at least suggested, that would go to the courts. But inside the NPA, because throughout these 2 days, we've been hearing how there are limited skills. So what kind of skills would you bring, for example, for people to be able to take the AG report and go and prosecute on it and argue wrongfulness based on the information provided by the AG, or argue collusion based on the report provided by the Competition Commission?
Yeah. I think it's important to always not take only the version that says there's a shortage of skills. Someone must be able to say, what skill are you talking about?
That's
Yes,
my
I understand
question.
as a
Yeah.
question, but somebody who says there's no skills, they must tell you, what are you talking about? What skill do you say doesn't exist? Excuse me. But typically in the NPA, the most important skill must be the ability to present a case. So trial advocacy is important. And there's different levels of it. Basic, elementary, depending on the level of prosecutors. The more senior they are, the more experienced they are, the higher the advanced advocacy training requirement would be needed for them, firstly. Then there's also financial training, the ability to read financial documents. There are people, maybe us around the room, who may be qualified, but we may not be able to read a balance sheet. Give somebody a balance sheet, they don't know what it means and what it represents. And they may not be able to find a crime right in front of them because they just can't read a balance sheet. So part of the training would involve financial training, reading balance sheets, being able to understand things. Share price manipulations. Find somebody, for those that deal with a lot with fraud, commercial crimes, find people that provide specialized training to be able to identify share price manipulations where information is given. So in the NPA, we'll be able to look at the gaps. So when you look at the cases where there's successful convictions, others where they are withdrawn, others where they are struck off the roll, and they're going nowhere, it's important to sit and understand what's missing in what was withdrawn. Why was it struck off? What's missing? Fine if you can't find a witness, that must be found. But it can't be that we've got 5-10 arch-level files, we just don't understand them. We just don't understand them. What do you mean you don't understand them? Read them. We've read them, but we're not sure where the crime is. That could be an indication of a deficit in ability. And once that's identified and people are skilled accordingly, that gets done. To be able to find people that hide assets in trusts, in whatever other instruments that are utilized, And knowing that people actually do that, as many do in the public service. They declare and make it very clear that I'm clean, I don't have all of this. But a further check by those that are skilled and trained in that discovered that the bugger has an offshore account, that type of thing. So that type of identification of skills required starts with a painful exercise of going to look inside the organization, those that are struggling. Sometimes it's easy, you can go to court and witness it yourself, but based on the statistics that come out, and you start engaging with the DPPs to say, why is there prevalence of withdrawals in your case, or struck-offs, or lack of meeting the target as far as convictions are concerned, you'll then discover this. But my sense is that if you speak to people honestly and they don't fear reprisal, punishment, and judgment and that type of thing, people will tell you what they need. They say, okay, I think I can talk, but I can't write. So I need training on writing skills, because many arguments are won on paper based on how well it's written. You can be articulate, but if you've written badly, decision is already made. For other people, it's vice versa. You find that can't write to save their lives, but they can speak themselves out of any situation. Not one of those, but that definitely does happen. So you've got to look at those things, identify them, and skill them appropriately. Then you can even go overseas. It really just depends. And if you benchmark, you know what level people, somebody at the level of a director, you should know you should be skilled to this capacity. At a chief director, you should be skilled to this capacity. Entry level, the minimum is this. So that's important. Then if you target, you can go as far as you go in the sense that you can target really basic things that everybody speaks about, means sitters. Every year for the past, I don't know how many years, we're always talking about sitters there. So we may need to want to look at that to say, let there be a team that just focuses on sitter, and it depends on which one. Sitter as in the training authorities, but sitter the institution, the information technology institution. It's been a problem for people for years. All that I'm saying is that at the end of the day, it has implications for work. Is there sufficient human beings now to do the kind of work we're talking about? And I think there's a big risk in being all over and taking too much. One typical case that we can all identify with, but I wondered the other day if we think about it, the Meiwa case. For how long has it been running? That long. It's one guy, Minister. It's one guy.
8 years.
No, however number of years, it's one guy running it.
Well, I'm saying 8 years.
8 years, yes, indeed. Advocate Balo has been running that case by himself for 8 years. He comes tomorrow, he says, I can't take it anymore, burn out. The case is not finished, it collapses. And yet it's 10 years late in the system. It delays further. So in all of this, with the menu of things government mandates the NPA to do, there's so many resources. So issue of resources would have to come in. So state of capture, then you add Madlanga Commission and all of those type of things, and the Madlanga Commission will have rollover of things. There is no way there cannot be a discussion about the number of human beings needed to come to attend to the problem. It has to happen. And once you bring them, you can bring them already skilled, they tend to be more expensive. You can mix, bring a few that are already skilled, they tend to move much faster. So they can do in a month what others would do in 6 months. So you need those, there's no doubt about it, even if you have to bring them in from outside. Find the money, attend to them. But you've got to build your triangle so that the bottom has a lot of people, pay them adequately. But you know that at least I'm going to lose 16 months, because to train them to be able to be proficient can sometimes take that long. So you need a bit of patience. But it may start slow, but then going forward as they acquire the skill, they then move a little bit faster.
Are you?
So that really is the kind of vision. I could cover other areas that I think are important. One that I noticed that I found strange when we deal with corruption is, and I can't understand the choices that have been made and what it means. There's been a talk of amnesty for the past 2 years, 2.5 years, even more in the shadows.
Amnesty of?
Amnesty in corruption matters. There's a number
Where?
of people.
I've not heard it.
No, Minister, it's been a discussion going on. We'll
I'm
have to
in the
catch up
wrong
with that if
circles
need be.
then. They don't include me
No, no,
in
that's
those
the wrong circle.
discussions.
No, there are people that have thrown suggestions for quite a while to say the problem of corruption and state capture has been so big and so much money lost that what if there was a general amnesty in the country around corruption, provided people brought in the proceeds? Is that palatable to society? Is that something society would be willing to consider? Those who are proponents of that approach suggest that we've gone just too far down the road. The only way out is to undertake that people won't have the negative consequences that they fear, but we'll get back a portion of what we lost, especially money, even if it's offshore, and we start afresh. It's that kind of approach.
Are we not having enough tools to be able to get that money, even if it's offshores? I thought that with the availability of the work that is being done by AFU, FIG, and others, we could, if we rather have the right people to drive that, instead of, because I know you are saying it's what is being discussed, and I'm exploring it because I'm hearing for the first time almost. Wouldn't that be seen as also encouraging corruption? Because I always say corruption is not a victimless crime.
Absolutely.
It's got victims.
Absolutely. Yeah.
And in our system, then what do we do with the victims of that corruption if we do the amnesty? I mean, you'd know we have a situation with the TRC Commission where the victims are saying there's no justice. Until people are prosecuted, they can believe that there's justice. Wouldn't we face something like that, as we think?
That's that's exactly the counter argument to it, to say, no, maybe hang on, that may not work very well. And I think that discussion hasn't sort of gained momentum, and I think slightly for that caution to say, what will it look like we are saying, to people? But it was definitely floated. A few individuals definitely floated it, seeking to influence the process. But the reason why I'm raising that is that there has been, and I think it's worth looking at, where in the NPA, one or two companies have come forward and returned money on the basis that there's a no guilt arrangement, but also that they may not be prosecuted or need not be prosecuted. There's a problem with that. Because what is that? What framework is that? Personally, when I can't even remember the term used because I don't understand it. I've never heard of it. I know plea and sentence agreements, but I don't know this one where it says we'll have this kind of arrangement, bring it back and whatever. But there's merit in looking at what was attempted to be done. It may have merit and it may be explored further and it may be a solution, because the first prize is just taking that much longer and the menu keeps growing bigger and bigger and bigger. And if there's not enough resources to feed the system, bring in people and naturally technology to deal with these things, which is an inevitability, it needs to be done. If there isn't money for that, then there must be pragmatic interventions at some point about what we do where. So the NPA can play a role in that by indicating what it can do and what it is finding difficult to do and what it completely cannot do and what it needs to do. Similarly, it goes to the police and so forth. The problem that we'll experience with the two commissions that are prominent, that make it that much harder to look at the work, is that it's exciting to have a confession, to get told the truth by the confessor. The problem, can't use it. Can't use it. Come and confess and tell us everything you've done, Gori, you name it, can't touch it. It's inadmissible. We still have to start afresh. I suspect that's why in some areas it's taking longer. So I would not blame the NPA, and I've defended it in various fora, that whilst there may be legitimate criticism in respect of the current NDPP's work, I think people are misunderstanding the difficulty of having to find some of the information while everyone is aware that that's the person they did it. The only reason they're standing there is because they confessed it. Otherwise, we know. So the NPA needs to come out and say, in respect of these cases that are standing still, the problem we have is basically this now. Because the frustration of the public is that with everything that we've heard, we don't understand why you can't move. It's because we can't use it, but also because we have to start afresh and dig it, which was always the issue with the SIU minister, in that they can conduct all investigations. You still need the DPCI to start and conduct an investigation. You still need EDAC to do that kind of work. So corporate prosecution side of the system doesn't look great. It does not look great. If you go to 2010 Stadia, there was deep collusion, deep corruption. A municipal manager dies for whistleblowing. What happened to those companies? What has happened to that case to date? It's 14, 15 years later. You move on to others accordingly. So those issues do matter, Minister, other than the usual cases that we all tend to talk about. In fact, here's something important that I thought I saw. A couple of months ago, I saw an article that said KZN last year had about 10,000 children giving birth under 16 or under 18. 10,000 children delivering children. I would have hoped that, and it's not only there, I think there are other jurisdictions, but the number, I thought KZN.
The highest is Eastern Cape and KZN. Yeah.
Eastern Cape and
is the
KZN.
highest.
Yeah, I looked at this and I thought, the kids are delivered. Somebody should know who the father was. So depending on age, I suppose the younger they are, they may be unable to identify the culprits as quickly as possible. But I'm imagining 13, 14, 15-year-old can say it's so and so. That becomes a person of interest, at least at a minimum. Without exposing the identity of that person, the person gets engaged to say, this is what we have, submit yourself to a DNA. Nice, quiet, we don't have to besmirch your name in case it goes wrong. You work with that environment, it's managed quietly. You get the DNA. If it's not the person, it was quiet, the person was never exposed. It must be handled sensitive. But if it's the person, you've got your culprit. I don't know how long forensics takes these days. But
Is there a quiet process?
no, there is, Minister.
Because I deal with litigation of the state, as you know.
Yeah.
False accusation and all those things, whereby the minute you say a person, then they say no. I had to explain to my wife and my family why I'm going here. I was asked, and therefore there's implication, and legally that person can take us to court.
Well, either way, whether you do it quietly or not quietly, you'll end up with that scenario anyway. But what I'm trying to suggest is that...
That's what I'm saying. Why quietly?
Well, in the sense that you may find people that don't want their name associated with that. To come and sue later doesn't sort you out, Minister. You can say, look, I was wrongly accused, I sued, I got 300,000, so you're still the guy that, once the damage is done, you can't fix with money. We're not like America where at least you get millions. You can go hide in an island. Here in South Africa, you get 50,000, and the best you can get with that is what? Tickets to a suite.
Okay, I would like to move to the next segment.
Yes.
Because I think we've gone in detail in terms of what you see as the work that needs to be done. And I want to open for the panel in terms of their questions, and then end with Prof. Somato Tafikeni with taking you through the comments. Just to check the side, any other question? Okay, from here. You've got advocate.
Yes,
Proceed.
Minister, it's just a small one. I would like to know your opinion on laboratories, because forensic laboratories are the biggest hold-up for and whilst you are there, also maybe just club to Zella care centers there. We've got 66 of them now, and no very limited funding from government. just briefly.
Yeah.
Sorry, Minister,
Yeah.
I'm taking time asking.
DNA is the responsibility of police, but we do work with that, but it can go on.
Okay, all right.
Yeah.
No, I can withdraw it. It's just that I think. Okay.
That issue's been there for a very long time. Now, how many labs must you basically have? Ideally, a dreamer would say a province, there must be one, at least a province, to focus on those statistics, you know. But others would give you better to say you don't need 9, you may do well with 5 or 6. We don't know what the holdup is. The police will explain. It may be an issue of resources, but there must be a way in which that is identified. It's either it's money to have them and equip them, or if the money is there, it's finding the people and having them appropriately trained to deliver. But there must be an answer of some sort. It can't be an issue that gets discussed all the time, because the numbers we've discussed about these kids, those are the victims the minister is talking about. It's 10,000 victims waiting for justice. And if you deal with 1,000 of them successfully, the other 9,000, you can't. Then they go back to school. You know, whatever the numbers may be in each province, that's a problem. So that's the first thing. Tutuzela care centers, I suppose, will always be a money problem, in the sense that to create it, it's a model that is great, that's excellent, it works very well if it's functioning properly. It delivers. But it's a luxury right now, because in terms of the numbers they deal with, they are a pittance compared to other numbers out there. They remain not as accessible as they can be, as they should be. And the only holdup is money. And somebody else would say, if you sorted out the labs, you can get more numbers done than in a Tutuzela care center. But the problem is that a Tutuzela care center is advantageous because you have more of a skill set and you have an approach that manages issues in the best way possible. So money, yes, is a problem. Thank you, Minister.
You can proceed.
Thank you. A quick question. So what are the top 3 things that diminish public trust in the NPA?
3. First one is not knowing what they do. Just have no clue what they do.
Huh?
Well, not me, I know what they do, but I'm saying the public doesn't know what they do.
Oh, okay. I thought you were saying NPA colleagues themselves don't know what they are doing, advocates. I was like, you.
No. No, those ones know very well. They know very well what they're doing. I think the first problem is the public just doesn't know what you do. How do you make decisions? The choices that you've made, how do you make these choices? Choosing this one and that one. So 2, it's the lack of transparency. Decisions tend to be made quietly in a closed group, collegiality. That's just a issue of habit. We need to be more transparent and be more engaging. When the NPA communicates, it doesn't communicate the detail that it needs to communicate that builds confidence. And that may need to change. Yes, it's important to let people know that the case came to court and left and the matter is postponed or withdrawn, whatever the case may be. Maybe a little bit more. A little bit more explain why is the matter postponed for 6 months, because that's the next date, purely on the basis that for some reason somebody could not arrange a foreign language interpreter. How did that happen? We're losing 6 months because an interpreter couldn't be found. And yet when the matter was postponed to that date, those involved knew that when that date comes, an interpreter, foreign language, would be needed. So why is it that when the matter comes, the issue of a foreign language interpreter, was it deliberate to create a further delay? Or something fell between the cracks? Are there no partnerships? In my time with Justice, we had an MOU with Pansal to say, can they build capacity to be able to provide different foreign language skilled individuals that the department could borrow from if they were needed in court, as the case may be. So those things, they're not soft, because I know people tend to say communication is soft. It's actually very strategic and very key. So I won't use the word soft, but for me, those are the most important. When people get to court, ma'am, they come to court, they hear the matter is postponed, and they loiter. You can see that they have no clue what just happened. Unless somebody goes to them and sits down with them and takes them through. It's postponed for this reason, especially in cases involving violent crime, let alone rape and sexual assaults or GBV as the case may be. So that becomes very important.
Anyone from the two colleagues? Fine. Prof, I hand over to you for the segment of public comments.
Well, thank you very much. 4 hours later, we're almost there. This last part, Chairperson and colleagues, the nice thing is that we front-loaded those because it's mainly your comments received from 28 organizations and individuals, mainly individuals, then 2, which I should start with, were in support. One being the Deputy Secretary of NAHAU within the Department of Justice, and even saying that he wishes that you had to come back as a DG. Then you also had another individual who indicated that you have depth, experience, resilience, and institutional knowledge that you'd bring. But then the balance of the comments have generally been objecting.
Yeah.
And in the objections, they referred to the Ginwala observations on your character and integrity. The issue of integrity keeps coming again and again. Some implicates you in the role of capture, state capture. Of course, they tend to put it in broad terms at times. And of course, the media generally had raised those issues as well. And they often cite the Constitutional Court. Some, of course, saying that Constitutional Court finding against you, but others accurately saying that it was on the President having failed to look at the Ginwala and take that into account as you were being considered. Then we had one from a former NPA member who indicated that he's now retired but objects and go on, you must have received the documents on the specifics where he's objecting as to why and what conduct there was when you were there. But the bulk of them, which is something that I would like you taking others, of course, into account because you were given a chance to respond to them. You gave a very extensive response. Most of them talks to a very fragile NPA that is struggling to reposition itself. Then they say you have these many pending cases, unresolved issues, which by your own submission and presentation you have also indicated, they say almost this would squeeze the very oxygen from an entity that's trying to rise should anything happen on the pending cases. What would be your reflection to that? Because in essence they say in a hypothetical situation you were considered. You have to deal with these pending matters unresolved, and this forum, as it was indicated, can't resolve those. And then there's NPA that also is facing major hurdles that it has to deal with as a repositioned organization. How would you deal with that recurring concern. One, integrity, the other one, the one of the reputation and the reputational risk.
Well, I think thank you. I've demonstrated to yourselves instances where that submission has no merit in relation to Chinwala. Just basic, at a common level. Non-disclosure is a non-issue because there was disclosure in the way that legally it's accepted. Discovery process, it's done. So that takes care of two things. It takes care of the letter, it takes care of all the other attachments. Opinions, no obligation to follow them. That takes care of that. Accounting officer issues, the head of department is responsible for the relevant issues, as accounting officer is responsible for the finances. And the issues that Dr. Chinwala was relating to are issues relating to the responsibilities of the DG. Those three fall away. So there's no merit as far as that is concerned. So this shouldn't recur. Whilst this panel doesn't have to make anything public, what I'm trusting it will do is to advise the President properly. The issue that is sub judice is the one that remains outstanding. Can I respond to the issue of the arms deal that I was informed? I don't know what Advocate Cronier
Before you
said.
move that one, you're saying which one is sub judice?
The JSA one.
The JSA one
Yes,
was
it's in
first,
court.
just to be clear, first they found you guilty
Yes,
and
they
then
did
you
find-
appeal.
Yes, there's an appeal, yeah.
So there is an appeal, but they have already had one. I wanted you to deal with that because it wasn't clear that it
Yeah, they
was
didn't
as
deal
if
with the appeal at all.
they haven't.
So what they
dealt.
did instead, they just moved. So the appeal remains outstanding, and while it's outstanding, they just move for a strike-off. So the issues before court are sub judice in the sense that they will address these types of issues, whether
Okay.
what they've proposed to do, they'll do.
No, I wanted to be
Yeah.
clear.
No, absolutely. The issue of the preservation order, can I deal with it because it was suggested? And I'll deal with one or two other cases. She's correct. That got done, Minister. We did that. No, that got done, Minister, and it was done legally so. And I would have expected by now that if anybody felt that anything unlawful was done, they'd have gone to courts to challenge it. What had happened again there, we have two things. We have the arms deal criminal investigations that were going on the side, no problem there. Those continued, they're not the issue here. But the individual was also subjects of those criminal investigations. But then there was a preservation order on a bank account that he held in Switzerland. That's what the preservation account, order was, on the basis that it's unexplained income. Nobody knows where it's coming from, so we're holding it. So his legal representatives, Advocate Celias, SC, and them wrote to the NDPP to say, there's a preservation order and we're making representations, and we argue that there's no basis. And they submitted documents to that effect, and they asked for, again, a meeting to have that discussion. So the documents came in advance. Arch-Lava files, about 2 of them or so. I looked at them, and I said, okay, the meeting can take place. But I then asked the head of the FU, Mr. Hofmeyer, that we discuss this, which we did, and we agreed that we would meet Mr. Silas. They would bring the team with. Advocate Cronier wasn't there. So if she said anything here, it's obviously hearsay. But I don't disagree with it because it virtually did happen anyway. So we had a meeting and the legal representatives came and the team sat like this in a boardroom and received a presentation. And
This team involves as well the head of FIU.
AFU, yes, yes, it was there.
AFU, which was leading.
Yes, it was
this
leading. It was
matter.
me, it
Okay.
was him.
And
I
then
think
from the
it was another
province
deputy.
that was dealing with it?
It was
Well,
Gauteng. It was this one.
It was
Yeah,
Gauteng.
it was this one. So it was an HQ matter. So, and then they called other prosecutors who were dealing with the broader arms deal criminal investigation, just to be present. So it wasn't an issue. So they were all there, close to 10, 15 people in a room. So they came and then they gave a presentation why they believe that the preservation order should not be taken further to a forfeiture order, because that was the next step that was gonna come. So the official said, well, we haven't seen some of these documents, we need an opportunity to look at them. So I said, look, thank you for the presentation. Leave these documents, we'll discuss them internally, and then you'll be advised accordingly what the attitude is. That was done, and then I took those documents and I said to the colleagues, I'm gonna make my own copy, and I'm gonna send these documents to everybody else for everybody to have their own copy. Then we'll meet to discuss. The following week, we convened. Everybody had read, we sat, and we had a discussion. What is the issue here? The issue is we don't know where this money is coming from. Okay, how far is the investigation going? Investigation is going. The preservation order is going to come to, is going to reach its time frame. Preservation order is a couple of days, I think 90 days or so. And if you don't extend it, it lapses, that kind of thing. So we started having a discussion about this thing. And I said, let's all discuss, because I must respond to this. So let's all discuss to finality. Everybody's at time. Let's now comment. We went back and forth, back and forth, back and forth, back and forth, back and forth. And every time we went back and forth, we kept looking at the documents submitted. Then the numbers started changing. You know, it was a majority, no, let's extend it. Minority, no. Then started moving. Then I asked the number of those that were advocating for preservation order to be extended, and others were saying, let it lapse or withdraw it. Whichever one you want to do, it's your decision. Because they were not so sure anymore, right? There's a lot of information. Then in the documents, I drew their attention to a contract that was there. Said, as everybody looked at the contract, and others said, yeah, we've looked at it and all that stuff. I said, what do you think of this contract? I said, yeah, it's a contract between this individual and these other parties. Okay, I mean, have you read what it says?
What's the parties in the arms deal?
Yeah, well, in respect of just these two parties, the individual whose account was blocked, and another party, they had their own agreement. Yes, it's part of the arms deal. They are in this agreement. So in this contract, they agreed on certain services. So that's fine. It's not an issue. But in there, and nobody had an issue with those things. So we say, so what does it represent that there's a contract? Is it legally binding? Is there anyone with evidence that this contract is not legally binding, it's been set aside or whatever? Because as it is, it's legally binding. We debated that. The conclusion was it's legally binding. It's okay, it's legally binding. So what does it mean? We look at it, say, well, it's legally binding. Then somebody said, yeah, the amounts involved, they were not indicated in the contract, but a commission was indicated. Said, okay, there's a commission there, okay. So it looks like the monies came from this, based on this contract, which is what the parties had submitted in their submissions. That it's this contract, the basis on which the commission was paid and the parties were paid. So is there anybody here that would say it's unexplained income? So nobody could. Everybody accepted that, no, that explains it. So if it explains it, is there a basis to hang on to the preservation order? Because it's been explained. What do we do? This is what the parties have said. How do we respond to this? Well, you can't explain. So the long and short, the conclusion was, well, because the matter of the corruption on its own is still being investigated and there's no conclusions and there's no link to this particular individual, we can't say that this individual is still part of or is part of that corruption investigation, but that this individual has given an explanation which, on the face of the documents provided, there's no counter-argument that we can rely on. On that basis, I then indicated that, well, if that's the case, it looks like it's going to be very difficult to extend the preservation order. It may very well be withdrawn, and that's how it was withdrawn.
It was a team agreement.
It wasn't a team agreement. Basically, they said it wasn't an agreement, a team agreement. They said, we understand, we see it, but it's your decision as NDPP. Then I said, I have no legal basis to argue if I don't have information.
I'd taken over from Prof. My apologies.
I'm not going to start anything new. It's just the completeness of record to say that the Labour Federation, COSATU, also objected, and the Freedom Under Law also objected. Active Citizens Movement also objected in addition to that. And also another part is that the Public Service Commission has also been used as a reference point for the findings. But in this case, it can't be your fault because they were asking the executive authority to take an action against you. And if the executive authority didn't at the time, so it is just the list of things that they were referring to, all arising from the Ginola matter and things of that time. It's just for those following the proceedings. Minister, thank you.
Thank you, Minister. On the Public Service Commission, if I can close that loop, it's not entirely complete, Prof, because the Public Service Commission, the problem with that investigation is that they also never spoke to me. It did what they called a desktop investigation without speaking to me, and then by the time it was produced, they had a problem because I was not given Audi, and that's how that matter ended.
And did you challenge the report at any stage?
No,
because of that flaw?
Of the Public Service Commission? No, I didn't challenge it, no.
Just something from my side, Advocacy Milan. On your response to us dated the 8th December, there's an issue that you flagged there in relation to Terrell Blanche, Eugene Terrell Blanche murder.
Yes.
You said.
On the 8th of December.
Do you have the copy?
Yes, I have a copy of the document. I remember the Terre Blanche matter, yes.
This one you are responding to, I think you are responding to a comment. But I do find something in it that I wanted to talk to you about.
Yes, paragraph 5.
Paragraph 5.
Yes.
In there you talk about, as the NDPP, identifying a prosecutor in the DPP's office in Pretoria who'd attend on the bail, but also yourself as NDPP traveling to Ventersdorp and personally meeting the families of the deceased with the prosecutor, but also in terms of an African minister, I think here, who had instructed to speak to the family in Afrikaans, and also the language, you highlighting that he did, and the family. I also addressed members of the AWB who had gathered outside to protest.
Yes.
I go back. Where is your DPP at this point?
Oh, no, he was there. He was part of the decision. He actually is the one who indicated the best person to do it.
He indicated?
He indicated the best person who would do it. The issue was, when we're in a meeting, when we're discussing the case, and the issue was, how are we going to approach what was likely anticipated would happen there in terms of protest and so forth, right? And the suggestion, even from the DPP, was that, can you as the NDPP go and assist so that we can quell whatever volatility that may have been there? Then I said, no, that's fine, I'll be happy to go. But I don't speak the language. Do we have people here that speak the language? And he indicated the officials, and one of them happened to be African. Then I said, okay, why don't we use this one? You know. So he said, no, actually, this is the perfect one that you can take. Why don't you go together? So he assigned that particular individual. It was the
DPP in Northwest.
No, not Northwest, here
Gauteng.
in Gauteng.
And where is your DPP prosecution?
He was around. He was around. I think it may even been him, but he definitely was around. Yes.
This intrigued me, and you'd remember previous as well. Yeah. You spoke about the police and how the hierarchy works in NPA.
Yeah.
So as I look at the comments, I think I missed it. I would have raised it earlier on.
Oh,
as
yes.
I look at the comments and your response now, I'm picking this up because it does concern me.
Yeah.
That you seem to have been too involved in prosecution and also jumping over almost other, because you had a NDPP, you had a DPP. The DPP says, no, come NDPP and deal with the court matter.
Yes. No, I think you have it wrong, Minister. Yeah, it's the NDPP.
Help me understand it properly.
In this, the NDPP doesn't deal with prosecution decisions. There's no need, but the NDPP is present.
I want to understand your role here. What were you doing?
No, it's
because
just to be around.
Explain.
No, it was for the NDPP to be around and deal with third parties, those who are protesting, and to assist the prosecutor by just being present and calming everybody down. The issue is it's almost like the Northern Cape one.
It was more support.
Yeah, it's more support. You do nothing. You just go and support.
No, that's why I'm asking, because you didn't specify.
Oh, yes.
And then it almost looks like you are the one who was going to court.
No.
To deal with the matter.
No, the only matter where I went to court myself was in the Northern Cape.
What was happening there?
Yes, I deal with it in paragraph. Same document, I deal with it in. Is it this paragraph? Okay, it's not in this document, but it's one of the cases I explained.
I didn't pick that up.
The document on dated 20.
Did you pick that up? On which deck? Paragraph 4. Yeah, it just says it is common cause that I'm the only NDPP ever to have roped and moved a case in a court.
I don't deal with it in
detail. I didn't even know.
I can't remember where I may have put it then. But I did submit it.
That's the only sentence.
No, I did submit it.
No, it's this one.
I did submit it. I can't find it now. But effectively, no, it's
paragraph 3. In the start of the prosecution of the chairperson of the NC, Mr. John Block. In this case, I personally roped and moved the bail application on behalf of MPA. And attended the bail appeal in the High Court.
Yes. It's the only time where I specifically roped at the request of the Northern Cape team. No, they were all there, but they were fearful. The situation was problematic from a security standpoint. And over time, the DPP requested that I come and assist the team. Because Northern Cape was small and everybody knew everybody, the prosecutors didn't want to go because they feared being identified. So I brought a team from KZN to go with me, to go and move the application. And I then moved that application.
I think it's late at night as well. You'd understand my discomfort where I'm sitting.
Yeah, I'm sure to be explained to you.
Because when we say, let me come to this point. I have an issue if we would say that NPA would have a DPP, would have prosecutors that operates with fear. And it will have to take an NDPP to have to go into a court, because when there's a review to be brought in, you've nullified yourself. I don't know the legal language they will have. I don't pretend to be a lawyer. So I specialize in my own areas, and that's why I would go into the areas. But in understanding the policies and the role of the NDPP,
Yes.
you could have easily compromised that case, because if the review is to be brought, where do they go?
The review of what?
Of that case. Let's say there's a
It's in court.
representation.
It's reviewed in court.
There's a representation to the DPP. DPP decides yes, and you think, then it's brought to you to be reviewed. Because the fact that the person is charged at bail doesn't mean that the case is done. It can still be, there can be a request for representation.
Yes, a bail is not a trial, Minister. They
Yes.
can still be, no, you're not functus officio on that basis. Bail proceedings are completely separate from criminal proceedings, like trial proceedings. It shouldn't apply there. They could still review or make representation, sorry, if that's what you mean. Because they'll be making review on the merits. Bail is a separate sui generis.
So you only got involved at a bail.
Only the bail.
And then what happened? Their fear of crime, what happened? It diminished. Then they carried to the case.
Yes, they did after a while. Well, there was a broader intervention.
Remember, I'm coming with your logic.
Yes.
That I went there because they said it's a small province. We will know each other. Therefore, there was no one I could send except myself as a leader. Go take it, and I move the bail. But then I'm asking about this because I'm assuming from where I'm sitting that the fact that these people were scared, it means you would have had to take the responsibility. Now you are saying, no, I didn't take the responsibility of the case. I moved out.
Yes.
Now I'm asking, at the time you moved out, the same team took the case further.
Yes, there were other arrangements that were made around security to diminish that, because the matter was reported to the police, and the police had to intervene and create an environment where, going forward, there to be diminished.
Okay, so we
Yes.
couldn't do that at the beginning.
No, it initially couldn't be done.
Why not?
Well, that's what the DPP indicated to me, that they've tried everything. They requested, just as a start of this thing, can they be assisted on that basis?
But why didn't you do that instead of you going to the case? Having experience in the justice cluster, the network that you'd have had, being former DG, obviously you'd understand, you'd know who to reach out to be able to do that. Why was that not done instead of you going to court?
No, it was still done, even for everyone, including myself. That was done, Minister. It was decided as the prosecution that let's do it this way in order to attend to the threats and in order to attend to just the fact that we need to get started one way or the other. So to get started, right now, those prosecutors and the DPP couldn't do it. For example, I'd ask the DPP, but what would be a problem if you did it? I could come and support. They wouldn't have it. So after a lot of discussions, the conclusion was, just help us get over this line, and then going forward, we'll see how it gets managed. And that's how the intervention continued over a period of time.
Mr. Mtlou, and then...
Thanks, Minister. Maybe this miscomprehension of the facts as you presented them. My impression was that you actually attended to that matter. You appeared.
Yes.
You appeared. Now, the issue of having now compromised yourself in as far as in the event that there would be further review processes, representations that are to be submitted to your office, you would have rendered yourself unavailable to attend to that, in that you would be functus officio in that space.
No.
Because you would have had intimate knowledge of the matter.
No.
You would have dealt with the matter at bail stage.
No. It's a bail application.
Yes.
Mr. Mtlou.
Yes.
As you know, a bail application is still a matter pending for investigation. And all that is being decided in a bail application are bail-related issues, only that and nothing else. It doesn't deal with the view on the merits.
That's actually not really cast in stone. You could have a situation, unless you're saying in that specific matter, merits were not dealt with. But it's not cast in stone that in bail proceedings, you would not necessarily get into the merits.
No, in this case, it was purely about whether there is bail, and if there is bail, to what amount.
Okay.
Yes, thank you. I just want to check if this process of your intervention in the Northern Cape was formal in a sense of correspondences, documentation, and so forth, that is there, or it was communications, one phone call here and there before you entered the space. But also, if you can, for the purpose of this context, indicate whose case was this and why had it become such a big deal?
Yes, there were formal meetings that took place. The reason why there were also formal meetings is because the subjects of the investigation in KZN were also in the Northern Cape. That's why it was easy. It was basically the same case, but in two provinces in terms of the individuals involved. So there were multiple teams meeting, not teams as in like physical meetings that took place to discuss what should be done. I'd gone to Northern Cape earlier before this particular date, and the team that side had come to Pretoria a couple of times, and that also met with the KZN team. So there is a formality to it. The DPP in Limpopo will confirm it because she's since been transferred there from what I understand. What was the other part, Prof?
Just for the sake of this, who was involved in this case? Why would it become such a big deal so that people following this case don't think that a small village, ward councillor was involved, therefore people start fearing everything? Why was it a big deal?
No, I think the difficulty is that one of the individuals being charged was the chairperson of the ANC in the Northern Cape. That was the difficulty, and there had been mobilization to support him as there was. So that was the concern.
Okay. Thank you very much, Advocate Simelane. I'm happy to announce that we have come to the end of this interaction. And thank you very much for making time to interact with us.
Thank you very much. Appreciate
and
it.
making yourself available.
Thank you very much. Thank you.
And have a lovely evening.
Thank you, you too. You too. Thank you.